out the $792 million. You might have heard it called the Ferris fee. And Alec had that fee paid directly to himself. And then we know that he is accused of depositing that money, and Creighton Waters told the jury it wasn't enough for him. He spent that money in 2 months. So where does that leave us? Well, it leaves us back on June 7th. And again, Creighton Waters going through all of this yesterday and saying, oh, we see the judge seated. Okay.
Be seated.
Good morning. First off this morning, we have to deal with the issue involving the removal of a juror. A few days ago, I received a complaint from a member of the public indicating that a juror had engaged in improper conversations with parties not associated with the case. I communicated and provided a copy of the communications to the defense counsel. After court, we then met with the juror on the record, and the juror denied denied discussing the case with anyone not on the jury or with anyone on the jury. She provided information that led us to the court to contact the persons that she was suspected of having conversations with concerning the case. Those individuals were interviewed and provided an affidavit regarding the contact that the juror had with them. We then also brought those two individuals in and had a hearing in chambers on the record in the presence of counsel yesterday. In which both of those individuals waffled on the nature and the extent of the contact. They also provided a recorded interview, or the state provided a recorded interview with the jurors, and I reviewed that interview last night. So the juror has had contact or discussions concerning the case with at least 3 individuals. Though it does not appear that the conversations were that extensive, it did involve the juror offering her opinion regarding evidence received up to that point in the trial that the conversation took place. And in order to preserve the integrity of the process and the interests of both the state and the defense in a fair trial, that juror will be removed and replaced by another juror. I will make a part of the record under seal because of maintaining the confidentiality of the identity of the jurors. I will place under seal the recorded interview, affidavits received, and both discussions with counsel have taken place on the record, and all of that will be made a part of the record. In the case, and we'll bring the juror out to inform her that her services will no longer be needed. We will then replace her with an alternate juror. Any additional comments by the state or the defense? Mr.
Not from the state,
Your Honor, we do not accept from your ruling.
Yes,
I've sat through everything you sat through, and it's muddled but we would defer to your judgment. However, I think it's important for me to note for the record that the interviews of these two people were done by SLED agents, one of whom was named as a witness in this case, and the other who was listed in the notes as being one of the investigating officers. Just to note that, again, SLED has made another bad judgment in this case. I'm not accepting from your ruling.
Yes, sir.
I'm just pointing out that this is just a continuum of a calamity of errors. Thank you.
And the court has not had any discussion with any SLED agents concerning this issue. All the inquiry by the court has been directly with the suspected parties involved and with the juror. And this is a matter that this long trial with the intense publicity is certainly, it would be certainly difficult for any individual to not have some exposure outside of the courtroom to information concerning the case, and to also be tempted to engage in discussions with others. But it is improper, it is contrary to my instructions to the jury daily, multiple times per day, and this juror unfortunately violated that order. So if you will bring out juror number 785. Yes. And sir? He's gone. Let's make sure she brings everything with her. She will, I'm sure. Tony. Good morning. Yes, ma'am, up here. In your normal spot's fine. If you could just remain standing for me. Good morning. You doing okay today? All right. I have, as you know, we've had some discussions with you over the past couple of days concerning indications of conversations with few folks not on the jury concerning the case, and expressing some opinion about the case. I have reviewed everything, including statements given by individuals and recorded interviews, and concluded that despite my order to not discuss the case with anyone, that intentionally or unintentionally you've had some discussions with some folks not on the jury, and which is going to require me to remove you from the jury. You have been by all accounts, great juror, and smiled consistently and have seemingly been attentive to the case and performed well, and I'm sure that with all the time you've invested in it, you probably hate not to continue, or maybe you're ready to go, I don't know. But I certainly want to thank you for your service. I'm not suggesting that you intentionally did anything wrong, but that in order to preserve the integrity of the process and in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs?
Yeah, one of the other jurors brought in eggs for everybody from
Oh,
the farm. So
okay.
eggs in my purse and nut water.
All right, well, you're going to leave the eggs? You want to leave the eggs or take the eggs? You're going to take the eggs. So, Mr. Bailiff, can you retrieve from the jury room her dozen eggs, her purse, and what else? And a bottle of water. If you can get those things from the jury room. As you know, the identity of the jurors are confidential, not known to the public, and the reason you are still where you are is that cameras are not allowed to videotape the jurors, and we have operated by juror numbers throughout the process, and we'll continue to do so, and your identity will be kept confidential as far as the court is concerned. And we trust that in the event you decide you want to speak publicly about this case, that you wait until after the case is over. You're not encouraged at all to do so, but you have a right to speak to anyone you want to, if you decide to do so. No, I have not spoken with her today, but no, this is not related to, I know we also had some conversation was brought up concerning your ex-husband, but that's not a part of this consideration at all. This is totally independent of any other conversation that he might have had concerning you. That's not part of the order of the court. So they're going to get your things, and then once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. Ed, you can go. Thank you. We get a lot of interesting things, but now a dozen eggs. It's certainly pretty interesting. We'll give them, give her a chance to leave or to take her. She's gone? Yes, sir. Okay, very good. Anything else before the jury comes?
Your Honor, we picked an alternate.
Oh, right, absolutely. When they come out, we'll need to select an alternate, and the clerk you have the remaining alternates in a box. Any objection to a blind selection of that alternate out of the box?
Nothing from the defense, Your Honor.
Juror number 254.
Juror number 254 will become part of the panel, of the deliberating panel at this point. 254. Yes, sir. Mr. Griffin.
Your Honor, before the jury comes in, early in my closing argument, we have a blow-up of the photos of Maggie and Paul at the crime scene. I'm going to hold it up so that the jury could see, the audience cannot see, but I'm just notifying Court TV that please don't display this blow-up during the proceedings. Thank you.
Thumbs up, yes.
Oh, sure, I apologize. I haven't.
You may bring the jury. Good morning. Yes, sir. Thank you. And good morning one more time. Day number 28. Welcome back. Juror number 254. You are now part of the first 12 jurors. We have 13. You're part of the first 12 of the panel at this time. And continuing with closing arguments, is the defense's turn. Mr. Griffin.
Thank you, Your Honor. Good morning. Wow. We're at the stage of the case that's called closing arguments. I don't know why they call it argument. I'm not here to have an argument with you in any form or fashion. What I'm here to do today, this morning, is to review the evidence with you that you've heard in the courtroom over the last 6 weeks. And in reviewing this evidence, my goal is to address questions that you may have about what you've heard. And the jury system that we have, frankly, is the greatest criminal justice system in the world, because it's the only system, jury system, that a criminal defendant's fate is put in the hands of his or her peers. In this country, we don't leave the decision of guilt or innocence up to governor, to the attorney general, to the prosecutors, to the presiding judge. You, ladies and gentlemen, make that decision. And as perfect as our jury system is, there's one thing that I wish it provided: an interchange during the course of the trial between us. Y'all sitting there and listening to what we say, and we don't know what questions you have and what you want answered. By the same token, we may have questions of you that we can't ask. Here's my opportunity to try to answer the questions that I think you have. There may be some things that I go over that you've already decided, and I'm wasting your time, and if I do that, I apologize. I truly do. But I don't, this case is so important, I don't want to leave anything out that one of you may have a question about. I think I can probably speak for everybody in this courtroom that there's one thing that we on this side have no question about. It's that y'all have been ideal jurors. We've been here 6 weeks, and each of you have come every day on time, and you've been very attentive, and it has not gone unnoticed, and we do appreciate you for your service. We know what a sacrifice it is, being away from your home, your work, your family, your personal obligations. Maybe some of you miss vacations, but you've been here in a 3-week trial, and here we are at the end of 6 weeks. And I want to thank you personally. I want to thank you on behalf of Mr. Harpootlian, Mr. Barber, Ms. Fox, and especially on behalf of Alec Murdaugh. In his opening statement, Mr. Harpootlian explained to you that the law governing your service requires each of you to engage in an unnatural task. In every criminal case, jurors are required to begin the process by presuming the defendant innocent. In this case, you were required under your solemn oath as we began to presume Alec Murdaugh innocent of these charges. And frankly, as he explained, that's not natural. When you hear on the news that a crime has occurred and an arrest has been made, you feel a little bit relieved. Thank God they caught him. And frankly, I would not be surprised if some amongst you, when you read in the paper that Alec Murdaugh was charged with the murder of wife and son, that you thought, oh good, they got him. But those opinions, and each of you, when you filled out your questionnaire, agreed and affirmed that you would leave those at the door of the courthouse and that you would decide this case solely on the evidence. And that's what the law requires. And when we begin, the law also requires you to presume him innocent of these charges. Now, I've been doing this a long, long time, and up until the advent of instant replay in sports, it's been very difficult to explain just how to do that to jurors, how jurors can do this, apply this presumption of innocence. And if you're not as interested in sports, I apologize for this analogy, but the analogy is the instant replay. Whether you're a Clemson fan or a Georgia fan, that on a Saturday afternoon, there's a play called on the field, and then it's reviewed. And under the rules, the call on the field stands unless there's visual, incontrovertible evidence that the call on the field was wrong. We see that every weekend on sports. Here, the call on the field is that Alec Murdaugh is innocent of these charges. That's what the law requires. And that unless and until the state proves his guilt to each one of you individually, voting individually, proves his guilt beyond a reasonable doubt, then that presumption of innocence stays with him. You're not being tasked here to give your opinion in this trial. You're being tasked to apply the Constitution, the bedrock principles that protect us all from a government. And those bedrock principles are, first, you get tried by the jury of your peers. Second, that the jury of your peers begin with presuming you innocent. And third, that you will remain innocent until the government, if they can, proves to you individually, in your mind, that the person is guilty beyond a reasonable doubt. Now, the judge will give you jury instructions on what that means, beyond a reasonable doubt. But the definition has been defined that reasonable doubt is doubt that would cause a reasonable person to hesitate when making an important decision in their personal affairs, such as to buy a house, get married, any consequential decision. And you will be making, when you get this case, probably later this afternoon, you'll be making one of the most consequential decisions that you will have ever made in your life, I suspect. I don't know all of your backgrounds, but it will be a very consequential decision. And if the proof that the state has put before you causes you to hesitate, when you go to fill out that vote as you're deliberating in your jury room, each of you will have a vote. And you will have the right to vote guilty or not guilty. And each of you will write it down. And if there's any reasonable cause for you to hesitate to write guilty, then the law requires you to write not guilty. This burden of proof that we have, many of you may have had experience with civil cases. And in civil cases, the burden of proof is much lower, and it's called by preponderance of the evidence. And you may have seen lawyers or judges or watched on TV as they give a visual image of Lady Justice, who's blind and who's blindfolded, so she does not bias for one side or the other, and there's scales on Lady Justice. And those scales are the scales of justice. And in a civil case, if one party proves their case by a preponderance of the evidence, meaning ever so slightly tilt those scales in their favor, then they're entitled to the verdict. there's another heightened level of burden of proof in a civil case called by clear and convincing evidence. And the law requires things like to prove fraud or some intentional acts. You have to prove by clear and convincing evidence. And that's an intermediate level of proof. And so it's not just tilt the scales ever so slightly in the favor of the party that prevails, but you have to get sort of 3/4 of the way there. But now proof beyond a reasonable doubt is the highest standard of proof the law recognizes. And it is, you have to tilt the scales all the way to one side in order for the state to meet their burden. Now, a little bit about the verdict. You will have an option of guilty or not guilty. My friend Dick Harpootlian over here he travels a lot. He's been to a lot of countries, and he frequently, he recently returned from Scotland, where he attended a jury trial in Scotland. And he tells me it's much like this, except the lawyers wear a wig, and I might benefit from something like that. But in Scotland, it runs about the same until it gets time to the verdict in the criminal case. And the jury in Scotland, where we derive our laws from, and they are given 3 options. One option is guilty. Second option is not guilty. And the third option is not proven. Not proven. Now here in America, we have combined the verdict of innocent and not proven into one of not guilty. And so when you go to render your verdict, if it's a verdict of not guilty, it's either you concluded that the defendant is innocent of the charges, or that the government has not met their burden of proof, their heavy burden of proof beyond a reasonable doubt. Now, and one of the reasons that defendants are presumed innocent and the government has such a high burden is because in criminal cases, the defendant really doesn't have the ability, doesn't have the resources, doesn't have the lawful authority to execute search warrants, subpoena documents, to prove his or her innocence. And so a defendant cannot secure a crime scene, cannot lift a crime scene for fingerprints, shoe-wear impressions, cannot secure telephones and get electronic data in the course of an investigation. So the defendant is limited on what they can do. In this case, on June 7th, 2021, Alec Murdaugh called 911, and Officer Deputy Green, and then followed by other deputies, rolled up on the scene. And he is standing on his property. His wife and son lie dead in a pool of blood each. He's within yards of him, and he had just put a shotgun down. He had just put a shotgun down. And what would that look like? 90 out of 100 cases when an officer rolls up, it would look like the person who had the shotgun and 2 dead bodies may have done it, probably have done it. Certainly is someone who should be strongly considered. And all the officers in this case told you that. Deputy Rutland said, yeah, Alec Murdaugh was a suspect, but there are a lot of suspects out there. Everybody was a suspect. Fair enough. Agent Owen says, well, you know, we have a circle, investigative circle, and it starts with immediate family members, particularly if they found the deceased, the victims. So he's in the circle by virtue of calling 911, and that's fair enough. But what doesn't strike us as fair is that the next morning, on June the 8th, after the gruesome murders of Maggie and Paul, this is what is issued, a joint press release, Colleton County and SLED, that says At this time, there's no danger to the public. At this time, there's no danger to the public. You have 2 people who have been executed within, y'all are out there, I don't know, is it 100 yards, 200 yards from Moselle Road? They've been slaughtered. And at this time, there's no danger to the public? Does that tell you that on June 8th, law enforcement had decided it had to be Alec Murdaugh? It's a fair question for you to ask yourselves. It's a question that's not been fairly answered in this trial. What we know from June 7th to June 8th, Alec is a suspect and he's in the circle. And from that day forward, he is at the mercy. He is at the mercy of the ability of SLED to exclude him from that circle. They have the ability to do the forensic work, they have the ability to interview witnesses, and they have the ability to gather electronic data. And we believe that we've shown conclusively that SLED failed miserably in investigating this case. And had they done a competent job, that Alec would have been excluded from that circle a year ago, 2 years ago, but he would have been excluded. What did you hear from the witness stand? You heard from Chief Barry McCroy. I didn't know Chief McCroy until I got involved in this case, but his reputation is outstanding, and he's a consummate professional. And he explained that when he got there, he was concerned that cars would be pulling up and there were some tire tracks that were not being protected, and that they could have evidentiary value. And then you heard from Mark Ball, who had a conversation with Sheriff Hill, who's another fine public servant here. And he also agreed, we've got to stop cars from coming in here to preserve these tire impressions. And it was not done. It was not done. Captain Chapman from the Colleton County Sheriff's Office, he testified about seeing other sets of tire tracks. As you came in off Moselle Road, you probably saw where Deputy Green's vehicle had stopped right at the kennels, but then on the other side, where you saw that Alec was parked and pacing on some of these videos, that's where Captain Chapman had talked about seeing tire tracks, and he tried to track them. SLED was coming on, and then it was like a trail to nowhere. It was a trail to nowhere. Deputy Rutland talked about seeing hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands from that moment forward. Was it tested? Was it sent off for analysis? There was no evidence of what, if anything, happened to the hair in Maggie's hands. Was it as a result of a struggle with her assailant? Was it her own hair? I mean, we don't know the answer to that. We know they failed to take fingerprints from the feed room, and they should have. They failed to properly take footwear impressions from the feed room, or at the apron right outside the feed room. And I think that's I don't think that's uncontradicted. The Agent Worley, who doing the best she can, did not go there to document footwear impressions. Did not do that. You heard from our expert, Mr. Zerchi, what is required, and I believe Dr. Kinsey also agreed it was not done. I know Mr. Palmbach did. And both, now I'll get to the shot angles in a little bit, but both Dr. Kinsey and Mr. Palmbach have the murderer for Paul standing on the concrete, standing on the concrete. Whether 1 foot's in, 1 foot's out, both feet are in, but there should have been footwear impressions. But we'll never know because it was not preserved. It was not taken. The thing that has baffled us, has completely baffled us, is why did they never take DNA samples off of Maggie's clothes, her dress? Why did they never take DNA samples off Paul's clothes? They never did. They never did. And we asked their investigators, why didn't you? Well, that's somebody else's job. That's somebody else's job. It was never done. But you know whose clothing they took DNA off of extensively? Alec. And you heard Agent Zapata talk about all the different grids on her shirt where DNA was samples were taken. Was Alec assaulted on June the 7th? No, he wasn't assaulted. Was Alec wrestling with the assailant on June the 7th? There's no evidence of that. So why are they taking DNA evidence off Alec's clothing in June of 2021? And there's only one reason. And it goes back to this right here. There was only one reason. Only one reason. Is that they had decided that unless we find somebody else, it's going to be Alec. Unless we find somebody else, it's going to be Alec. And I'll get into more detail about Maggie's phone. And Maggie's phone was not secured properly. Maggie's phone was, well, let me just go right into it. Maggie's phone was found on the side of the road in the morning or early afternoon on June the 8th. Whoever killed her threw that phone on the side of the road, without a doubt. Without a doubt. Alec, from the get-go, has said, you get Maggie's phone, you get my phone, or you get my OnStar data, and you will not see my car traveling down the road with Maggie's phone, because it did not happen. It could not happen. Detective Owen, have you gotten it yet? No, we've not. We sent the black box from on the Chevy to the FBI. It was a new model. Turns out the data's encrypted, and so we haven't got it yet. Well, what about General Motors? I mean, I'll do what I have to do, whatever I can do. And so, well, you know, we're looking into it. We're looking into it. Well, what we learned during this trial is, sure, SLED sent a subpoena via a fax machine to somebody in Detroit, I believe, and whoever got it in Detroit, whether there was a number off, I have no idea what the reason was, but we do know the initial response was, we don't have anything. We don't have any OnStar data that you're looking for. There's no indication that SLED followed up with a phone call. There's no indication SLED followed up with a letter. There's no indication SLED did anything other than put it in a file. Put the response in a file. And that was it. That was it, ladies and gentlemen, until somebody watching this trial somewhere contacted somebody at General Motors and said, why don't you guys cooperate with the FBI and SLED on this investigation? And they're like, what are you talking about? So Friday, you know, sometime in the last 6 weeks, lo and behold, here comes all the OnStar data that you got to see. And that would be great. That would be great. But for the fact that when they seized Maggie's phone, it had, they put it in airplane mode. They knew how to put it in airplane mode. Excuse me, I'm losing my voice. Let me get water. I apologize. Oh, there's pollen. Something else. The they put it in airplane mode, but what you'll see, I got a photograph, is the location services were still on, meaning still pinging off GPS satellites. And the phones don't hold that much memory. They hold a lot of data, as we have learned, but they don't hold that much memory. And it writes over itself. And for GPS location services, the ping points that we see from Paul's phone on all that data, that would have been on Maggie's phone for the 7th. But for the fact that it wasn't extracted until sometime in like June 16th. I think that's the date, but if I'm wrong, I apologize, but it's around the middle of June. And that ping information that we see on Paul's phone, for Maggie's phone, it goes back to like June the 9th. Well, a lot of good that does. A lot of good that does. We don't have it. We would have had it had they extracted it earlier. Now, Agent Dove says we didn't have an upgraded software that would read it. It took us a while to get it. I don't know why it took them a while to get it. There's really no explanation about that. But you heard about Faraday bags. Put it in a Faraday bag. So it's not pinging against satellites, not overriding. They didn't do that. And it's lost. Had they done it, I hope we wouldn't be here. I hope, because I know it would say, because we have enough evidence in the record, and we have to go around our elbow to get to our thumb to get there, but there is sufficient evidence in the record that shows Alec Murdaugh was not driving down the road, Moselle Road, with Maggie's phone in the car and tossed it at whatever time. When he went by at 9:08. I don't know what time they think it's tossed, but that would have gotten him out of the circle. I would hope, but probably not, because they've been so focused on him. Now, as I mentioned, Alec asked multiple times. I think the testimony was 5 times. Agent Owen, you know, if you get this data, it will show I wasn't there. And you know, we didn't learn why they didn't get it off Alec's phone until very recently, because you'll remember on June 10th, he gave SLED his phone. Yeah, you can copy it. Please copy it, because it'll show that I wasn't driving. Now, my phone was not with Maggie's phone at any point in time going down the road, I did what I said I did. Well, they did extract it, but what we've learned, the extraction was a superficial extraction. Not because Alec requested it, that's just what they did. Said a logical surface extraction. So they didn't go in and pull out any GPS pinging data like you see on Paul's phone. They didn't get it off Alec's. Now, if Alec had not made those requests to Owen, and they are disputing that, there's one thing you can be 100% sure of, is they would have called Detective Owen up here on the witness stand during their rebuttal case to say, no, he lied. He didn't ask that of me. I mean, they got Sheriff Smalls in here to say, I didn't give him permission to put a blue light in his car. They came and challenged whether he had authority from the sheriff or maybe a deputy sheriff to put a blue light in his car. But they didn't contradict anything you said about, I've been asking for this data that would get me out of the circle. And now we know why it took so long to get the stuff from his car. It's because it's because the FBI wouldn't go to General Motors on this event data. The FBI was up there and they bought a Suburban, they're riding it around, and they're reverse engineering all these systems to try to come up reports. And then they come in here and tell you, well, it's not complete, some is inaccurate, but this is what we got. And during the middle of all that, that's when, lo and behold, we get on start. Thankfully, we did. But So then we roll into Labor Day weekend of 2021, where Alex, long-time drug problem, his financial issues, misconduct were exposed. And that made him an easy target for SLED. And I hate to say this, but the evidence is crystal clear. From that moment, they started fabricating evidence against Alec. And Mr. Griffin, that's an awful charge. Don't all lawyers accuse law enforcement of fabricating evidence? And I can tell you, this guy right here was a federal prosecutor, was a state prosecutor, and some of my best friends are in law enforcement. And I don't make that claim lightly. Here, what you have heard is they came up with a report that says Alec's t-shirt had high velocity blood spatter on it. High velocity blood spatter. What's that? That means you're within feet of a shooting, and they didn't just say any shooting. It said in their report, it says as a result of Paul's murder. High velocity blood spatter on a shirt as a result of Paul's murder. That was number one. Well, let's stick with number one. Why do I say that it's fabricated? Well, you heard Agent Zapata said we did hemotrace confirmatory blood tests on that shirt. That means there was two types of tests. There's a presumptive test, which is what they use a product called LCV that makes it turn purple where it might be blood. But it turns purple on other agents as well, including bleach, you heard. And you also heard that the shirt came out of the bag wet and it smelled like detergent. Anyway, they spray it, it turns purple in places. So they think, well, that must be blood. Next thing they do at the SLED lab is they do a confirmatory test to see if it's blood. 0 for 74, not blood, not blood. That didn't stop SLED from going out and pursuing with vengeance this report. They didn't give the no blood test result to the guy in Oklahoma, and when it surfaced, they had a problem on their hands, and they were pushing it up until this trial. And you heard the testimony from the stand that they went from Mr. Bloody Shirt leading up to this trial to Mr. Clean during this trial. And they ask him, and they raise issues during the trial with Blanca, where were his clothes? No one's asking about the man's clothes that he had on the Snapchat video back in, at 7 o'clock with his son until November or so, I think is what she said. I mean, the issue of changing clothes, it was late to the dance because when they went to, as you heard, when they went to the Collin County Grand Jury to get an indictment that you're going to be deliberating on, they told that grand jury they had an expert report that says high velocity blood spatter. And I asked Agent Owen, I said, when you went to the grand jury and when your guy gave you the report, how'd you not know, you chief investigator, how'd you not know that there's this hemotrace test that says it's no blood? Well, I didn't get the email. I say it in somewhat jest, but could the dog eat his email? I mean, how's the lead investigator in the case not get the lab report that says there's no blood on the shirt? Now, ultimately it was produced to us, and we were raising Cain about it and saying, how can you say this on one hand and that on the other hand? And here we are with a Mr. Clean theory that he washed off after brutally murdering Maggie and Paul. He takes a hose and washes himself off and gets in a golf cart, butt naked, I guess, and drives to the house. So that's the blood spatter fabrication. The other is this blue raincoat with GSR, and do you remember that testimony? Shelley Smith, who worked for Ms. Libby and Mr. Randolph, had told SLED after September, after Alex's problems had been exposed, after she had a conversation with a Allendale police officer following an accident investigation in which she was in an accident, that on the morning, she said in here, as she told you, on Wednesday after Mr. Randolph's funeral, and that turns out to be, I think, June 16th, that Alex shows up at the house at Alameda at like 6:30 in the morning, knocking, trying to get in, and he has a blue tarp. And in this blue tarp, she lets him in. He goes upstairs with this blue tarp. He comes back downstairs. He lays this blue tarp out on Ms. Libby's retirement rocking chair in the living room, and then he leaves. And then she leaves to go to her day job, and when she left, the blue tarp was laying out on Ms. Libby's rocking chair. That was her testimony. And so SLED gets that, gets a search warrant, goes to Alameda, and they seize a blue rain jacket. They seize a blue rain jacket. And when they do, they take that blue rain jacket and they show it to just about every family member. Let me get it right quick. So they can think of, and it's defendant's 87, Doug, if you can pull it up. But they show this blue rain jacket to as many family members as they can get in contact with, and the rain jacket is, and no one recognizes it. No one sees it. No one said Alex ever worn it. No one said Paul's ever worn it. No one said Buster's ever worn it. No one said Maggie's ever worn it. Have not seen this blue rain jacket. Has not seen this blue rain jacket. One more thing about this blue rain jacket. When they did the search at Alameda, John Marvin was there. And John Marvin asked him, did you find anything? And they said, well, we found a blue rain jacket back on the property. And he said, well, my dad drives a buggy around, and maybe it fell off the back of his buggy. Clearly, John Marvin was understanding that it was back on the property, and then they asked him to come look at the blue rain jacket, and he was told it was found in the closet. And he said, that didn't sound right, and they never clarified it. Now here's a picture. I'm not even going to put it up, but 411 is a picture of this closet, and you can see the blue rain jacket that's just sort of folded up and stuffed down here at the bottom right. That's the blue rain jacket. And apparently right before this trial, they showed Shelley Smith this picture and says, does that look like the blue tarp you saw? She goes, well, yeah, sure, it looks like it. They never showed her this. And she said, this is page 87, it's on the screen. She'd never seen this. But they did GSR testing on this, and it says, whew, it's hot. A lot of GSR on that. Manufactured evidence, ladies and gentlemen. And then there's this issue of misrepresenting what are the type ammunition found in the shotguns at the residence at Moselle. Paul was murdered with first shot was a buckshot. Went through his chest. He was turned this way, went in here, and then out under his arm, and that was buckshot. The second shot was into the head, either depending on what expert and what pathologist, it's either this way or this way, but into the head. And that was still a duck shot. I learned that you can't shoot ducks with anything but steel pellets because they don't want lead in the water. So you got to have steel pellets. And then Agent Owen testified, admitted begrudgingly that he had testified to the grand jury that there were 4 weapons found up on the property in the gun room, 12 gauges that were loaded, or I'm not saying 12 gauges, I'm sorry, 4 shotguns that were loaded with buckshot and birdshot. There's 4 other ones. So that matches. Well, guess what? Totally not true. That was totally not true. And he admitted on the stand it was not true. He admitted telling Alec during the interview, and he said, well, I can do trickery. And we're going to see that shortly. But and then I said, are you trying to trick the grand jury? No, I didn't say that. Well, we walked through it, and he did say it. And he didn't remember it, and you'll remember the testimony. And I said, well, people make mistakes, don't you? Yeah, that was a mistake. And it's okay to make mistakes, right? Yeah. And you can make mistakes about time. Well, that's the most common thing people make mistakes about. It's not all right for Alec Murdaugh, who's in the center of the circle, who's not all right for him to make mistakes about time. It is not all right, according to the same investigator who says it's okay, happens all the time. But here we go, and then Eureka. They finally get into Paul's phone in April of 2022, and they see Alec. Well, they don't see Alec. They see Cash the dog, and they see Paul's feet walking around, and they hear voices in the background. One of them sounds like Alec. And off they go. They go off and get an indictment from the Cullinan County Grand Jury, relying upon high-velocity blood spatter, relying upon 4 guns having the same load, and relying upon a rain jacket that's got GSR on it, and Alex lying about being down at the kennels. Now we know, after we've been here 6 weeks, of those 4 things,
Bixby voice privacy contacts have been updated. To continue, review the updated items on your screen.
I'm so sorry. No, that was turned on. I will turn it on. What we know is 3 out of those 4 things that was presented to the Cullinan County Grand Jury that you're going to be deliberating on for the indictments that return aren't true. No blood spatter, no GSR rain jacket that's ever been connected to Alex whatsoever, and there's no loaded gun. So we're left with the lie. We are left with the lie. Now, Alex lied about being down at the kennels in Almeda. And why did he lie? And that is certainly a fair question. And that's, and frankly, I probably wouldn't be sitting over there right now. He had not lied. But he did lie. And he told you he lied. And he told you why he lied. He said he lied because, I'll tell you, he lied because that's what addicts do. Addicts lie. He lied because he had a closet full of skeletons, that he didn't want any more scrutiny on him, which is the most ironic thing in the world because depending on which day of the week, their theory is that he slaughtered his wife and son to distract from a impending financial investigation. But he puts himself in the middle of a murder investigation, and he puts himself in the spotlight of a media firestorm. That's their motive evidence, and we'll get to that. But he lied. He lied because of his drug paranoia kicked in, and he was clearly in the throes of addiction. He lied for all those reasons. But what he didn't lie for is because he was covering up the fact that he killed Maggie and Paul. That is not the reason he did it. Doug, will you play the dog kennel video, please? I'm going to play the dog kennel video. So just please listen to the voice.
Get back. Quick, Cash. Quick. Cash. Hey, he got burgers now. Hey, Mama. It's a guinea. This is a chicken. Come here, Cash. Cash. Quick.
4 minutes later, the state would have you to believe that Alec Murdaugh up and blew his son's brains out of his head and murders his wife after having that conversation about Bubba having a chicken or a guinea. 4 minutes later, their case wants you to believe that this is a family down at the dog kennels doing what families do. They're checking on a dog, tail, Bubba's out running around, and they're saying, Bubba, got a chicken. Now, why would Alec not want law enforcement to hear that? I mean, there's nothing on that tape. There's nothing on that tape that indicates there's any strife, any conflict, any anger, any planning, anybody being afraid, anybody running, anybody scurrying. Nothing. It's Maggie, Paul, and Alec down at the kennel. That's it. And their timeline is based on the fact that this automated thing kind of messed me up, but the point I was going to open this up and say, under their theory, if your phone's not moving for some period of time, you're dead right then. You could be run over in the traffic 2 hours later, but if you're not answering a text 2 minutes after you receive it, you're dead at that point. And that's their case. That is their case on time of death. Is phone stop moving, you're dead. You've heard testimony from a lot of witnesses. I would say practically every witness who took the stand, who actually knew Alec and Maggie and Paul and Buster, testified under oath how much Alec adored Maggie, she was his all. Some people describe Paul as Alec's best friend. His relationship with him was awesome. And that was unanimous. Unanimous. I want to just play briefly a clip from Blanca testimony about Alec's relationship with Maggie.
You've also, I think in multiple interviews with Sweat and other folks, described, I think the words were, Maggie.
Please continue, Doug.
All. Isn't that what you told Slade?
Yes, sir.
What does that mean, Maggie was his all?
he adored her. He loved her. He adored her.
Worshipped her. I mean, just treated her as somebody he adored, correct?
Exactly, yes, sir.
Now, this was her testimony from the witness stand. And then, in every trial, there's you hope you find, some very authentic witness, part of the fabric of America that comes in this courtroom. And we had it in this case, and it's Dale Davis. And I want you to remember what Dale testified about Alex's relationship with his family. Will you play Dale Davis's?
Me? When you use the phrase lovey-dovey about Alec and Maggie, what does that mean?
It means they loved each other.
What, in your presence, you described them as being lovey-dovey, didn't you?
Yes.
And tell the jury what you meant by that.
Oh, every time I always see them, I've never seen that man even raise his voice at his wife or kids. Or his wife. I've never seen him even, none of them argue. But he always, anything she wanted or the boys wanted, he would try to get it.
And what was your observation about his relationship with Paul?
They like to hunt and fish together. I mean, they drink beer together.
Okay.
That was Dale Davis. Which brings us to the question, why? Why would Alec Murdaugh on June 7th execute his son Paul and his wife Maggie, who he adored and loved? Why? The state's theory is that that it was a storm a-coming, clouds are arising, and that his financial house of cards is about to collapse, and he's about to be exposed. And because of that, he does what every rational person would do: go kill your wife and son. That is their theory of motive. That is their theory of motive. And it worked too, by the way, because he killed his wife and son. Guess what? Jeannie Seconder quit asking questions for a few weeks. Oh, in the boating case, that won't be worth anything now that his wife and son's been murdered, because he's sympathetic. Have you heard such? One thing Mr. Waters and I agree on is the best thing about jurors is you bring your common sense in here, and you use your common sense. And that's what it's all about. That's what your collective wisdom. And just collectively think, individually think, what kind of sense does that make? Alex, his financial house is a wreck. He's stealing money from clients. He's got to produce a financial statement, maybe, in a hearing coming up. And his dad goes back in the hospital that day. His dad goes back in the hospital that day, and he ultimately dies a few days later. Okay, so I get a call. Jeannie comes in. My dad's going to the hospital. Paul's coming home. That'd be a good time to kill Paul, wouldn't it? That is their theory of the case. And if you don't accept that beyond a reasonable doubt, ladies and gentlemen, I submit the verdict has to be not guilty. Because there's no reason for him to do it. No reason whatsoever. Now, you've heard a lot of testimony about these financial crimes, misdeeds, and he told you he did it. He told you he did it to support a very expensive drug habit, and none of that's an excuse, but he is an addict, and addiction is real, and addicts lie, addicts cheat, addicts steal to keep getting their drug. The evidence was permitted in this case for you to hear solely to consider, did he murder his wife and son because he had this storm a-coming, that he was going to be exposed. Is that why he murdered? That's what they say. That's why he murdered, and that's why you're allowed to consider it. Now, Judge Newman in his jury instructions will tell you that's all you can consider it for. You can't consider it by saying, man, I never knew he could do that. So if he could do that, he must be able to do the most heinous crimes in the world. Kill his wife and son, execute him style. I mean, that's a no-no use of that evidence. The only permissible use of the evidence is that sufficient provocation, motive for him to kill his wife and son? Was it sufficient motive, not provocation? And the evidence in the case is that there was no impending financial doom on June 7th. June 7th was a day which frankly was no different than any other day in the frenetic lifestyle of Alec Murdaugh. He had so many balls in the air, and he even, I forgot his paralegal's name, and I apologize to her, I think Christy. She said he would come in like a Tasmanian devil. I mean, he was frenetic. And they were on to this $792,000 fee in the Ferris case, and they were asking questions at Chris Wilson's office. But the reason they weren't concerned that he was stealing money. They were concerned that he was sheltering money, trying to hide it from being disclosed in the voting litigation, in which he was a defendant. And they didn't want any part of that. And that situation with the with the Ferris fee, as Ms. Seckinger, Jeannie Seckinger said, that was a one-off. That was completely on its own, different type conduct than all the other stuff that you heard about. That was a one-off. And what happened on June 7th? She says, I'm in his office, and he gets a phone call that his dad's put back in the hospital. And she thinks that he told her it was terminal. He may have, I don't know, but his dad is put back in the hospital. He wasn't terminal that day, but the next day he got the terminal diagnosis. In any event, she takes off her CFO hat and puts on her mama bear hat and hugs him and a friend hat. And their theory is he slaughters Maggie and Paul to buy time from her investigation. That is it. That is their theory. That is their theory. And it's totally fabricated. They've got no evidence of that. There's no evidence that Maggie was on to his financial misdeeds. There's no evidence that she was about to blow the whistle on him. There's no evidence that that he had a $20 million life insurance policy on her, and that if he murdered her, that he could get out of financial bind. None of that. None of that. And I asked Ms. Seckinger, how long of a delay did that buy Alec? Well, month maybe? A month? A month? That's their theory. That's what their case is built upon. And then this motions hearing is, there's a motions hearing scheduled for Thursday. It had previously been scheduled 2 other times. And it was continued at the last minute on the other occasions because 2 of the lawyers had cancer and were receiving treatments. But it wasn't sure it was going to be continued previously. Did he go murder anybody, to get out from under those prior hearings? No. This had nothing to do with it. And, so they brought the plaintiff's lawyer in. He's an excellent lawyer, and he's, like any plaintiff's lawyer. I'm going to clean his clock. I'm going to take everything he's got. That's what they all say. So then we had to bring the defense lawyer in to say that was a negligent parenting case, and it wasn't worth the paper it was written on. I mean, folks, that's what we are in a murder case, and that's what we're having to deal with because that is their theory of motive. But even if the financial day of reckoning was impending, if it was right there, Alec would not have killed the people he loved the most in the world. There's no evidence that he would do that. We do have evidence of what he would do and did do. And if you'll pull up Defense Exhibit 125, which is in evidence. On September 2nd, 3rd, 4th, I forget the date. This is the Labor Day weekend. He gets his drug dealer, Curtis Eddie Smith, to shoot him in the head because he couldn't go on, because it was all going to come crashing down, and he had a big life insurance policy. So when Alex is at financial collapse, he doesn't go kill somebody else. He tries to end it himself. This is a natural response. You don't want anybody to do it. But this, people kill themselves from being exposed. Don't kill their wife they adore, son, the apple of his eye, as some people have said. That's not. That is, I don't have the adjective for that. That is so outlandish. I don't have a word for it. Totally illogical, irrational, and insane. Those are the words I wrote down. For someone to kill their loved ones when their criminal conduct is being exposed. So, you can take that down. Yeah, thank you, Doug. Yesterday we heard a lot from Mr. Waters. And I've been in Mr. Waters' position. As I explained, I was a federal prosecutor for a number of years. I've been a state prosecutor, part-time mostly. And I've done his job. It's a very rewarding job. And I hold him and I hold his office in very high esteem. But there are just sometimes folks just get caught up in a case, they get a desire to win, they get so intoxicated by the attention that's brought on by the case that they start sort of a win at all cost approach. And I'm going to go through some things that Mr. Waters stated to you that just aren't facts and aren't supported by the facts and the evidence that you heard. And before I do that, I want to give you a cautionary statement. We lawyers aren't witnesses. I didn't take an oath to stand up here and talk to you. I have ethical obligations about what I can say and limitations under the rules, but I'm not a witness. I'm here to talk to you about the evidence. And the same applies to Mr. Waters. You decide what the evidence is. You decide. And
further, we're going to take a short break for about 10 minutes. Please do not discuss the case.
factors that the prosecution has brought up are simply not indicative that Murdaugh actually committed the murders themselves, or himself. So basically they've walked through the kennels and Murdaugh being down there with his wife and his son. Now, Murdaugh had previously lied to investigators saying he wasn't there at the kennels, but then a video at 8:44 p.m. showed that he actually was there. And so Griffin has really broken that down and talked to the jury in a way that is very conversational. He said, you know, does that make sense? This video at the dog kennels shows Murdaugh, his wife, and his son talking about a chicken that was in their dog's mouth. They were kind of, you know, laughing about it, joking about it. So is that a conversation that they would not want investigators to know? And Griffin's saying, no, that doesn't make sense. He's saying it was a family doing what they do, you know, just laughing, being down by the dog kennels. So why, in that instance, would Murdaugh have then turned around and, according to the state's theory, about 4 minutes later, gunned down Maggie and Paul? So, you know, the defense has definitely started to poke holes in that. You mentioned talking about the investigations. Griffin even said, you know, if this investigation had been done properly, then I wouldn't be sitting over there at the defense table representing my client. Now, Andrea has been in the courtroom today, and she's bustling down here. She's been checking out the jury and getting to see their reactions. So she's getting all set up down here with me, but certainly a lot of holes that have been poked in the theory so far. Jim Griffin, obviously, we knew today that he was going to be speaking, and he didn't come out with the passion that I expected him to right away. He was a little more subdued. It could be a slow boil, you know, where he wants to start off calm and then move up to being a little bit more passionate. But his argument, and he went through the days, are that it's absurd to think that a loving father could kill his son and his wife. And that is what he was trying to present to the jury today. And he started by saying, well, another point he made was discrediting SLED. And that has been a big theme of the defense from the very beginning, is discrediting SLED. He said that they didn't rope off the tire tracks like they should have. They didn't rope off the bloody footprints like they should have, and he went into that. He went into the fact that, and we knew this was going to come back, the high velocity blood spatter. He went on to say that, you know, SLED, when they presented to the grand jury, said that there was in fact high velocity blood spatter on Alec's t-shirt the night of the murders, and it turns out there was not. After it was tested by Ms. Zapata, they found out that it was not. But there was trace, obviously, amounts on the steering wheel that he said from touching the bodies of the, but I don't know, it was interesting to me that basically so far he has said SLED made mistakes. Oh, and by the way, if you didn't catch this, he came out and said SLED planted evidence. He said on June 8th, and he put up a big poster board in front of the jury with that press release now that has become so famous, and he said SLED fabricated evidence against Alec because they already had decided by June 8th that it was him. Do you think that was effective? I do. I think it was effective. I think the way he was talking about it was, you know, breaking down the different instances where SLED has maybe not followed what he thinks is the proper method of, you know, investigating this. And I was mentioning earlier that, you know, he looked at the jury and he said, if SLED had gone about this in the right way, I might not be over there at the defense table representing my client. I mean, he's really pushing it that, you know, that the investigation just wasn't handled properly, and that's why they came in with this idea that Murdaugh was a suspect as soon as deputies rolled up to the scene, is what Griffin said. Something he went back and did. Now, we know this. A lot of the witnesses that were brought in by the defense, Mark Ball sticks out in my mind, even though that they were defense witnesses, ended up being powerful for the prosecution as well, talking about Alec's lies, talking about the way that he said again and again that he went down to the dog kennels. Mark Ball also said Alec changed his story many times about whether or not he checked Paul first or he checked Maggie first. But they brought up two videos that he actually played. He paused speaking for a moment, and he played the video of the housekeeper, Blanca. He played the part where she said that Maggie was his all, and then they brought out the video again of Dale Davis, and he is that neighbor that we heard on the witness stand talk about taking care of the dog kennels. He was there the day of the murders. He was there on June 7th on the day of the murders, even though he did testify that the puddles of water were not the average puddles of water that he expected to see. But they put his video up for the jury again and letting him say that Alec was a very loving man, that he had never heard him raise his voice to his family. And he also spoke a little bit about Paul's relationship with Alec, saying that Alec and Paul love to hunt together, fish together, and even drink beers together. And that got a little laugh again in the courtroom of having that memory. But he is coming from this place. He said there was no reason for him to do it. He was, just like you said, they played the video again from the kennel. They played the kennel video and said he was a loving dad. And how did they go from having this conversation about was it a guinea or was it a chicken? He said the prosecution will have you believe that under their theory, if a phone stops moving and you stop answering your phone, you're dead. I'm unsure, Sam, and I'd love to hear what you think. To me, that wasn't a powerful argument, because we were able to see the interactions on their phone that Maggie and Paul had. They were checking constantly. I mean, we all do.
Yeah.
Right? So he said it's the defense's theory that if your phone stops moving and you stop checking it, you're dead. Well, wouldn't that be the case? I mean, with many of us, you know. So I'm unsure that hit home. What do you think?
Yeah, I certainly think that, the state has walked through the timeline of data collected from Maggie and Paul's phone. Paul especially, multiple times. Different witnesses even have testified that Paul was constantly on his phone, constantly checking it. We know based on the evidence that he was checking his phone. He was going back and forth. He was Snapchatting. He was texting with different people. And then Maggie, her phone was locked for a little bit, but she also was constantly on that phone. So I agree with you. I'm not so sure about, what really that does.
Right, yeah. He said, and just to reiterate this again, he said, well, the prosecution wants you to believe that under their theory, if you stop moving, if you stop checking your phone, you're dead. But the incredible thing is, we know, and if I could look back in my notes, but I believe it's 9:48 is when Paul's phone locked. 8:48 is when Paul's phone locked forever. 8:49 is when Maggie's phone locked forever and was never checked again after reading that last text message that was a family update about Alec Murdaugh's father and what physical condition he was in. So maybe if one of them, Sam, stopped looking at their phone and the other person still had a lot of activity, it would be easier to believe that wasn't the murder time. So he went on to say 4 minutes. He said that the prosecution will have you believe that we see this video at 8:44, the Snapchat video where the family's talking about the guinea, the chicken, and 4 minutes later, this dad decided to kill his wife and his son. Again, the problem I have with that is, well, what is normal behavior? Where is the testimony about normal behavior before a man goes to kill his wife and son? Is there such thing as normal behavior before you commit a heinous crime? I don't know, and I don't know that we have a frame of reference to compare that to.
Yeah, absolutely. I think that's a really good point, is, we don't know what that would look like. This is an interesting circumstance, and we don't have something to really base it off. One thing that Jim Griffin has done a lot today is walk through the evidence that was presented. And again, we talked about earlier how he was mentioning, the SLED investigators and how that evidence was not collected in the right way. And so as far as testimony about, what would a father look like before he kills his wife and son, we don't have that.
We don't know.
But we do have the evidence presented. And so let's take a listen to what Jim Griffin said is the problem with the evidence and the way it was collected today.
We know they failed to take fingerprints from the feed room, and they should have. They failed to properly take footwear impressions from the feed room or at the apron right outside the feed room. And I think that's I don't think that's uncontradicted.
Yeah, so you heard Jim Griffin there talking about the footprints that were collected. Now he's gone through and he's talked about how SLED agents or deputies showed up to the scene, right? They see Maggie and they see Paul after Alec Murdaugh made that 911 call. And now Murdaugh has testified, and he told 911 operators on the phone that as soon as he saw Maggie and Paul's bodies, he ran up to the house and he got a gun, implying that, it was for protection after he found them dead. And so Jim Griffin actually turned to the jurors and he put them in the shoes of the responding deputies. So he said, imagine this. Deputies come up to the scene, they see Maggie, they see Paul, they're dead, and they see Alec Murdaugh. And now Alec Murdaugh has a gun in his hand, he's putting it down. But now what would those deputies think? And so by posing that question to the jurors, Jim Griffin was saying that investigators automatically thought that Alec Murdaugh was responsible for the murders. They automatically showed up to the scene. They had that idea in their mind. And that tainted the evidence that they collected because they weren't, looking because they had this idea of the suspect.
And let's talk a little bit more about that and about what they did and didn't collect at the scene. That was another point that defense attorney Jim Griffin was making, saying that DNA, and this might not be something that was focused on during the trial, but he said DNA from the clothing of Maggie or Paul was never collected. It wasn't collected on the night of the murders. It wasn't collected after that. But they did, in fact, collect DNA from Alec Murdaugh. So he was trying to make the point that already, even on the night of the murders, even going as far back as June 7th, that SLED and Colleton County sheriffs and everybody was involved had already had their mind made up of who was guilty. So he tried to, again, like Sam said, poke holes, saying, if they would have tested DNA on Maggie and Paul's clothing, would they have found something? Would they have found a DNA match that could have led them to the murderer? There was something else, and I don't remember this being brought up in trial. Sam, you will have to tell me. Yeah. I never remember hearing from anybody that there was hair found in Maggie's hand, but the hair was never tested. Let's listen to this, and then we'll talk about it.
Deputy Rutland talked about seeing hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands from that moment forward. Was it tested? Was it sent off for analysis? There was no evidence of what, if anything, happened to the hair in Maggie's hands. Was it as a result of a struggle with her assailant? Was it
You may bring them in. All right, thank you. You may continue.
Thank you, Your Honor. Yesterday in Mr. Waters' closing argument, he said that the evidence established that Paul and Maggie were murdered with family guns. I mean, that perhaps is his view of the evidence, but that's not a fact. In fact, the state's ballistic expert testified that the 12-gauge shot shells, as you found in the feed room, were fired by the same shotgun. That the shot shells, the things that rolled under the door, were fired by the same gun. That's all he testified to as to shotgun. Now, they have put a lot of guns in evidence here that have nothing to do with the crime. So we don't know what shotgun was used. It could have been a shotgun bought at Walmart that afternoon. It could have been a 20-year-old shotgun. But all the evidence, ballistic evidence, is shot shells were fired by the same gun. And don't know that you really need an expert for that, but that's what the testimony was on the shotgun. With regard to the 300 blackout, you'll recall that this guy Paul Greer testified that the cartridges found at the crime scene, and Maggie was shot with a 300 blackout, that the tool marks, it's called tool marks, that the extractor and ejector marks from the cartridges found at the crime scene matched extractor and ejector tool marks on some cartridges found at the house and some found at the shooting range. And what he didn't say was that where the firing pin breaches, that is one of the most reliable indications, it did not match. No match. And he also did not compare projectiles. There was a projectile found. When I say projectile, that's the bullet thing. That went into Maggie's body and broke up. But one went into the dog house and was found in the dog bed. And so they have that. And what they did not do is take that projectile and dig projectiles out of the berm where the shooting range was and compare it to see if they match. And that's the most reliable way to do it. Now, in David Owen's notes, he said that the ballistic expert can't be 100% sure until you have the gun. And you heard my cross-examination of Agent Greer, and this tool mark ballistic examination is somewhat soft science. It's come under criticism. It's what they rely upon. Not every investigative lab relies upon it. That's what they did here, but it's not gospel. It's not gospel. Another thing about the 300 blackout, he in his closing, Mr. Waters repeatedly said that Alec bought it. And I assume we're talking about the replacement. I don't know. Alec bought it. Well, Alec didn't buy it. The evidence in the record is Maggie bought it. And he kept saying it's the defendants. And it's not the defendants. The replacement 300 blackout, which frankly no one had seen Paul with it in quite some time except Will Loving on one occasion sometime in March. It was Paul's gun. It wasn't Alec's gun. Paul's gun. At one point in time during his closing argument yesterday, Mr. Waters reenacted a shooting scenario, if you'll recall. And I'll do my best, but he stands up here and he says that Alec shoots Paul in the chest one time. And 999,999 times out of a million, that person is dead. He puts his shotgun down, and he has a 300 blackout right here because he is so smart and so diabolical that he's going to stage it so it look like two shooters. So he's got a 300 blackout here, a shotgun that he just took his son out, but his son was 1 in a million, he says. 1 in a million comes this way, so Alec has to put the 300 blackout back down, pick up the shotgun, and shoot Paul. Where in the world does that scenario reside other than in Mr. Waters' mind? It doesn't. It doesn't. There's no evidence to support anything like that. None. None. And the fact that he has to go to such gymnastics to come up with Alec staging a two-shooter theory, I ought to tell you, there's 2 shooters out there. I ought to tell you, someone to do that. Another curious point in Mr. Waters' closing argument yesterday involves Paul's intuitive talents. You will recall that Alex informed agents that Paul was an intuitive little dude. Referred to him as a detective. that Miriam Proctor, Maggie's sister, said that Maggie referred to Paul as his little detective, her little detective. And particularly when it came to trying to root out whether Alex was still doing drugs. And then he just sort of left it there. Sort of left it there for you to then take it and run with it as if, oh, Paul must have found Alex using drugs. There must have been a confrontation down there at the kennel, and that must have been what happened. Now he didn't go that far in his argument, but he laid it out there for you to run with. But that was clearly the implication. And I want to tell you first, there are no facts to support that. None whatsoever. Let me add another scenario that's equally as plausible. What if Paul the detective learned the source of drugs that were being sold to his dad? What if Paul the detective goes to that drug source, says, cut it out, that's my dad, you're in my family, and if you don't, I'm going to tell on you, turn you in. And what if source is a member of dangerous drug gang?
No, I won't object.
Sustained.
Well, the point is, there's no more evidence to support it, and there was no evidence. Those were just plausible scenarios that they were throwing out to you, and that you could think up many equally plausible scenarios. But you have to decide the evidence based on the facts that the state puts before you. Not theories, not inferences, not speculation, but cold, hard facts. Mr. Waters also said that Alex, the master liar, accused Shelley, Smith, Blanca, and perhaps another witness of lying. He never did such a thing. He never accused anybody of lying from this witness stand. Now, I've been around long enough to know that witnesses can misremember things and believe them to be true. And frankly, I'm the biggest defender of that trait in my household. I convinced myself that I remembered something accurately, and I will have an argument with my wife until she shows me photographic evidence that I'm just wrong, and that's what it takes. I mean, that happens. People misremember things. But because we point out that there was an inconsistent fact, that doesn't mean we're saying someone lied, and we never did that. We never did that. One example is Sister Marion. One example of misremembering. Sister Marion said that she spoke with Maggie about 7 p.m. while she was at Edistow, and that Alec wanted to come to Moselle to visit her father. Well, we know that her recollection is mistaken because we have cell phone records, we got FBI records, we got her phone bill, we got that shows she was in Mount Pleasant and then she was traveling to Moselle around the period of time where Sister Marion thought she was at Edistow. Did not happen. That doesn't mean she was lying about that. Absolutely not. That's just how she remembered it. And she also said that when she talked to Maggie, that Maggie was going to go over and visit Mr. Randolph at Alameda. But we know from the records that Mr. Randolph had already been readmitted to the hospital. I mean, that's in the records. And that Maggie knew it. We've got Maggie's text to Blanca, I think, in the day saying they're putting Mr. Randolph back in the hospital. We're scared for everybody and hope Alec doesn't go down to the hospital. Well, no reason I'm pointing it out. This is how Miriam remembered it. But if she remembered it incorrectly, and that happens. But because we point stuff out like that, we're not saying they're lying. Now, then the same with Shelley and the blue tarp. She remembers something, we're not sure what. But the evidence clearly is, she says it was on Wednesday, June 16th. And we got FBI cell phone forensics, we've got records, and we got testimony that Alec is in Somerville. Spent the night with his in-laws, the Branstead on Tuesday, and he stayed there toward the end of the week, and then they went to the mountains at Kiowee. So Alec could not have been knocking on the door of the Alameda house on the morning of June 16th. And Barbara Mixon came in and told you that she relieves Shelley. Shelley works all night, leaves, and goes to work at the school district. Barbara Ann comes in at 8 o'clock and relieves Shelley. And as Shelley recalled it, as the tarp was laid out when she left for work. Barbara Ann came in and said, well, I didn't see it. No time during that week that when I worked was there a blue tarp. I mean, you know, Shelley remembers something, but she's not a blue raincoat, and it's certainly Alec could not have come over there on Wednesday. Now Shelley also says that he spoke to me about times, and that bothered me. And I called my brother. We're not disputing that, but what she didn't say is Alec told me to say I was here in 45 minutes or things like that, and frankly, it doesn't make a lot of sense because Alec kept saying, "You get my phone records. You get my phone records, and you'll know exactly what time I was when I was there." And I'll get to this a little bit more in a moment, but Mr. Waters keeps talking about compress the time so that it looks like he's been gone from Moselle longer than he was. Fair enough argument. I understand his point, but that point evaporates when you're talking about how long you are at Alameda. It doesn't matter if he's there 45 minutes or 20 minutes. I mean, does it really matter how long he was there? Now, I guess before you had the OnStar data, they could be saying, oh, he said he was there 45 minutes, but he was only there 22 minutes, and he spent the other 10, 15 minutes traipsing through the woods, burying bloody clothes, and getting rid of murder weapons. Well, we may have heard that in this trial had we not gotten the OnStar data from General Motors in the middle of the trial, which shows conclusively he drove over there and he drove straight back. Another small point, he said there's biological material on the Polaris. I don't think that was ever tested. It certainly looks like it, but what we've learned in this case is things aren't always as they seem. They thought they had blood on the shirt. Turns out there's no blood on the shirt. And that this biological material showed that Maggie was running toward her baby. Now, I don't know that there's any evidence which way Maggie was running or what she was running to. There's not. I mean, it's a fair inference, and everyone who knows Maggie would know that's what she would do, and we're not disputing that would be her mother instinct. And did that probably happen? It probably did, but it's just stated as a fact. There's no evidence of that. Now, one thing he also said, the cell phone backlight turning on. And I don't have an Apple phone, but so here's the issue, and mine won't do it because I don't have an Apple phone, I don't think, but if you take a phone flat and pick it up, light comes on. And why is that important? Why is that important? Like I say, I'll probably turn this phone off. And if I'm making a point that you all know the answer to, I apologize, but it's important that you do know the answer to why this is important. It's important because now that we have the OnStar data, we know Alec drove his Suburban by the spot where Maggie's phone was found at 9:08. Now, there's probably some seconds in there, but 9:08. And we know that her phone is in the woods at that point. So the question is, did Alec throw it out the window at 9:08? And the answer is, no, he didn't. Because if you throw it out the window, at a minimum, the display light's going to come on. At a minimum. And when that display light comes on, it registers. These phones say a lot. Lesson learned in this case. It registers in this Knowledge C database, and it says display light on. And it has a time that the display light came on. Well, there's no, on Maggie's phone, the display light does not come on at 9:08. Okay? So, means Alec didn't throw the phone out. And yesterday, Mr. Waters says every single expert testified that the backlight comes on and sometimes it doesn't when the phone is raised aggressively. That's not true. Only one person testified to that. And Mr. Murdaugh, who, over the weekend, he works for Charleston County Sheriff's Department. I don't know why they didn't get SLED agent to do it, but he sits, apparently he got a phone similar to one that Maggie had, not Maggie's phone, had software, well, not the same version as Maggie, and he spent all weekend throwing the phone on the ground and see what would happen. Or many hours of the day throwing the phone on the ground. And he comes in here and says, hey folks, sometimes the light comes on, sometimes it doesn't. Well, our expert, Mika Sturgis, says it comes on. It comes on. And that's what we're talking about. That's what we're talking about. But folks, we wouldn't even be having this discussion if they had secured Maggie's phone and not allowed and put it in a Faraday bag so that the GPS coordinates on the 7th would not have been overwritten. And they were. So now we got a guy down in Charleston throwing a phone around all weekend. Because they are desperate to prove Alec threw the phone out when he went by the ring. They got no evidence of that. In fact, the evidence is the contrary. He did not. And the evidence supports everything that he had said from the day he had that interview, or a couple of days. You get the OnStar data, you get GPS data, you get my GPS data, and you'll know I'm not traveling with her phone. Never got it, wrote over it, and now we've got a guy tossing a phone in an office. Doesn't even work for SLED. Not every expert says that. The guys even said that's not his area of expertise. So, let's see if I've hit all. Oh yeah, the last one's about me. Mr. Waters says that I did an HBO interview in November 2022, and he references some things I said in the HBO interview. Well, I didn't, and he knows I didn't. It was testified about. There's an HBO special. I am on it. I'm not telling anybody to watch it, but that was filmed back in, I don't know, spring, summer of 2022. I'm well before he was charged with murder. I'm not on TV talking about his murder charges, but he wants you to think that, and I don't know why, and I took a little bit of offense to that. I really did.
And we object, because he was.
I was not being interviewed.
Objections overruled.
Not being interviewed in November of 2022. Not. So I've asked why. They can't answer that. They don't have an answer as to why. Now how? How could Alec, in the time period we know, we're going to get to it, but how could he have butchered Maggie and Paul without leaving a trace of evidence within a matter of minutes? How? We went from why, now how. And the answer to the how is he couldn't. But this is the wrong question to be asking yourselves. Because the question that you are tasked with answering is, has the state presented evidence that proves beyond a reasonable doubt showing that Alec butchered Maggie and Paul without leaving a trace of evidence, all within a matter of minutes? In a matter of minutes. Have they proven evidence? Do they present evidence of that? Proof beyond a reasonable doubt. He was able to make bloody clothes, bloody guns, who knows how much, whatever, disappear in a matter of minutes without leaving a trace. Without leaving a trace. Of course they haven't. A reasonable doubt is doubt that causes a reasonable person to hesitate in one of the most important decisions of your life. And here, there's no direct evidence of Alec doing anything other than he's at the kennel, 8:44, and it's just pleasant family talking about Bubba the dog getting a chicken. So the state's trying to weave this story of his guilt based upon circumstantial evidence. And the judge will charge you on circumstantial evidence, and I have no dispute with what the state put up here yesterday, because that's the law, and you're going to get it. He's going to give you the written document with the charge. And you will see in there that when they rely upon circumstantial evidence, it's as good as direct evidence, but there's some things that it has to do to be as good as direct evidence. And what it has to do, the circumstantial evidence, is that the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. And if these circumstances portray the behavior of a defendant as suspicious, the proof has failed. That's circumstantial evidence. So what are the circumstances that the state relies upon? Well, he was at the kennel at 8:44. Paul last used his phone at 8:48. He replied to a text with a friend about a movie recommendation. Maggie's phone locked for the last time at 8:50. Actually, it's 8:49 and 50 some odd seconds, but 8:50. But, however, her phone recorded significant steps around 8:55, and we're going to see that. And her phone tried to activate the camera at 8:55, and it registered an orientation change at 9:06. And I think you pretty much understand the orientation change, but when the phone goes from landscape to portrait, or this is beats me, but goes from that to that is an orientation change, and the phone will tell you. So it did that at 9:06, and they've got 300 shell casings, the extractor and ejector markings match with casings found around the house and shooting range. So that's pretty much it. And then of the circumstantial evidence of his guilt. Now they want to say, well, he lied about it, so it's consciousness of guilt, but I'm talking about what evidence they have, put all the circumstances together, prove he shot and killed Maggie Paul, and that's pretty much it. And how have they established the time of death here? Solely on cell phone use. Solely on cell phone use. And using the phone or not using the phone doesn't dictate or define whether you're dead or alive. I mean, I'd say most everybody in this courtroom does not have their phone with them right now. Under the state's theory, as I mentioned before, if they die while they're not using their phone, then they're dead the moment they stop using their phone. That's what they have here. That is their case. There are a number of reasons that Paul would stop using his phone. First, so I got two testimonial clips, one from Rogan. Remember Rogan Gibson? If you'll play that quickly, Doug. This is Rogan testifying about Paul's phone.
You were asking a little bit about Paul's cell phone usage. He was on it a lot.
He was on it a lot, yes, sir.
Yeah, and
Who's testifying?
and did the battery get down?
Okay, just a moment. All right. What is the objection?
Not showing the witness, they're showing the defendant while the witness is testifying. I think the testimony was.
What's the legal basis for the objection?
That is correct.
All right. Mr. Griffin.
It's a clip from the live feed of this trial, Your Honor. I can't control who is being depicted, but it's my voice asking Rogan.
Been in trial how many weeks?
6 weeks.
All right, so we're not going to replay the trial.
That's right. It's a clip of a few seconds.
I sustain the objection.
All right, take it down, Bill. So you will remember that Rogan said that when Paul's phone, and by the way, if you don't remember and you have questions about it, when you're jury deliberations, you can always ask to have testimony replayed for you through. Your Honor, can we play the audio without the video?
You're asking me,
Yes.
what can you do? I rule on objections.
Can you play the audio then, please?
You asked a little bit about Paul's cell phone usage. He was on it a lot.
He was on it a lot, yes, sir.
Yeah, and did the battery get down low pretty regularly?
Yes, he would let his phone die sometime, or he would lose it.
Well, and when it would get down low, did he have a habit of not using it to try to keep him going all the way out?
Yes, I have seen that happen before.
And have you done that yourself?
Yes, sir.
All right, and so you'll know from the photographs and the evidence in the case that Paul's phone was at 2%, and it was on low power mode at the time. He was texting this friend of his about a movie recommendation. And then, can you play the audio only of, you remember Nate Tootin, and he testified about Paul putting the phone down when he was working around the kennels.
And how would you describe the relationship between Paul and Alex?
They had a really good relationship.
Would you say that Alex?
I don't think that's the right clip. The so there, Mr. Tootin testified that when Paul would work, he would put the phone down, forget where it was at times, and that it was pretty common for him to put the phone down at the kennel so he wouldn't get it wet. And you recall, Dale Davis, they brought him to the stand. I think they brought him to the stand to make it seem like the hose was unraveled and then it was used and put back. And we know from the video, and you can see it again, the dog kennel video, we pointed out the hose is on the ground outside Cash's kennels. And Mr. Davis says, yeah, that was not how I left it. Someone had put it down, and then I'm going to show you. Got it right here. Doug, can I have the Elmo, please? Oh, that's awful. Just give it to me, please. Ladies and gentlemen, you'll have back in the jury room State's Exhibit 503, which is a picture of the dog kennels from the murder scene, and what I'm pointing out on top of these two kennels are dog beds. You'll see Exhibit 503. The dog beds are up here on top. And you recall Dale Davis says that when you clean out the kennels, hose it down, you put the dog beds on top. On top. So it's pretty clear from these photos, this photo, that Paul and or Maggie had sprayed out the dog runs and put the dog beds on top, and put the hose away. Alec testified that Bubba and Grady had on collars, and we see the collars in State's 45. And so their collar's hanging here, but their collar's hanging here, and then there's collars here. And the dogs don't have collars on them in the dog picture. So it's a fair conclusion that after Alec left, when he said he left, that Paul puts Bubba up, Paul puts Grady up, after cleaning out the kennels, and then he goes back into the feed room to get his phone, where he was confronted. Or sometime later it happened. I don't know. But they are relying upon cell phone usage for time of death. The coroner said he did the armpit test, which is no test at all. It's just a guesstimate. Can you pull up in evidence? Now I want to talk about Maggie's phone and Defendant's Exhibit 158, please. So this is Maggie's phone timeline that we put in evidence, and this is going from 8:49 to 9:07. And if you'll just walk through it, you'll see at 8:49:26, last text message read by Maggie. Okay, go to the next one. 8:49:28, backlight off. Go to the next one. 8:49:31, phone locks and remains locked until recovery by law enforcement. It was locked for the last time and never unlocked. 8:53, but on 8:53 the backlight comes on. It's being manipulated. 8:53:12, orientation to portrait starts. 8:53:15, phone begins logging 59 steps. 8:53:20, there's a Siri usage, and the testimony is you can get that by squeezing the button. 8:53:24, the orientation portrait completes, so it switches. And then 8:53:28, backlight is off. Next, backlight is on. Backlight is off again. And it's on again. Keep going. And then 8:54:34, camera use starts. It's activated by touching the camera icon or by swiping left from the lock screen. There was a question as to whether that could be from facial recognition, and Lieutenant Dove said that information resides in the Knowledge C database, but he did not look for it. Micah Sturgis, our expert, looked for it, found it, and came and told you that was not a facial recognition miss. It was from intentionally activating the phone only for 1 second. Go to the next slide. Camera usage ends. Go to the next slide. Orientation to landscape starts. 8:54:44, it ends. And then 8:55. So the point is, there's a lot going on with Maggie's phone at around 8:55. Keep going. Keep going. And then at 9:03, the backlight goes off. And at 9:04, there's a missed call from Alex. And at 9:04:23, the backlight's off. And 9:04:41, the missed call from Alex ends. So let's back up to, let's go to 9:04:23, missed call from Alex. Okay, and this was the testimony on 9:04:23, and it's important. Alex calls Maggie, and when that happens, you would her backlight was on. Go back one more. So her backlight is on at 9:03:52. At 9:04, missed call from Alex starts. At 9:04:23, and instantaneously, the backlight goes off. Now, you heard the testimony of that means when that call came in, someone pushed on the side to stop the call. Now, was that done by Maggie because she was over on the other side of the workshop where we see those footprints that we heard about that were never really analyzed? And that she didn't want any noise coming through? Or was that some bad guy or bad person has Maggie's phone and stops the call? But something's going on with her phone at 9:04, I'll tell you that. And then at 9:04, the next one is missed call from Alex Enns. 9:05, backlight on. 9:06, orientation changes to portrait. 9:07, incoming call from Alex. 9:06, 14. Keep going, Doug. And 9:06, 52. Keep going. And then at 9:07, her phone stops for good. Now, one of the things that you heard in this case is that orientation change was at 9:06 that we just talked about. And Doug, if you'll go to the if you go to Defendants 156, please. And so these are Alex's steps on his phone that were registered during this time period. And if you'll go to entry, if you'll look at entry 28, and if you'll pull that out, Doug. All right, so 28, this is between 9:02:18 and 9:06:47. And this is the time period that Mr. Waters in his argument said was scurrying around because he took, can you just bring it back a little bit more, please? So can we do it so we can see the whole line? Just that's fine. So that so here we see line 28 between 9:02 and 9:06. There's 283 steps, and it went 208 meters. So I want you to first, and so they take the position that this is him scurrying around. But if you do the math, which we haven't done here on this document, but 283 steps in 269 minutes, 269 seconds, turns out to be 1.05 steps per second. 0.05. 1.05 steps per second. Multiply that by 60, you get 63 steps per second. And if, ladies and gentlemen, this is a slow walk. 1 step per second. 1001, 1002, 1003, 1004, 1005. This is Alex scurrying around according to the state's case. And if you look at the distance in meters of the last, when he gets, I guess, to the house at 7:55 to 8:55, he goes 203 meters before it stops registering. And then one thing you will remember during this time period, between 9:02 and 9:06, at 9:06, Maggie's phone has an orientation change. Her phone has moved from here to here, but what her phone doesn't have, go to the second page. What her phone doesn't have are steps. And Lieutenant Dove testified that yeah, it doesn't look like anyone, like, that her phone is moving at 9:06, but there's no steps being registered. Alec is walking from 9:02 to 9:06. So, we bear the reason that Alec is not walking with Maggie's phone. That's the timeline data that I wanted to review with you. The if you'll go to Exhibit 524, Defendant's Exhibit 524, please. I think it's, yeah, State's 524. I'm sorry. Do you have that? So if you'll go to the slide where no, sir, not 38. Do you have the whole document, or you don't? Oh, yeah, we'll drop that. Okay. Well, I mentioned earlier, and so State's Exhibit 524 is all the OnStar data. You will see there that he goes by the spot at 9:08 where Maggie's phone was found. And there was testimony that he sped up after he went by there. He sped up to like from 42 to 45 and went back down to 44 miles an hour when he went by there. He's not speeding up when he goes by the area where Maggie's phone was found, whenever it was tossed. And then they have, a chart or slide that talks about how long it took him to get over there and the speeds that it took. And Mr. Waters was arguing to you that compressed the timeline. The faster he gets over to Alameda, it means that he's gone longer from Moselle, and it gives him a better alibi because, as you know, he's orchestrating this alibi. And so he's driving fast over to Alameda according to their theory, and we graphed it out, and he's passing some cars, and he is, he's a fast driver. Okay, so they say, he's compressing the timeline. Compressing the timeline is what they say, compressing the timeline. But then they say, he drives fast on the way back. Why? He's driving the same speed over there, same speed back. There's no reason to compress the timeline coming back. I mean, you'd want to be driving slow as you can to make it appear you've been gone a lot longer. I mean, he drives the same speed from Moselle to Alameda as from Alameda back to Moselle. It takes him the same amount of time. He's not compressing any timeline at all. And what's the most curious part about Maggie's phone? About Maggie's phone? What's most curious about it is Alec has her password. Alec, if he is wanting to change the timeline, when he calls her phone, he should answer her phone. When he texts her, he should reply to that text to show activity on her phone that she's still alive. If he is manufacturing a timeline by speeding, the easiest way to do it is use both phones, talk on both phones, and he did it. I mean, this whole thing about using Maggie's phone, driving Maggie's phone, throwing Maggie's phone out it's such a stretch for them to come in and try to put her phone in his hand. And then you start thinking through, why would Alec take her phone and not Paul's phone? Let's start there. Why would Alec take her phone and not Paul's phone? That's a question I don't have an answer to. It makes no sense. It makes no sense why he would take Maggie's phone. If there's something on there, he knows her password. Put it in. see what it is. We know from all this phone data, her phone was never unlocked. And he had the keys. So if he's taking her phone to unlock or to do something with it, he didn't. And so why? Why? And these are circumstances that have to be consistent with each other and have to point conclusively to the guilt of Alec Murdaugh, beyond a reasonable doubt. And these circumstances just raise more questions, ladies and gentlemen, raise more questions that we wouldn't have to be dealing with if they had just simply secured Maggie's phone in a Faraday bag on June the 8th when they got it. We wouldn't be here. So we do know from the timeline that Alec left the property at 9:07. Were they killed before he left? I don't know the answer to that. But we do know that if he was in the house when the shots were made down at the kennel, that he would not have heard them. We had decibel testing from Mr. Sutton. Now they were angry with Mr. Sutton's angle test. They were not angry, but they challenged his conclusions on a lot of things. But they didn't touch his acoustic testing. Didn't doubt that. Haven't challenged that. And so if he's in the house and shots are ringing down at the kennel, he doesn't hear them. Now, they say that sometime after 8:44, and they peg it 8:48, 8:50, because that's when Paul last responded to a text from this friend of his, but they ignore the fact that it had to be cleaned up, and I think Buster testified that takes 10 minutes at least to get the dogs in, clean up, and et cetera. And then there's all this 8:55 stuff going on Maggie's phone, but let's take him at their theory at 8:50, after having a pleasant conversation, talking about is it a guinea or is it a chicken, and Bubba, and all right, so 4 minutes later, let's go ahead and kill my wife and my son because I got questioned at the office today by Jeannie's secretary. Okay, that's their case. So let's run with it and see where it takes us. Well, it takes us that he leaves the property at 9:07. So from the moment, if he's got, if it happens at 8:50, he's got 17 minutes. 17 minutes. He would have to be a magician to make all that evidence disappear. As you heard, under either Dr. Kinsey or Mr. Palmbach, Dr. Reamer and Dr. Kinsey, Mr. Palmbach and Dr. Eisenstadt, either way, the shooter's covered with blood on Paul's shooting. And that's what all that testimony was about. It wasn't about trying to figure out who's got the right angles. The whole point of that is, while we ended up having to get our own experts, is to prove the shooter is covered in biological material, covered in blood, covered in everything, because of the blowback. And it wasn't until on reply that Dr. Kinsey said, oh, well, there'd be blowback under my version too. Blowback meaning blood, biological material from killing Paul. So the shooter's covered in blood. The shooter's gun is covered in blood. And that there's not sufficient amount of time to clean all that up, make all that disappear. And then call your son Buster, driving to visit your mother, who he had gotten a call from Barbara Mixon earlier today and said your mother's agitated because your dad went back in the hospital and you might want to check on her. He goes to check on her. He calls Buster. And does he say, hey, Bus, I just blew your mom and brother up? You should see the damn mess. Are you kidding me? He calls Chris Wilson. Normal conversation. He calls his brother John Marvin, talking about his dad. And then he goes over there and he sits down with Shelley and sits on his mom's dad. And he stays there 20 minutes, not 40 minutes or 22 minutes. I don't know. The records show what time. But the fact of the matter is, he's got no blood on him. He's acting normal as every day. He is the same old Alec. Yet their theory is he just blew the people he loved the most in this world, blew him away. Now, I'll talk a little bit about the angles that Mr. Sutton did, his reverse trajectories on the shots, and I mean they're having a good time joking about the size of the figure in the pharaoh, saying, "Oh, it must have been a 12-year-old kid. It's 5'2", 5'4", and you know, let them have their fun." But that's not what the testimony was. Testimony was that the barrel of the gun has to be at that level to make the shot into the quail pen. We didn't take the measurements. SLED took the measurements. And so, yeah, could a 6'4" person get down to that level? Sure. And Mr. Sutton says that's not a natural shooting angle. Could a 6'4" person get on their knees? Sure. Shooters are in movement, and a 6'4" person is going to be moving around on their knees? I don't think so. But, you know, the most common sense thing here is there were two shooters. Because there were two guns, and as Mr. Palmbach said, one gun is high capacity, holds 10, 20, 30 rounds. And if you're going down to execute somebody, one gun's enough. Why take another gun that only has 3 shots? And Dr. Kinsey agreed with the angle coming out of the quail pen, so that the angle puts it pretty far away from the door of the feed room where Paul's killed. But it's not our burden. It's not our burden. It's their burden to prove to you, based on circumstantial evidence, that all the circumstances are consistent with each other and point conclusively to the defendant's guilt beyond a reasonable doubt. And those facts are just not consistent. Those facts are just not consistent. I want to say a word about condition of Paul and Maggie, particularly Paul. I'm not going to show you any photos, but I think you would agree that it was so bad. It was so bad. And Alec, in the back of the car, with me in the back of that, you could see me on the camera, sitting there and talking to Agent Owen and Agent Croft, and he says it was so bad, they did him so bad. Agent Croft misheard that and said, he said I did him so bad. And I think the evidence is, everyone who's listened to it and everyone who knows what Alex was talking about around that time says they did him so bad. And Agent Owen was in the car, and he doesn't say to you, oh, he actually said I did him so bad. I think we can put that issue to rest, but that issue points to a bigger question. What would they be saying in this trial if that conversation wasn't videotaped? What would they be saying? We know Agent Croft would be saying, he said, I did him so bad. And then where would we be then? I am grateful to SLED that they videotaped that, so that you'll hear it if you have any questions. I don't think you should, but They did him so bad. That is for sure. Another thing that we're going to clear up right now is Alec's concern for Buster. You heard that, and you heard that in Mr. Waters' closing. That in the statements that Alec made on the roadside shooting in Labor Day weekend, where he tried to arrange assisted suicide, that he told officers that there's no danger to Buster. Of course, there was no danger to Buster because of that roadside shooting, because he knew who shot him, Curtis Eddie Smith. He knew he was trying to get himself killed. But from that, there's going, the reason he knows there's nothing to worry about Buster is because he knows he did it. That's what was just argued yesterday. Well, Deputy McDowell, in a body cam video that's in evidence, captured Alec speaking to Buddy Hill about his concern about Buster's safety. And will you play that now, Doug? It's in evidence. I don't have the exhibit number. Again? Because I think the...
Randy, what about Buster? You gotta get... Mr. Bud, can y'all get a police officer with my oldest son in Columbia? Can you call Buster? No, I haven't told him yet.
Did you hear that? Can y'all get a police officer for my oldest son in Columbia? What about Buster? What about Buster? Can y'all get a police officer for my oldest son? Buddy, can y'all get a police officer for my oldest son in Columbia? That's Buddy Hill, the sheriff. And they want to come in here and tell you he wasn't concerned for Buster's safety? Once again, I'm grateful Colleton County Sheriff's Department had body cams. Because now you know. You know Alec was concerned. You know Alec asked for a police officer for his son in Columbia, Buster. Now I'm almost done, I promise. But I do want to talk about Alec's misstatements about time. Alex told Deputy Owen during the interviews that, well, first, Alec's statements about time are not lies; they were just misstatements, and even like I said. Deputy Owen says people make mistakes about all the... Agent Owen, they make mistakes about time all the time, and they do. Now, Mr. Waters is critical because Alec was wrong every time he gave a time estimate. Turns out, I think Mr. Waters is probably right about that. Whether the time period is inconsequential or consequential, he's wrong about it. And the... And we had brought in, Alec had told deputies in an interview that he got home at 5 o'clock, and that's not true. That he went to work that day at 8:30, that's not true. And so he is just wrong on times. But what was consistent, whenever he had an interview, he said, you get the records, and it will show what time did this, what time I did that. It will all be in the records. And guess what? They are in the records. And when the records show that his time estimate was wrong, they jump up and down. The statement to Deputy Green, he says, I've gone to my mom's for about an hour and a half, and I last saw them 45 minutes. Now that I don't know. I frankly don't know if that's wrong or not. I mean, he's talking to Deputy Green about 10:30. Hour and a half from 10:30 is 9 o'clock. I mean, he left. He left at 9. He left at 9:07. But That's that. The question about what he did when he got down to the scene, and he said he ran up to Paul and Maggie, and he left his phone, and then he went back to get his phone, and then he's talking to the 911 operator, and you can hear it, and he says, "I've been up to it now. It's bad." He doesn't remember the sequencing, and I don't think anyone should hold that against him. You know, Mr. Waters gets up here and says Maggie was running to her baby. Alec was running to his baby. And can you imagine what he saw? And is it evidence of guilt that he doesn't remember what the sequencing was in that moment? Is that evidence? Is that evidence of guilt? Or is that evidence of trauma? This is a guy that then went to get a 12-gauge shotgun, and he put 16-gauge shells in it. He knows the difference, but he didn't know that night. And I'm not quite understanding what the state makes of this. Did he not go up to their bodies? Because the forensic evidence sure speaks to the contrary. What we have is Maggie's DNA all over his T-shirt, and you heard that from Agent Zapata. We have Paul's DNA on his T-shirt. How did he get Paul and Maggie's DNA on his T-shirt if he didn't touch them? If he brutally murdered them, hosed off down there next to their dead bodies, got in a golf cart butt naked, drove to the house, changed clothes, went over to his mom's, goes down, calls 911, then searches for Whaley restaurant menu and checking emails, waiting for the police to show up. How does he get their DNA on his body? Because it's on there. Their forensic lab tells you that. Because he went up to them and touched them. And then there's a spot of blood on the Suburban steering wheel that was Maggie's. And we know that the Suburban was never down at the kennel, thanks to the OnStar information. I'm not sure that was an accepted fact until OnStar sent their stuff in, but the Suburban never went down to the kennel until after he returned back from Moselle. So we know the blood got on the steering wheel after he checked Maggie like he said he did on the 911 call. And then there's a spot of blood on the gun that he went to get. And then there's GSR. There's GSR. There's 3 particles of GSR on his shirt, 3 particles of GSR on his shorts, and 1 on his finger. And the SLED agent testified that's consistent with transferred GSR when you pick up a gun. So, but really, we're back to the lie. We are back to the lie. Because that's all they have in this case, is that Alec lied to them when he last saw them. And he shouldn't have. And he shouldn't have. And he said, what a tangled web we weave once we start to deceive. And once he lied the first time, he was stuck with the lie, and he continued to lie. And he shouldn't have. He shouldn't have. And he told you, what was going through his mind. Probably wasn't rational, but he was in the throes of an addiction, and he had just found his wife and son murdered. And he's being interviewed. He'd been swiped for GSR, and he does think David Owen is the guy that investigated his friend. But he was wrong, and he told you. Turns out he was wrong, but I thought that's who it was that night. And he was under investigation he was being accused of obstructing the boating accident investigation, and he's under investigation by SLED for that. And he had all these skeletons in his closet, and he was wanting to get them away from him and looking for the real killer. The state in this case has gone to lengths trying to, through a sleight of hand, convince you of this and show you that, and without convince you of guilt, without showing evidence of guilt, convince you that he murdered his wife and son because of his financial misdeeds were going to come out, which is about the most illogical thing imaginable, and there's no evidence of that. And then the state brings all these shotguns in here, and I'm not going to pick every one of them up, but the forensic evidence on these shotguns is they can't be excluded. Well, okay. They can't be included either, so you know nothing more about these shotguns than you would have the day you showed up for jury selection, because there's nothing to know about them. Can't exclude them, can't include them according to them, but we do know there's no blood, guts, brains on any of the guns that would have been there from this shooting under everybody's interpretation of how Paul was murdered. They want you to think that because you own guns that you should be viewed differently. I don't know what else to make of that. I don't know what else to make of that. When this trial began with opening statements on January 25th, Mr. Harpootlian asked, why? Why would Alex execute his wife and son in cold blood? And here we are, 6 weeks later. And you've heard weeks' testimony about Alex's financial crimes, drug addiction, and lies. But after all that, the state has failed to provide a satisfactory answer to this question. Why? The state cannot provide an answer to this question because the answer is he would not, under any circumstances, murder those that meant the most to him. Your oath requires that you hold the state to the exacting standard of proof that the state must prove the defendant's guilt beyond a reasonable doubt. And when they rely solely on circumstantial evidence, these circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. And if they merely portray the behavior of the defendant as suspicious, you must find him not guilty. The state's evidence fails to meet these requirements. Circumstances don't point conclusively to Alex's guilt. Far from it. Mr. Waters wants you to believe that Alex slaughtered Maggie and Paul on June 7th and repeatedly lied and changed the story to fit the timeline and evidence. As it turns out, in fact, the state is the one that's been manipulating evidence to fit their theories of guilt, which changed over time, from the date of these murders until yesterday. In the absence of forensic science, a reliable investigation, the guns, blood spatter, the time and opportunity to have committed these murders, you're instead left to make inferences about all sorts of interactions and behaviors. Prosecution wants you to view the evidence through the diabolical monster lens that they have tried to paint, but the law requires you to view it through the lens of innocence, where none of these things, individually or taken together, prove conclusively to Alex's guilt beyond a reasonable doubt. Up until now, you've not been able to say a single word. Can't imagine how frustrating that must be. But soon you will have the most powerful voice in this courtroom. With your words, you can let everyone know that in a court of law, only evidence and the burden of proof matters, not gossip, innuendo, opinions, and most of all, not theories layered on top of speculation. With your words, you can let the state know that they don't get to obtain an indictment by misleading a grand jury and then bring you before you a case built on theories, speculation, There are two words that justice demands in this case, and those two words are not guilty. The oath you've taken in this case is to follow the law, to follow the Constitution, and to hold the government to the burden of proof. And it requires a verdict of not guilty. On behalf of Alex, on behalf of Buster, on behalf of Maggie, and on behalf of my friend Paul, I respectfully request that you do not compound a family tragedy with another. Thank you.
Ladies and gentlemen, we'll send you to the jury room for a break. Please do not discuss the case. Everyone will be seated. So, Mr. Meadows, are you closing on behalf of the state?
Yes, sir.
Do you have an estimated length of time that you might go?
No more than 40 minutes.
You ready to go?
If you give me, I just need to go to the bathroom.
Sure. All right, we'll take a 5-minute recess.
During his questioning of the witnesses. And one of the biggest is that the defense is trying to push the theory that SLED did a sloppy job of investigating. He went through several issues that he had with SLED on this investigation. He talked about the tire tracks not being preserved. He talked about bloody footprints not being tested. And he talked about Maggie's phone finally not being put in one of those fair day bags that would have perhaps vindicated Alex's story that those two phones never traveled together and that he didn't in fact slow down on his way to Alameda that night to toss the phone out. I know we have some sound a little bit earlier of him talking about these tire tracks and the evidence that he feels SLED should have collected. Let's listen to that.
What did you hear from the witness stand? You heard from Chief Barry McCroy. I didn't know Chief McCroy until I got involved in this case. But his reputation is outstanding, and he's a consummate professional. And he explained that when he got there, he was concerned that cars would be pulling up, and there were some tire tracks that were not being protected, and that they could have evidentiary value.
I don't think so. We didn't.
Logan, are we filling the break? Well, there you heard him talking about not preserving that. And I would say, if I had to say, the one theme that kept coming up again and again during his closing arguments was talking about Maggie's cell phone. Now, you might not have followed this. You probably know that Maggie's cell phone was found outside the Moselle property. But did you know that her phone only had information back to 2 days after the murders? They could only recall information from June 9th. So he really took the time to hit home on that and blamed investigators, saying if they would have put it in a fair day bag, that her phone would have been fine. I want to bring in News 19's Sam Perez, who's been listening to the testimony all morning as well. And Sam, I would have to say two things during the closings. One, the theme was SLED didn't do a complete investigation the way he would have liked to. And two, Maggie's phone apparently holds the key to everything. And if we just would have had the phone, we could have vindicated Alec, but we don't. What do you think the jurors are going to make of that?
Absolutely. I think that's certainly, one of the big things that Jim Griffin is is trying to explain to the jury, and then also trying to say, just because they have their own opinions, the state might not have produced the evidence that would get a guilty verdict. So I think really just pushing that, I think the jury's going to hear that, they're going to take that into consideration and bring that into deliberation. So I'm interested to see how it'll go.
All right, I know we have a little bit. We're talking about Maggie's phone and how many times he brought this up during his closing argument. So let's go ahead and listen to a little bit of what Jim Griffin had to say.
Maggie's phone was found on the side of the road in the morning or early afternoon on June the 8th. Whoever killed her threw that phone on the side of the road, without a doubt. Without a doubt. Alec, from the get-go, has said, you get Maggie's phone, you get my phone, or you get my OnStar data, and you will not see my car traveling down the road with Maggie's phone, because it did not happen. It could not happen.
All right, so there you heard Jim Griffin talking about that. You know what, it's funny though, he keeps saying that this phone holds the answers. It would have vindicated Alec, but do we know that? It's not something we know because again, the data on that phone only goes back to June 9th because they didn't put it in these Faraday bags. And if you don't know what a Faraday bag is, and I had to Google that myself, it is a special way to secure your cell phone. It can't be tampered with, it can't be cracked into. No, if somebody was trying, like an outside source was trying to get into the phone, so it basically protects that phone's data from anybody coming in to tamper with it. I want to talk to you now about another point he seemed pretty intent on making. Is the idea that this murder couldn't logically happen, right? He said that Alec would have had 17 minutes, and he kept getting a laugh from the jury as he said Alec would have had to be talking with his family about this chicken, commit the murders. He said he'd have to hose his body down, get rid of all the evidence, and then he said 2 different times, drive buck naked in his golf cart back to the house, getting a laugh both times. And then just saying that it doesn't make sense, it's impossible to do all of that in 17 minutes. My question is it?
That's a great question. I mean, certainly it was 17 minutes, right? And we know that there's a big distance between the house where Murdaugh ended up and then the dog kennels where he was. He had to take a golf
They said it was
cart.
about a 60-minute drive in the suburb, or 60-second drive.
60-second drive.
So it really isn't that far. It's 60 seconds in the car.
60 second in the car, but he was in his golf cart.
Right.
So it would have been a little bit longer. So thinking about 17 minutes to do all of this, I don't know. No one's tested it. No one knows for sure if it is or is not possible. But I think the goal of the defense is pointing out the inconsistencies also when it comes to, were his clothes clean? Were they not clean? Was there DNA? Was there blood? Was there no blood? I think all of that kind of, he's just trying to call into question all of the inconsistencies specifically about that 17 minutes.
Okay, something else I want to bring into the discussion. Jim Griffin talking about Alec's driving. He said that Alec just drives fast. That's what he does. You know, we have heard testimony and we have heard the OnStar data saying that he drove 70, 80 miles an hour. It was dark outside. There are back roads to Alameda, and he said he is a fast driver. That's all there is to it. And he said, you know, he brought up again that Creighton Waters said that Alec was trying to compress that timeline. So basically, Creighton Waters was saying Alec knew he had to get to Alameda quickly to make this alibi work. And today in the closing arguments, we heard no, Alec is just a fast driver. Now, again, I see both of their points. It's up to the jury to decide. How did you feel, and did you feel like that was a convincing moment for Jim Griffin?
I think it's so hard to tell. I do think it's, interesting, but this isn't something that they haven't brought up before. The defense did kind of mention that, he was just speeding up. This is normal. He drives these roads all the time. But we also heard testimony when this was discussed initially that, that road was riddled with potholes. It was dark. There are deer out on the road. So I think it's up to anyone's interpretation. Maybe it is just the way he drives, or maybe the prosecution has a point and he was going quicker than normal.
And trying to compress that. Now, he brought up, I thought one of the parts, and tell me if you agree with this, I thought one of the most powerful things of Creighton Waters' closing argument was talking about what happened in the moments right after the murder. That 4 minutes that he used the words busy bee. He said Alec became a very busy bee. He had 283 steps during that time. between 9:02 and 9:06 we're talking about. So the very busy 4 minutes that he said he was probably getting rid of murder weapons, and then started manufacturing his alibi, Creighton Waters, saying, listen, this is a seasoned prosecutor. This is somebody who knows exactly what he is going to have to do and how he is going to have to argue his own case for himself. So he is creating an alibi. So he gets in the car, Sam, and for starters, he calls Maggie 3 different times. We know that. And then instead of making the easy right to go down to the dog kennels, Creighton Waters in the testimony saying he made a left out of the property and he decided to go straight to his mother's house. But it's interesting to me when he was trying to explain that today, he said, Alec was just making calls. How could he have made calls if he had just killed his wife and son, saying that he called Chris Wilson and Buster and John Marvin? It's really an argument you can see both sides. How could he have made those calls if he had just killed his wife and son? Or is it the prosecutor in his head thinking, I've got to make these calls to cover up that I just killed my wife and son?
Absolutely. I think you can see both sides of the argument in, a lot of these instances. And then also you mentioned the steps that prosecuting attorney Creighton Waters mentioned in that kind of busy bee period that the state's claiming that the defendant was going through. But then today in court, Jim Griffin broke that down. He did the math, and he says that busy period of about 4 minutes equates to Murdaugh taking 1.05 steps per second. Now, I wasn't in there to actually see, but I guess he demonstrated it and showed that, is that a quick pace? It's really up to the jury to decide, or is that a relatively normal pace?
And again, though, we have to remember Alec's size and fitness level probably have changed quite a bit. When you look at Alec in that sled video from the interview that he did with David Owen back on June 7th, he looks very different than the man we see sitting in the courtroom today. All right, let's talk about this DNA evidence, and let's listen to what Jim Griffin had to say in the closing about the DNA or lack of DNA testing of Maggie and Paul, then we'll talk about it.
Deputy Rutland talked about seeing hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands from that moment forward. Was it tested? Was it sent off for analysis? There was no evidence of what, if anything, happened to the hair in Maggie's hands. Was it as a result of a struggle with her assailant? Was it her own hair? I mean, we don't know the answer to that.
All right, so that's what we know. That's what he presented today. I have listened to this case nonstop. Sam, I know you have too. I don't even remember hearing about the hair in Maggie's hand. Do you remember hearing about that prior to today?
See, I do remember hearing about it, but an investigator
Do you remember which witness it was?
Off the top of my head, I can't remember.
Okay.
It was early on, though, and to Jim Griffin's point today, that hair was found, and it was mentioned in court in the testimony, but then we didn't hear that much more about it. Now, I don't know if that's because it was deemed insignificant. Now, remember, they also talked about the DNA evidence under Maggie's fingernails, right? And they went through excruciating detail talking about the percentage of chances of DNA. So I don't know if the hair was in the same way, where it just wasn't really relevant. But I do remember hearing about it, but, not in much detail.
Well, I guess I should say this. Dr. Ellen Reamer did the autopsies, and as we know, she is from MUSC. I mean, to me, she was the most credible witness. I think she was incredible. 5,500 autopsies, and she said even in the week that it had been since she had testified, or the few days, she had done a dozen more.
Right.
She is a busy lady, but she testified that there were absolutely no defensive wounds on either Maggie and Paul. So we know that. We also know that Paul was shot one time, the first time in the chest, could have survived that. And the testimony has shown, the experts, Dr. Kinsey said, the way the blood spatter on the ground was that Paul took 2 steps forward after he was shot. Again, this goes to make me think, did he know his attacker? Would somebody...
Jury guy there. You may bring the jury. Thank you. Ladies and gentlemen, the state gets an opportunity to do a rebuttal. Mr. Meadors.
Police and court. Good afternoon. On behalf of Attorney General Alan Wilson, Deputy Don Zelenka, Deputy Attorney General Creighton Waters, and this entire team, and I want to name them all, but thank you for being here. Thank you for the attention you've given this case. Being a juror is not an easy job. I'm not a jury watcher. I don't sit and stare at jurors, but goodness knows we've been here 6 weeks. I have looked over occasionally, not to pry, but I've noticed when I have looked, you've all paying attention, so thank you. 6 weeks. Thank you. And I'm not going to be that long. Your clerk, Ms. Hill, has done an outstanding job bringing the world to Colleton County, bringing the world right here with her hospitality, her grace, making everything as convenient as she can. But the one thing she didn't do and couldn't do is give you a booklet on how to be a juror. 5.5 weeks ago when y'all got here, 6 weeks ago, she didn't have that pamphlet for you because they don't exist. There's not a book on how to be a juror. But you have been preparing for this moment in this courtroom to decide this case your entire life. And it's called life. It's called living. It's called experiences. It's called interacting with your spouse, your children, your neighbors, your coworkers, your good experiences, your bad experiences, evaluating people, and deciding what's credible, what's believable. It's true in every case I've ever tried in my 34 years of doing nothing but murder cases. Credibility, believability. And I agree with Mr. Griffin. When I looked at this case the first time, I said to myself, this is a CSC case. Now, in our world, that means criminal sexual conduct. It's not a criminal sexual conduct case. This is a common sense case. And you didn't leave that common sense with you when you came here 6 weeks ago. It's with you now. It's been with you during the 6 weeks here, and you're going to take it back into the jury room. I've been listening yesterday and today, and we all have, about law enforcement didn't do this, law enforcement didn't do that. I think they actually said they fabricated evidence, putting law enforcement on trial. I once called Mr. Harpootlian in a trial an automatic smoke screen machine. I think what the defense is doing in this case is more like an eclipse. You remember that eclipse on August 17th of 2017, where it kind of got dark for a little bit? And the birds started chirping, and you felt like it was dark. And then it cleared, the eclipse went over, and the light came back. That's what the defense is doing. Taking you away from the facts, from the credibility, and saying, wait a minute, there's an eclipse here, there's a smoke screen here, look at that. And somebody said the word offensive. I find it offensive that a family with a great-grandfather, a grandfather, a father, Sylvester Randolph Murdaugh, who was good to me when I was a young man, prosecutor. He knew I wanted to do this as my job. He knew I cared about this job. This is the best job in the world. I tried to be solicitor 3 times as long. It doesn't get any better than this job. And I find it offensive that the defense, through the defendant, who was also a part-time solicitor, is claiming that law enforcement didn't do their job. Listen to me, please. Didn't do their job while he is withholding and obstructing justice by not saying, I was down at the kennels. I was down at the kennels. I was down at the kennels. And he's going to blame everybody else. Is that offensive? Is that offensive? Mr. Griffin said a minute ago, can you imagine coming up on the scene and seeing, can you imagine not telling law enforcement, lying that I was down there and I saw them, I was right there? Why wouldn't you tell them that? Maybe get some more evidence. Did you hear somebody? No, I wasn't even down there. Credibility, believability. That really does sum it up. You remember 6 weeks ago today when Mr. Waters' fantastic opening and talked about direct evidence. And direct evidence is something you know it when you see it. It's evidence you gather with one of your senses. You hear it, you feel it, you smell it, you touch it, and you come in here and tell witnesses, hey, this is what I heard, what I felt, what I smelled, what I touched. But do you remember when he was describing circumstantial evidence? There was a storm that day coming. Part of his theme, the storm just happened to come. And you could hear it coming. And then, during part of his opening, you remember it started raining? You could hear it. You could feel it. It's almost like circumstantial evidence morphed into direct evidence. And that's what happened in this case. Circumstantial evidence became direct evidence in many instances. This case is about two things. It's about being real, and choices. My mama gave me a book when I was a little boy about the Velveteen Rabbit. I was actually going off to college, dealing with people and learning about people and tough times in life. Go get the Velveteen Rabbit and read it if you haven't already. But she just put in the front of that book, and I love my mama, always be real. Always be real. And this case is about that defendant never being real. And choices, which I'll get to at my end. Ladies and gentlemen, they blame everybody but Alex. Everybody but Alex. Let's go back to the first. I'm not going to bring it out. But this back here, the press release was sent out. There's no danger. There's no danger. did Alex not do? They showed a tape there. He's asking the sheriff, I think, call Buster. First time he tried to call Buster, took the sheriff a while to get out there. You know when the first time he called Buster? It's about 40 minutes. Well, actually, he texted him, didn't even call him. Wasn't his first thought. Wasn't the thing after he did 911. It was later. Perhaps even when some of his friends had gotten there. Oh, don't call. No, right off the bat, if this happened, call my son. Call him. Buster, stay where you are. You with your girlfriend? Up there in North Charlotte? Go. We got some people after us. That's what's real. Don't you? You go to the police station right there. And what else do you do too? You don't talk about being real. What do you do? Y'all, I just left my mama. She's with Shelly. Get somebody over there. Get them over there. If these people are out here to kill us, get them over there. Go, please, take them right now. They're by themselves. I can't do that. That's where I took the guns. I can't tell them that. That's what's real. And he brings up the boat case right away. Right away. A year and a half previous. It's coming up for a hearing. Nobody's thinking about that boat case except Alice. And right then, he's using it to throw off. Here's your first suspect. Does that make any sense? They have a hearing coming up. They're going to look to resolve this thing. Nobody's out there thinking about a boat case on a Monday night. Anybody upset about that? Think about all the facts that would have to happen. They'd have to know both, as Mr. Waters said, somebody in the boat case would have to know that they're both there. They'd have to know they were there. They'd have to know that Alex just wasn't there. Oh, no, wait a minute. That he was there, but just for a little bit and went back up to the house. And they'd have to come. You know what? We don't need a gun. There'll be guns there for us to use. Yes, and that's great circumstantial and direct evidence. I'll get to that. They'll have guns there for us. They'll have guns there for us. We can use them. Does that make any sense whatsoever? Let's talk about murder. Murder is the intentional, malicious killing of another living, breathing human being with malice aforethought. What's malice? Y'all know what malice is? It's the name malice. It's the evil wickedness one person shows to another. You know how long it's got to exist? Just like that. At the pulling of a trigger. 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 Malice aforethought. It can be expressed. Rarely happens. I'm going to kill you. Or it can be inferred. It can be inferred with the use of one gun. There's no claim of self-defense here. They're claiming they weren't there. It can be inferred 2 guns. Malice aforethought. And we don't have premeditation in this state. We don't have to prove premeditation. We don't have to prove motive. I think it's been proven. His world was collapsing. Mr. Griffin goes, does that make sense? Did in his mind. His world's collapsing. His world's coming down. This was the only way he could save. It's the only way he could save Alex. But if that motive, well, I don't know, is that enough? Don't know. We don't have to prove motive. We're certainly there. That's one explanation. But if he's down there and he's angry, just don't sound like a real jovial there. Bubba! Don't let me forget about Bubba. Bubba! Come here. Maybe you just got angry. Maybe you got angry at Paul. Maybe you got angry, you started all this with the boat case. And maybe he just lost it. Maybe he just lost it. Maybe it looked like a suicide. And then Maggie came and he had to shoot her. I don't know. Only one person knows. And that's why we've got the motive. That's why we say he did it. But we don't even have to have motive. Just angry, he did it. Nobody else could have done it. Nobody else did do it. I'm going to get to that, and that's how we prove beyond, I want to say all doubt. But our burden's only reasonable doubt. But losing it, and then you get the question, well, have you proven malice? Well, yes, sir. Yes, ma'am. 2 shots to Paul. Malicious. First one didn't do it, the second one finishes him off. 5 shots to Maggie. Not an accident. 1 shot, 2 shots, 3 shots, 4 shots, maybe 5 shots, depending on whether this one's running through. That's malicious. So if you find he killed him and you get the malice, I don't think there's any dispute in there about that this is a malicious killing. But I've got to go over that with you. Malice of forethought. And then the burden on us in this case, as in every case that's tried in this wonderful land of ours, that's why this is so great, I agree with you, is beyond a reasonable doubt. I'm going to borrow one of these waters if that's okay. It's not beyond all doubt. If that's the case, this courtroom wouldn't have been here historically as long as it had. The law doesn't describe that, and listen to His Honor. And I'm not playing up to him, he is the best. He's the law. Listen to him when he reads the law. Beyond a reasonable doubt. It's not beyond all doubt. We can't do that. It's beyond a doubt that would make reasonable folks hesitate to act. I was trying to retrial a case years ago and reading reasonable doubt from this ex-solicitor, Solicitor Wilson, I'll give him credit, describing reasonable doubt, and he said, sometimes, questions are just questions. You can't answer every question, and the law doesn't require it. If after hearing all the evidence, or if you're firmly convinced of the defendant's guilt, you must find him guilty. If, on the other hand, you're not firmly convinced, then you must find him not guilty. He goes to see his mother. He goes, and you see the OnStar taking him up to the side, over near the smokehouse. We submit to you that's when he went to hide the guns. It's common sense. We submit to you that there's a driveway there, nice pavement. You can go look at it. Nice paved driveway. Submit to you when he came, it was 9:30 at night. Testimony is very unusual, very rare. Kind of funny, Miss Nixon, who testified earlier, we talked to her recently, didn't remember any of the conversation, but said she called and said he told him your dad's not doing well. Well, he didn't go over there that afternoon when he got the phone call, when his office is right near there. Go see him then. He didn't do that. He waited till 9:30. I don't know if anybody's got any folks that are suffering from Alzheimer's, but when they're asleep, they're tired. He wasn't going to love his mama. He wasn't going to be with her. He was going there because he loves Alex. He loves Alex. And he was going there to create his alibi. At 9:30 at night, use your common sense. And you remember, she said he called. What happened after that? Well, it was about 5 minutes or so. At first I was thinking, well, that's when he was going to hide the gun. And the time frame over there is so important, not for how long he was from left to come back, but it's how long he was in there with Shelley. How long he was in there. Because that's when he was hiding the guns. The guns are missing, y'all. He was hiding the guns. And what does Shelley say? He didn't stay long. 15, 20 minutes. He left. And later that week, later that week, and I don't know which one in my mind right now, I'm so tired. But one of the days she came by, I think it was after the visitation, and he says, Shelley, you remember I was here about 35 or 40 minutes. Y'all remember looking at her up there on the stand? And she got visibly upset. I said, what's wrong? Ask her, what's wrong? What's wrong there? Was he there 35, 40 minutes? No, sir. Why are you upset? It's a good family. You think she knew right then? He's coming back to say, hey, I was here 35, 40 minutes now visiting my mom. Shelley said, no. No, you weren't. So upset that she calls her brother, police officer in Yamasee. You think she knew right then? And that's real. That's real. Shelley's real. You saw her, but body language is so important, right? Body language was so important. We're talking about the defendant. All our body language. You see Shelley's. And then one day that week, never before, never, ever, 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 ever before, at 6:30 in the morning, doesn't call. He didn't need a timeline to create for that one visit. Didn't want a timeline. Didn't want a record of that. He comes to see Shelley. You ever been over that time before? No, sir. What was he carrying? It was some blue vinyl-like. Remember I tried to what? It's like this. What did you think it was? A tarp. I don't know what it was. And they try to gloss over it now. Tell you one thing they didn't gloss over. You remember when she was on the stand? I said, well, have you talked to them? Have you talked to their investigators? Well, yes, sir. Did they record you? Yes, sir. Can I have a copy of it? And then we came back and we got a copy. And two investigators, they were worried about it then, went down and talked to her. And talked to her about her times and ran times by her and asked her if she'd ever seen anybody in this blue coat. Have you ever worn it? They were worried about it. Because that's great circumstantial evidence. It kind of morphs into direct evidence. I saw him coming at 6:30. You even heard, they asked one of the experts, well, could it stay on there for 5 years, 10 years? Sure. This was days after the murder. Shelley sees him come in with a blue something. Well, where'd he go? He went upstairs. Why? I don't know. Did you see it later? Thought I saw it on the chair. Can't answer every question. Miss Mixon sure didn't see it the next day. Now I asked her, was there another tarp there? Well, there was a blue and silver tarp. Picture of it too. That wasn't it though. This was all blue. And the only other blue tarp that's in evidence, and I let it go in just so I could argue this right now, is the tarp that they showed Shelley that they got from Kmart. That's not real. This tarp, no. Looked like that. I don't know what it was. He had it bungled up. Well, lo and behold, when we find out this information, and they try to make a big deal about it, I think it makes it more pure. She's at a traffic stop or an accident or something. She tells the police officer, I forgot about this. You can't make it up. So they get a search warrant and they go search. And lo and behold, crumbling in the closet is a blue vinyl something where you pull it out and it's this jacket. You see how evidence of a fact and another fact that leads to the fact in question? I don't know why he put it in there. I don't know why he killed his wife and son. I don't have to say why. I think he did it to protect the one he loved the most. the one he really loved the most, so he could keep his lifestyle and not be embarrassed financially, and he wanted to keep going and loving Alex. I don't know why he kept that jacket. Maybe it was Solicitor Murdaugh's jacket. Certainly consistent. It might have been in that truck. I think one of the family said he kept a lot of stuff in that truck. Might have been out in that stump house. I don't know. But he brought it back in there and hid it. 6:30, days after the killing. And what's inside? Wait a minute. What's on the outside? Well, there's a little bit gunshot here and there. What's on the inside? The inside. Minimum 38 particles. It got so much that Megan Fletcher finally said, you know, we get, I can't remember the term right now, we get so many, I just stopped. I'd have been there for days. Gunshot residue. Inside the rain jacket, the blue tight garment that Shelley said, I saw him carrying something like that. He got rid of the guns, and he's hiding it there for some reason. Thank goodness he did. Because thank goodness for Shelley for bringing that in. That's what he disposed of the guns with. And he went out of town. She said he left, and before that, she thought he'd left, and he came back, and he had moved to ATV, and then he said he was in another truck, and he came back, then he left. He's disposing and hiding whatever he was doing with that evidence. Only one person knows. But that blue rain jacket, that tarp, is incredible circumstantial evidence that we ask you to consider when you go back there. Is Shelley making that up? How could she make that up? How could she know there'd be a blue tarp in that closet? Same closet, same stairs, he went upstairs. We went upstairs. I can't explain the tarp on the chair. Don't have to. We can't answer every question. That doesn't mean it's not reasonable doubt. She saw a blue tarp light. It was in that closet. It's got gunshot residue on it a few days after. Maggie and Paul were brutally murdered. And that's consistent with every reasonable hypothesis. And you know the thing he told Shelley? The night when they were talking. You're getting married, aren't you? You remember her saying that? You getting married? If you need any money or help with it, let me know. It's incredible timing. Oh, and your job, don't you work from school? You know, I've got friends down there. I can help you on that if you need. I was there 35, 40 minutes, wasn't I? Can you make up those sequence of facts that lead to the conclusion he's trying to get her to say, I was there longer. I wasn't outside longer. Blanca. Blanca loved Maggie. I didn't realize that really until I talked to her just a few times. I met her years ago at a federal prison. Remember when I saw her? Remember her name. But you know, even when Blanca was quit working for him for a while, and you remember she had health problems and said she saw Maggie on the road somewhere, and they kind of pulled off and just talked, just called up. Blanca cared about Maggie. Knew her so well, she knew what she wore to bed and what she didn't wear to bed. And that kind of bothered her about the clothes that were laid out. Some undergarments, which she knew she didn't wear. But Blanca's texting Maggie. Maggie's texting Blanca on June 7th. And in one of his statements, and I'm going to get to those, he said, you know, Maggie wanted to come. She wanted to come. Well, no, sir. No, she didn't. She was having worked on her other stuff. He tries to say in here today, look, she was in Charleston. She was going back to other stuff. Remember the text to Blanco, well, I left the workers there, but I guess it'll be okay. He had said, come, I want you to come. She didn't want to come. We also know that from her sister Mary, who had a little regret in here today. Didn't hear much regret from over there, but you know who regretted? Who was real? Was Mary. I encouraged her to go. She didn't want to go. They got in close. You know, it's like siblings. Jane, Marshall, James, I had to get my siblings on the record. We love each other. But she had that relationship, you know, we weren't close, but then we got closer as the kids got older and got younger. We were close, we talked. One of her best friends. And she told her, why don't you go on over there? She regretted that. But she killed her about it. But that refutes his lie. Oh, she wanted to come, she wanted to come. No, so you wanted her to come. Why? Had he already planned it out? Was his world collapsing? He didn't have to. We don't have to prove he did. But he got her there. She wasn't planning on being there. Blanca's got the food ready. She leaves. Let's stay on the real train for a minute. She goes home. She gets a call sometime that night. And this is real. What does she do when she hears? She drops the phone. Remember that? Her husband had to get on the phone. She dropped the phone, real emotion, because she cared about Maggie. That's real. And you remember she described that day when she left Alex leaving, and I put his shirt up, got his collar, helped him with his, I assume it was a blue jacket, I don't know. Described the shirt. Remember, just kind of tucked it in. And now on Alex's second interview, when he's confronted by David Owens. And they actually showed him the video of the tree. They showed him that. Did you change? When I saw you that night, you were wearing shorts. When did you change? And you remember what Alex said on that interview? When is that? When is that time was that? And then he told him the time, 7:44, whatever it was. He said, I guess I changed after that. Well, those are the clothes he was wearing when he murdered Maggie and Paul. Those are the clothes. And what does Blanca tell us? That was on August 11th. She said sometime mid-August. I didn't even know this. I got it. You can't make it up. Sometime mid-August, he comes to see her. Do you remember that shirt when I left that day? I said, no. I mean, yes. It's a Vinnie Vine shirt. You weren't wearing a Vinnie Vine shirt. I fixed your collar. He tries to get her to tell what he was wearing. He tried to say, no, you weren't wearing that shirt. That Columbia shirt, you've got one of those. But guess what? I ain't seen that one since. I have not. Blanca and Shelley. That's great circumstantial. Did you ever see that shirt again? Never saw that shirt again. Ever. Where's the shirt? You know what? I forgot about Shelley. I don't think this was mentioned. When Shelley sees Alex that night, you remember what she said about his clothes? Shorts, shirt. What she said about the shoes? Sperry type, cloth shoe. You remember that? When Dave Owens and those get there, and when I think I accidentally put some of the dust out on the, those aren't Sperry shoes. He's changed his shoes again. I'll get to you in a minute why that's important. From going to visit his mom, he's got Sperry type shoes. He comes back and puts on the tennis shoes. Why? Is she making that up? Blanca said, I've never seen the shoes before. When I got there the next morning, there was a t-shirt that looked like it had been pulled down, fell on the floor. Where does he keep it? She washes her clothes. Those are clean shorts up there. This is where he kept his shorts. Did he wear these shorts much? No, he didn't wear them much, but she knows that family. She knows where the shorts are, where the shoes are. Do you remember the Sperry shoes? Yeah. Did you see those? Never saw him again. Never saw that shirt again that he was wearing in the video. Never saw it again. And when he confronted her at the house about what he was wearing, she had real feelings and told y'all about that and told law enforcement about that. Is that real? And why is that important? Because it goes back to credibility and common sense. Those were clean clothes that Shelley had washed. That Blanca had washed. And when we get there on the scene that night, you remember Laura? Miss Rupp? She's sitting in the back. David's in the front. Alex in the front. His lawyer's on the side. And you know, it's something else I don't understand. Your wife and your son have just been killed, and you're worried about having a lawyer around? Everybody said, well, you know, just sled agents. We need to have a lawyer around. Really? My wife and son have just been butchered, and I'm worried about having a lawyer. But they did. And that threatening, overbearing, cheating, manipulating. You know when I asked old Dave, put his hand on his shoulder? So did Laura. What are you doing? I got a heart. Is that rushing to judgment? I got a heart. They didn't rush to judgment. They were saying, tell me what happened. Tell me what happened. Well, and he starts looking at his phone. You can check my phone, the alibis that he's created, that he's doing. And he says, I went and ran. I got on my knees over here. Went and ran, and I tried to take the pulse of Paul. I'd still be on the ground arguing myself. And I tried to turn him over. I tried to check his pulse. Really? I went to Maggie, checked her pulse. And you can't do that in the 20 seconds he's now trying to say you can. You can't. And they've tried to change that. And he never did it. Because what did she say? What did Miss Rutland say? He was clean. He was clean. He was clean. He was clean. He washed up. Yeah, and you hear the water running in the dog video. You hear it. He'd washed up. And this phone, tried to make a big deal about this phone that you do see right afterwards when we know he was down there. There's some movement on Maggie's phone. But every expert has said, just because if one phone's down here and the other one's walking, you're not going to have steps on that phone. He took Maggie's phone, the golf cart, however he got, drove back up to get those shorts and that shirt. And yes, you can get it and manipulate it and call to see if you made a call, put it down. That's not going to record steps on that phone because it's not moving. But that doesn't mean it wasn't with his phone. Don't fall for that. That's not real. Every expert said that. Every expert said that. And doesn't that make sense? You can grab it, see, make a call, put it down. You keep walking, it's not going to record if it's there. If it's in the car, it's in the Suburban, and I'm getting to that. So what happened? And this is why I asked Miss Rutland. And they're bringing in drug use. If he did as many pills as he said, he'd be dead. You can't take that many pills. That's your common sense. But why I ask her this, and I'm asking, I want to look at every one of y'all. Tell me what he was like in that car. You've got the video. Did he appear to understand you? Yes, sir. Were his answers timely? Yes, sir. Were they subject matter appropriate? Yes. Do you understand him? He can understand you. Look, he's thinking. He's opening the door. Was he in his right mind? Of course he was. And why is that so important? He says he didn't go down there. Is that enough? Yes. With everything else, that's enough. I never went down there. He's in his right mind. I never went down there, Dave. I never went down there, Lord. I never went down there after supper. I stayed up. I took a nap. He goes from taking a nap from 6-7, then the next time they met, 6-10. I took a nap. August 15th. You sure you're down there? are up there taking, yeah, I took a nap. I never went down there. Never, ever, ever. You think he would have taken the stand and said, you know, I was down there, y'all, if that video hadn't come out on that phone? Well, no. Now, under Mr. Waters' cross-examination, I lied. Why'd you lie? I wrote it down. I'm still not clear. I had paranoid thoughts. Usually I can take a deep breath and get through it. But I couldn't, so I just lied. Once I lied, I continued to lie. And he continued and continued and continued until 627 days later when he took the stand, the first time he'd ever told anybody. Anybody. He told his family, he told his friends, he told everybody, and they believed him. I wasn't down there. And why is that so critical? That's the time of death. That's when it happened. That's what the records show. That's when the conversation, yes, it is important. Paul, who uses his phone all the time, Paul is in a conversation about the dogs, interacting. Well, send me the picture. He does. And then it stops. Yes, that's what it happened. And then Maggie's phone. A little bit text. She reads that text. I think she went to her car. Y'all decide. Nobody knows. One person knows. She goes to her car. And she's got some rings there she's putting back on. I think she's got 2 rings there, and she's putting on another in the car. Maybe they've been working in the kennels. There's one shooter. There's only one shooter. And she hears that shot, and she comes back around. She hears the shot. She reads the last text y'all have in there. I think she opens the thing about Solicitor Murdaugh. He doesn't. And then you don't see anything else. You don't see anything else on the phone. So is that common sense? Yeah, that's when they were gone. Yes. Yes. When they interact so much. Yes. That's common sense. And that's why it's so important. You want to help law enforcement? You're in law enforcement? I was down there. Y'all know what? I was down there. I didn't take that nap as long as I did. Did you hear anything? Why would you not give that information? Okay, then the 10th, with his lawyer, Mr. Griffin, in the car. Did you go down there? No. Look at him. Is he coherent? Is he under the influence of anything? Is he withdrawing? No. I want to help you. I want to help you. And then on the 15th, here's this video. Here's you in the tree. Now, Rogan says he thought he heard you down there earlier. Well, I don't think so. Why not say it then? Think about it. Well, it's just Rogan's word. Does that make any sense? Just Rogan's word. No, sir, I can handle that. He made a mistake, like Shelley did. Like Mark couldn't close. No, sir. I can handle that, though. But when the video comes out, he's stuck. He's stuck. I'm going to try to wrap up. Yeah. Yesterday morning at 2:53 in the morning, I don't sleep much during trials, but I kind of woke up. And what he did when he took the stand was corroborated that he's a liar. He corroborated the fact he doesn't tell the truth. The one thing that was more important than anything. And you know, they're putting these law enforcement on trial, talking about blood evidence, talking about other things that were presented to the grand jury, which that blood evidence was investigated, and the state didn't offer it. That's what you do in your prosecution. Didn't try to offer it. Now they're trying to put us on trial for doing our job. Think about that. Blame everybody else. Look, they looked into this, and it didn't turn out to be. So now we're going to blame them. We didn't try to present it. Isn't that ironic? They're now jamming us for doing our job. Jamming us for doing our job. All the evidence of the guns, and I'm going to get that in a minute. The timeline, the incredible timeline, his lies, all of that, the gunshot residue, all of that's presented. And do we make mistakes? Yes. And that happens in life. But you don't lie and misremember being at the scene of a murder when you said you weren't even there or being at the scene where your family was brutally murdered. You don't lie about that. That's not a mistake. That's not a mistake. This is the state of South Carolina versus Richard Alexander Murdaugh, not the state versus David Owens, not versus Sled. And I want to tell you something. Sled, Walterboro, Laura Rutland's working with David Owens. Sled starts working with the FBI. They're working together. This is, think about it. Rush to judgment. They gave that man every benefit of the doubt. Oh, what are y'all doing? How's it going? You remember that third interview when he was, David Owens said, well, and I submit to you, they're taking those interviews where he's trying to come find out what they've got on him. Well, how's this thing looking? How's this thing looking? Well, we've got some shell casings by Maggie's body out over there where y'all shot in the range, and some shots out there by the side of the house. The shell casings, they all were made from the same gun, all cylindered in the same gun. You think if that didn't, they could find an expert to refute that, they would have? And Alex goes, oh really? So the gun was there? Yeah. You see his reaction? They all came from the same gun on Maggie. Now the other one, Mr. Griffin tried to argue, Paul Greer, yeah, it could have come from that shotgun. Don't know. Is that credible evidence? But it could have. Not saying it did or didn't, but it certainly could have. He's got that gun. It's got Maggie's blood on it. Don't know if he used that or not. But I know the assault rifle's missing. And Will Loving comes from a fine family in Columbia, I can tell you that. Says we were down here not in March, it was more like May or April or May. We were shooting his gun on the side of the house and those shell casings. That's where they found them. And lo and behold, the shell casings match the shell casings around Maggie. They were all cylinder in the same gun. They came out of the same gun. They've been in the same gun. Yes, Mr. Waters is right. That's a family-owned gun. And is that incredible, circumstantial, and direct evidence? Yes, ma'am. Yes, sir, it is. That's powerful. You can feel it like the rain. The murderers come in. There'll be a gun there. We'll just use their gun. Does that make any sense? Y'all too young. You ever watch Columbo? When I first looked at this case, this is an episode of Columbo, except this is real. And you get to see one of my heroes, the detective, didn't always look that good, wasn't all that, but you got to see the crime, and then you got to see him figure it out, and the mistakes they made, and that's what happened here. He killed him. He thought he could get a timeline, but it got him. Within 20 seconds, he's texting Maggie on that phone when he's passing the location of her phone. Is it common sense? He threw that phone out, called her, and threw it, and the orientation didn't go on. They said, if you pick it up, yes. Yeah, we had somebody come in here, you throw it rough, and it doesn't come on. And what are the chances it's anything else? He'd almost had to bump into him. And you take this new story, I was down there till 8:50, whatever, go up and take a quick nap, come back, he didn't hear the shots, just happens to come back. It's common sense, don't leave it with you, take it back there with you. I'm down there now, my wife told me this. I'm down there under this new story, and the deal was to come talk, go see my mama at 9:30. And you're right down there, you've just seen them now. Well, you said before we hadn't even seen them, don't forget that. And you go up to the house, why don't you say, hey, Max, I'm gonna go see Mom real quick. It's just a few minutes later. No, you go up there, you take a quick nap, you know what, I'm gonna try to call them, let them know I'm going down. Does that make any sense? And then when you get to the Y, you'll see the light. When y'all went out there yesterday, those trees are much lower. Go back in and look at the way it was. And I think even Buster said when you get down there, if the light's on, you can see. Why don't you just go right over there? Hey, I ain't going down there. No, doesn't hear anything, doesn't do anything. He just takes off. Does that make any sense? We've proved that nobody else could have done it. With that timeline Does it matter when he's rushing back? Yeah. I doubt he's ever killed 2 people before. So he's not thinking, he's frantic. Puts the wrong 2 shells in the gun. Coming back, he's got Maggie's phone. It had been sitting there, that's why the steps weren't on there. He's moving. He gets it. I can't take this phone with me. He's a lawyer, so he tosses it out. That's the only thing that makes sense. And what did he say about Paul's phone when he went up there? You know, I started to get, I didn't know I got it out, and then it kind of just popped out too. Does that make any sense? You got to evaluate everything. If you can't believe somebody's credible on one thing, how can you believe them on the ultimate issue when they said they didn't? When the only thing they corroborated for you throughout the investigation, throughout this trial, and throughout Mr. Waters' cross-examination is he's a liar. And that's all you can judge people on. The 3 witnesses that were beautiful, that were uncontroverted. And one was Paul. He didn't testify to you up on the stand, but he testified to Dr. Raymer, and he testified to his phone. And here's so beautiful of evidence. It's so pure. He didn't know he took that video. That's why he said he wasn't down there. And this is beyond all doubt. We respectfully submit. Paul knew. Dad, I got some insurance. I got some insurance. Not the kind of insurance you've made money off of. An insurance some clients you gave back and some you didn't. I've got some insurance on you. I don't know why you killed me. I made some mistakes. You heard a lot of good things about Paul too. I know I put your life, open your life, your fake life with this boat case. Your finances are coming out. I know that. But if you go lie and say you weren't down here, I got you. I don't know when it'll come out. Maybe you'll go ahead and lie. But this is going to come out. Paul had that insurance on him. And maybe that's why he was worried about that phone. And you can't make that up. Because you remember when I asked David Owens, does anybody else in the world know that that video was out there except Paul? No, sir. And that's incredible evidence. And it did sit there until law enforcement working together, the states, the local, SLED, everybody, got it out. And that's great law enforcement. Thank you. Yes, and that's when the case changed, along with all the other evidence. Maggie testified to you. He shot me here. He shot me here. And look at all the shell casings around me. Y'all look at them. They're the same ones that Will Loving shot with Paul. They're the same ones that have been shot down there. Yeah. They came out of the same gun. That's great directing circumstance. And finally, and my daughter-in-law, Sally, and my Aunt Cissy still calls my dad Jack this. My daughter-in-law been married about 3 months, one of the happiest days of my life, because they were happy. They were watching that kennel video. She and her dog Tater. And when Bubba started to bark, that's what my aunt calls him, Dad, Bubba. Tater barked. And Sally said, isn't it something that your best witness in here are the dogs? You know, some people say they got a sixth sense. You think Bubba knew? You think Bubba knew something? He got Alex to say something. Bubba! Thank God for Bubba. DNA, and that DNA, when people live together, you'll have it all over your shirt. That's not it. But DNA, in this case, that dog negates all. Thank you, Bubba. And guess where Bubba is now? Bubba's with Blanca. Bubba's with Blanca. You can't make that up. And that puts him down there. And that's the lie he told and told and told. I went down there. Why aren't y'all doing something, law enforcement? Why aren't you telling us you were down there? Why aren't you telling us you were down there? Thank you. If he tried to respond to the phone, as Mr. Griffin said, it would show that he was going to Malamita. He had to get rid of that phone. He had to get rid of it there. Finally, it's a book, Your Greatest Power. My dad gave it to me when I was young. He said, read it. Your greatest power. You know what it is? Your greatest power is your power to choose. Choice. We've all got it. We're born with it. We use it every day. We use it when we treat people, whether we say hey, whether we're nice, whether we forgive people. We make good decisions. We make bad decisions. But what my dad always told me, don't blame anybody else. If you make a good choice, that's good. Don't get too cocky. Be humble, but that's good. But if you make a bad choice, you're responsible for it. There are consequences. It's your greatest power. And for whatever was going on in his mind, his world's collapsing. It's coming down. All these world is coming down financially. He's confronted that day by somebody's law firm. Where's this check? He's got another hearing coming up. It's a motive. Don't have to have it. But yeah, it's there. And is this rational? When he said that, is that rational? Was it rational to be on the side of the road and claim you're shot? And when you're in the ambulance, and go watch this if you need to, and you're talking to the officer in the ambulance, and you say, what happened? Oh, by the way, he wanted to kill himself. He called 911. He called 911. When he told the officer in the ambulance, well, what happened? Well, some guy shot me. He even did a sketch. He faked the sketch. But what did he tell the guy in the ambulance? It sounded like a shot. He's trying his world, and he says there in that last interview with the call-in interview, Mr. Harpootney and Mr. Griffin, what you got in there. Ryan, I'm sorry, I lied about everything. I was under a lot of pressure. Had a lot going on. Really? Your wife and your son were murdered 3 months ago, and now this is the real Alex. Well, my world's coming down. My world, Alex's world is coming down. Been confronted by his law partners. Losing his job. Now it's me. My world's being affected. Not about that, but now. And I'm sorry I lied. I've lied about everything. Richard Alexander Murdaugh loved, I think he loved Maggie. I think he loved Paul. But you know who he loved more than that? You know who he loved more than that? And who he's going to make sure that life, wanted to make sure that life, he loved Alex. And he exercised his greatest power of choice to make sure that life continued, or try. And it couldn't. And now, ladies and gentlemen, after his honor charges you, you're going to go back there and exercise your greatest power. Based on the evidence you've heard, the evidence you haven't heard, the credibility, the believability of the witnesses, and especially of Richard Alexander Murdaugh, who has lied and lied and lied and lied, and it's been okay. He got you through. It stops here. We respectfully request it stops here today. No, it's not okay. And we're going to exercise our greatest power and find you guilty of killing Maggie and Paul. Thank you.
Ladies and gentlemen, you've now heard the evidence and you have heard the closing arguments. Next up will be jury charge and then your deliberations. We're at lunchtime. We're going to take a break for 1 hour and 15 minutes for lunch, and you'll come back. I'll charge you on the law, then you will deliberate. Please do not discuss the case.
John Metters with the State Attorney General's office saying he's a liar. And that's what you judge people on when he's talking about Alec Murdaugh, saying he killed him, thought he could create a timeline, but it got him. Andrea Mock is outside the courthouse now with more on these closing statements from the prosecution. Andrea.
seated.
Yeah, JR, I have to say I thought that was a pretty powerful rebuttal from John Meadors there, talking about going through the timeline again. And just like you said, his major point was Alec is a liar. And he said to the jury, if you believe anything he says, you got to use your common sense, because he has been caught in lies over and over again. I thought it was really powerful when he decided to talk about Shelley Mixon's testimony. Of course, that is the woman that was in charge of taking care of Miss Libby, Alec's mom. And he said, use your common sense. He said, the woman has Alzheimer's. Alzheimer's patients get tired at night. And he went to visit her at 9:30 at night. He said, use your common sense. Then he said that Shelley testified she was very uncomfortable at the fact that a couple days after the murder, Alec said to her, I was there for 45 minutes, right? She also says that he came over very early in the morning, 6:30 in the morning one day, with what has been described as a blue tarp. We now know the inside of the blue tarp had so much GSR on it, it couldn't even be counted. John Meadors mincing no words, saying he carried the gun in that blue raincoat, took it upstairs at 6:30 and hung it up in the closet in the morning. And then he went on to say that Shelley Mixon was so uncomfortable by that, she called her brother, who is a police officer in Yemassee, and said, this made me very uncomfortable. So yeah, very powerful words from John Meadors, closing, saying that Paul testified in his Snapchat video, and again stressing the fact, he said, if my wife and son were killed, I would have done anything to help them find the killer. And what did Alec Murdaugh do? He lied. He lied to investigators, and he even lied on the 911 tape. Now, we are listening right now as the jury is being charged. Make sure you keep it here to News 19. We are going to be cutting in live throughout the day, but for now, I'm going to send it back to you, JR.
All right, and of course, for more on this, simply go to our website, WLTX.com. Live team coverage throughout the day and night right here. Stay with us.
It's Thursday, March 2nd, and the talk is live. Everyone's counting.
All right, we are back with more coverage for you. I am live in Walterboro right now. I'm Andrea Mock. They just decided to break for lunch. Judge Clifton Newman saying that he will charge the jury when they get back. Good afternoon. You are watching WLTX live coverage of the Murdaugh trial. I'm Andrea Mock, live in Walterboro, right outside the Colleton County Courthouse, where Judge Clifton Newman told the jury, break for lunch. I'm going to charge the jury after lunch, and then it will be in their hands. But what a morning it has been. We finally got to hear the defense, Jim Griffin, go up and give his plea to the jury about why his client, Alec Murdaugh, shouldn't be convicted. Basically, I would say his whole speech revolved around two things. One, he says it doesn't make sense for a loving father to kill his own wife and his son. And two, he believes Maggie's phone is key evidence. Now, you may or may not know this or have followed it, but Maggie's phone actually got erased. They weren't able to pull any data from the phone as far as steps and tracking any later than June 9th. And of course, the murders happened on June 7th, so that wasn't very helpful. Jim Griffin saying if they had that phone, it would be key. Let's listen to what he had to say.
Their theory is he slaughters Maggie and Paul to buy time from her investigation. That is it. That is their theory. That is their theory. And it's totally fabricated. They've got no evidence of that. There's no evidence that Maggie was on to his financial misdeeds. There's no evidence that she was about to blow the whistle on him. There's no evidence that that he had a $20 million life insurance policy on her, and that if he murdered her, that he could get out of financial bond. None of that. None of that.
All right, yesterday, Creighton Waters gave his closing arguments, going through detail by detail about the timeline of the night of June 7th. And one of the things he asked the jury, he said, hey, use your common sense. Does this make sense? He said the timeline shows that Alec's car, his Chevy, pulled up and stopped. And 19 seconds later, after discovering his wife and his son shot dead, 19 seconds later, he called 911. He said, is that enough time to even process that? Listen to this. All right, it looks like we're having some trouble getting that sought, but basically Creighton Waters saying that if a father had stumbled upon his wife and his son and he would check them, he would make sure they were okay. He might try CPR, he might check their pulses, but he said 19 seconds. He said, why did it only take him 19 seconds to assess the health of both Maggie and Paul and then call 911? He argued it was because he knew exactly what type of scene he was pulling up to, because he was responsible for killing them. Again, they are on lunch break now. They will be coming back in about an hour from now to charge the jury officially, and you can keep it here to News 19. We're going to have live coverage throughout the day. taking his chance to talk to the jury one-on-one. I want to tell you, just because I'm not sure you could tell from the video, but I was in the courtroom and Jim basically put his podium right in front of the jury and looked them in the eye. He was standing very close to the jury as he was delivering most of his closing arguments, and he says, it's funny, both sides say use common sense. He says common sense says a loving father doesn't kill his wife and son. Meanwhile, John Medard, Creighton Waters, they say the opposite. They say the facts are stacked way too strongly against Alec Murdaugh for you to use common sense and to realize that he did this. Now, Jim Griffin spent much of his time today. He was talking for hours. He spent a lot of time today talking about mistakes that SLED made. And he said that they didn't preserve the tire tracks. He says there was a bloody footprint in the feed room that they never tested, and maybe that bloody footprint would have told them who the murderer is. Jim Griffin also went and wanted to ask why there was never DNA samples taken. That's a fact I'm not sure many people knew until today, that Maggie and Paul's clothing was never tested for DNA. But what was tested for DNA, Alec Murdaugh, and he says he felt that they had decided from the get-go that Alec Murdaugh was guilty. Let's listen to a little bit of what he had to say.
What doesn't strike us as fair is that the next morning, on June the 8th, after the gruesome murders of Maggie and Paul, this is what is issued, a joint press release, Colleton County and SLED, that says, at this time, there's no danger to the public. At this time, there's no danger to the public. You have 2 people who have been executed within, y'all are out there, I don't know, is it 100 yards, 200 yards from Moselle?
All right, we're going to go back inside the courtroom now because you can see the judge has returned from his lunch break. He is set to charge the jury at any moment. We're going to listen in live here and find out what is going on. I believe the jury is actually being led into the room, I'm being told now. So the jury is actually being led back inside at the moment. But again, as we mentioned, this trial started in January. It has had several weeks of testimony from a number of witnesses from both sides out there. And once the jury gets the case, they can begin deliberating the guilt or innocence, they believe, of Alec Murdaugh. And there's a look at the defense table now. Dick Harpootlian addressing the judge at the moment, making a few remarks. You see the defendant there in the center. Alec Murdaugh, as we await the jury to be seated so we can begin these proceedings. And then, Andrea, I know you're probably still listening outside as we wait for the jury to come back in here. But again, the prosecution hammering home here, common sense to the jury.
Yeah, one thing that was really powerful, JR, when John Meadors rapped, he said, you know what, I do believe that Alec loved Maggie and Paul, but I believe he loved...
Received the evidence and heard the arguments of the state and the defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina, you are the finders of the facts in this case. I do not have the right to pass upon the facts or to even express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, and the weight of the evidence presented during this trial. As a trial judge, it is my responsibility to preside over the trial of the case, and I have the duty to rule upon or pass upon the admissibility of the evidence offered during the trial. You are to consider only the testimony which has been presented from this witness stand, along with other exhibits and evidence presented during the trial. Any other evidence or exhibits which have been made a part of the record you may consider along with any stipulations made by counsel. I have the additional duty to charge you the law applicable to this case. And as the presiding judge, I am the sole judge of the law. It is your duty as jurors to accept and apply the law as I now state it to you, then to deliberate in an effort to reach your verdict. And finally, I charge you in this regard that you should not be concerned with what you think the law ought to be, but what I charge you that the law is. You are also the judges, the sole judges of the credibility, that is, the believability of the witnesses who have testified and of the evidence offered. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony was contradicted on the one hand or supported and corroborated on the other hand. You may believe a small portion of a witness's testimony and disregard the larger, or vice versa. All these things you will consider, bearing in mind that you should give the defendant the benefit of any reasonable doubt. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by direct evidence or circumstantial evidence. The law makes no distinction between the weight or value to be given either direct evidence or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. An expert witness is a witness who, by education and experience, has become expert in some art, science, profession, or calling, and may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may then disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness, simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it is not contradicted. In regard to evidence of other crimes and evidence of alleged bad acts on other occasions, this evidence is limited to consideration by you as it relates to the motive of the defendant for the offenses charged in this case. This evidence cannot be used for any other purpose. This type of evidence must not be considered in any other fashion. In particular, the South Carolina Rules of Evidence provide that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewith. Put another way, evidence of other crimes or bad acts cannot be used to show that the defendant is a bad person and therefore is more likely to have committed the crime for which he is accused. You may not consider evidence of other crimes and bad acts for this purpose or for any other purpose other than it as it relates to the motive of the defendant. In addition, while you may have heard that other crimes and bad acts of the defendant have resulted in other charges or indictments not before you, the fact that the defendant was arrested, charged, and indicted in these matters is not evidence and cannot be considered by you as evidence of guilt in this case, nor do these indictments create any presumption of guilt. As to any other pending charges, as is the case here, the defendant is presumed innocent until proven guilty beyond a reasonable doubt by the state in a court of law. The function of the jury is to determine whether a defendant is guilty or not guilty, and the consequences of a conviction in this or other pending matters is of no aid in determining whether the defendant committed the offense. You should not consider nor speculate about sentencing consequences for this or any other crimes, as those issues are not before you. The fact that the defendant was arrested, charged, and indicted in this case is not evidence and cannot be considered by you as evidence of guilt. Nor does it create any presumption or inference of guilt. The indictments are simply the formal written instruments which contain the charges made against the defendant. The indictments are the formal documents by which this case is brought into this court. The defendant, Richard Alexander Murdaugh, has pled not guilty to the indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It's not just a legal phrase. It is a substantial right to which every defendant is entitled, unless you, the jury, are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt. The state must prove the defendant guilty beyond a reasonable doubt. So what is a reasonable doubt in the law? A reasonable doubt is a doubt which makes an honest, reasonable, sincere, and conscientious juror hesitate to act. Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. Proof beyond the reasonable doubt can also be described as proof that leaves you firmly convinced of the guilt of the defendant. Now, there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of a crime charged, you must then find him guilty. If, on the other hand, you think there's a real possibility that he is not guilty, you must then give him the benefit of the doubt and find him not guilty. The indictments in this case allege 4 separate offenses against the defendant. The indictments are murder of Maggie Murdaugh, murder of Paul Murdaugh, possession of a weapon during the commission of a violent crime involving the murder of Maggie Murdaugh, and possession of a weapon during the commission of a violent crime involving the murder of Paul Murdaugh. Each indictment charges a separate and distinct offense. You must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant, Richard Alexander Murdaugh, is charged with the murder of Margaret Murdaugh and Paul Murdaugh. The state must prove beyond a reasonable doubt that the defendant killed Margaret Murdaugh and Paul Murdaugh with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under the circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person, or any other acts of preparation going to show that the deed was within the mind of the defendant would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. The defendant is also charged with possession of a weapon during the commission of a violent crime. 2 counts. The state must prove beyond a reasonable doubt that the defendant was in possession of a firearm during the commission of a violent crime. A firearm means any weapon which is designed to or may readily be converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. While the arguments of counsel are a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting their arguments, counsel often have referred to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely on your own understanding of the evidence. You must decide whether the state has met its burden of proof beyond a reasonable doubt based solely on the evidence presented in this courtroom. As you were instructed at the start of the trial, you're not permitted to conduct any independent research about this case. The facts of the case, the evidence presented in the case, or the people or organizations involved in any way in the case. Do not try to find any information from any source outside the courtroom, however reliable that source may seem to be. Do not look at dictionaries or other reference materials. Search the internet, websites, or blogs, or use any other electronic tools to get information about this case or help you make a decision. You may not use computers, telephones, cell phones, smartphones, tablets, the internet, or other tools of technology with communication capabilities at any time during your deliberations, except only as provided by the court to review the digital evidence in this case. If your deliberations necessitate an overnight break, you may use these devices as necessary, but you may not use them to communicate with anyone about the case until the case is over. This means that you must not use phone calls, video calls, emails, text messages, instant messages, blogs, chat rooms, websites, or any social media, such as Facebook, Twitter, LinkedIn, YouTube, Reddit, and Discord, to send or receive any information about this case. This includes information about a party, a witness, an attorney, a court officer, or your fellow jurors. News accounts about the case, research on any topic raised, or even any topics you may think would be helpful in deciding the case, or any testimony presented by any witness you may not investigate. During your deliberations, do not read, listen to, or watch any news reports about this case. This includes anything that may be in the newspapers or on the internet, radio, or television. You must not consider anything you may have read or heard about the case outside of the courtroom, whether before or during the trial. Information on television, radio, internet, or from other sources may be wrong or incomplete. In our judicial system, it is important that you are not influenced by anything or anyone outside of this courtroom. If your deliberations necessitate an overnight break, even though you may use electronic devices as necessary for purposes unrelated to this trial, I must urge you to minimize your use of such devices. Many internet browsers, smartphone apps, and social media services, as well as traditional media like television and radio, will provide information and news that you do not seek, with little or no prompting. It is a strong possibility that information about this case may be thrust upon you every time you use an electronic device. You must therefore use these devices only as absolutely necessary. You must ignore and avoid uninvited information about this case. Now, Madam Forelady and members of the jury, I am required to charge you the law as I have done through these instructions now I'm being given, to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I have instructed you on various subjects must not be considered as indicating an opinion of this court as to what you should find to be the facts or what your verdict should be. In conclusion, now you've been chosen and sworn to give the parties a fair and impartial trial. When you have done so, you will have completed your oath, and no one will have a right to criticize your verdict. You must not be swayed or influenced by opinions or expressions of opinion you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement. Each of you must decide this case for yourself, but only after impartial consideration of all of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. Now, you may have noticed that I have read these instructions. I do so to give you the law as accurately as possible. I will give you a copy of these instructions to have in the jury room. You may refer to these instructions to assist you in your deliberations. You must consider the instructions as a whole and not follow some and ignore others. And Madam Forelady, it will be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with the court, please reduce your message or question to writing, signed by your foreperson and the foreperson only. Do not address any questions to anyone other than the court, and reduce it to writing and pass it to the bailiff, signed by the foreperson and the foreperson only. It will then be brought to my attention. I will then respond as promptly as possible, either in writing or by having you return to the courtroom. I caution you, however, with regard to any message or question you might send, that you should never state your or specify your numerical division at the time. Now, you've heard the testimony and you have heard the law. Whatever your verdict, Madam Forelady, you will indicate the verdict on the back of each indictment and then sign and date your verdict. You will have these 4 indictments, and on the back of each indictment is a place for verdict. And each one, as to each one, you write your verdict, either not guilty or guilty, then sign and date the verdict. You're not authorized to write the verdict until all of you have agreed on the verdict. Now, in just a minute, I will send you to the jury room. But prior to doing so, I want to ensure that from the 12 jurors we have remaining, if there is any reason that any one of you cannot continue deliberating, please let me know at this time. We have 13 jurors. Only 12 can deliberate. So out of the first 12 jurors now on the panel, if there are any reasons why you cannot continue, please let me know at this time before I excuse the alternate. A show of hands as to anyone who cannot continue deliberating. All jurors then seem to be in good shape and good to go. So when the jury leaves the courtroom, the alternate will remain. And the alternate is. I will send you to the jury room, all of you, except for the alternate, but do not begin deliberations until you have received a copy of this jury charge, the indictments, and the exhibits. Once you receive these things, that will be your signal to begin your deliberations. Once you begin deliberations, you will deliberate until you have reached a verdict, at which time you will knock on the door, advise the bailiff, and we will bring you out to receive your verdict. So if all of you will now go to the jury room except for the alternate juror number 741, who will remain with us while the others go to the jury room. Stated for the record, whatever it is.
About excusing the alternate or not.
All right, what about it?
We've been going for 6 weeks, and if we, could perhaps hold the alternate in the case there's a problem with the 12, and we have to insert the alternate during the deliberations.
Yes. The state concurs with that, Your Honor.
Of course, the statute says alternate must be excused once the jury begins deliberating. And that's always a risk that is taken. So with the consent of the parties, if that's what the parties want, Mr. Murdaugh.
Yes, sir.
Do you want me to hold the alternate in the event something happens to any other juror?
Yes, sir.
All right, very good. So, Madam, you will not be dismissed. You will remain as a member of the panel while the jurors are deliberating, but will need to be taken someplace separately from the panel to ensure that you do not talk with anyone or communicate with anyone, and we'll figure all that out in a few minutes. But aside from that, if you all will review the exhibits with the court reporter and the bailiff, you can take the charge and the indictments in, and the jury may begin deliberating.
Your Honor, for the record, we have no additions or exceptions to your charge.
Okay, thank you for reminding me on that. Any additions or exceptions to the charge?
Voluntary intoxication, Your Honor.
Yeah, voluntary intoxication was not charged. It was not raised. I cited with the fact that it was not raised as a defense and would not be appropriate to charge.
Yes, sir, Your Honor.
Okay. Why is everyone standing? Click on it. So, let's see, is there a separate room the alternate can go to for the time being? For the time being. That's for the time being. Down there. 741, if you will follow court officer to a place. Yes, sir.
Your Honor, may I approach with Mr. Waters of something that's come up that I think I need to bring to your attention?
All right, you have been listening to the charging of the jury there. Judge Clifton Newman charging the jury for about 32 minutes, and something that rarely happens. The alternate juror was expected to be dismissed because basically that's what happens when the jury starts deliberating. The alternate jury member or members are dismissed, but because both parties and the defendant said they did not want that alternate juror to leave, that alternate juror will stay, at least for the time being, as you heard the judge. I want to bring in our Andrea Mock now. Something that the judge said in his charging to the jury: other crimes and bad acts cannot be considered when determining the guilt or innocence here of the defendant, but the motive that the state is alleging here has everything to do with the alleged financial crimes. Andrea saying that he was trying to buy time. This morning, John Meadors said that his world was collapsing. This was the only way he could save Alec, was to commit these crimes, as he bought more time for the financial trouble that he was in.
Right, and I think, you know, we have all known Judge Clifton Newman for a very long time. He chooses his words carefully, and that's what he did when he was giving the jury direction. He said that evidence of other crimes and bad acts may not make him guilty, but only can be used to show motive. And that is why Creighton Waters and the prosecution argued to keep those financial crimes in, because, again, it showed motive. Now, let's go back a little bit to what you just said about his world collapsing. And I want to go back to John Meadors, because that was the last voice. If you think about it, that is the last voice that the jury will hear before they went to their deliberation, was the voice of John Meadors. And he talked again, reiterated what Creighton Waters said yesterday about his world collapsing on June 7th. Of course, there was the boat crash. He was facing both civil lawsuits, and Paul was facing a criminal lawsuit. We had Jeannie Seckinger at PMPD asking him where that Ferris fee was, asking him about missing money on June 7th. Also on June 7th, of course, he gets the terrible news that his father is dying. So let's hear a little bit about what John Meadors had to say.
Whatever was going on in his mind, his world's collapsing. It's coming down. All these world is coming down financially. He's confronted that day by somebody's law firm. Where's this check? He's got another hearing coming up. It's a motive. Don't have to have it. But yeah, it's there. And is this rational? When he said that, is that rational? Was it rational to be on the side of the road and claim you're shot? And when you're in the ambulance, and go watch this if you need to, and you're talking to the officer in the ambulance, and you say, what happened? Oh, by the way, he wanted to kill himself. He called 911. He called 911. When he told the officer in the ambulance, well, what happened? Well, some guy shot me. He even did a sketch. He faked the sketch. But what did he tell the guy in the ambulance? It sounded like a shot.
All right, there you heard him giving a very convincing argument this morning about explaining to the jurors about how Alec's world was collapsing on June 7th and what the motive was. You know, interesting, Judge Clifton Newman, in charging the jury, also said, talking about direct evidence and circumstantial evidence, he said crimes may be proven by both. Something for the jury to think about, because a lot of this case is circumstantial evidence. But let's talk a little bit and move to talking about that lie. Today when Jim Griffin was talking, he said, now we have to talk about the lie. He said it all comes down to the lie. Yesterday, Creighton Waters, and again, Jim Griffin today, saying if he was really a grieving father who wanted to do everything to find out who killed his wife and son, why would he lie? Why wouldn't you say the last time you saw your loved ones? And in this case, here's what Jim Griffin had to say today to the jury about why he told that huge lie.
And why did he lie? And that is certainly a fair question. And that's, and frankly, I probably wouldn't be sitting over there right now if he had not lied. But he did lie, and he told you he lied. And he told you why he lied. He said he lied because, I'll tell you, he lied because that's what addicts do. Addicts lie. He lied because he had a closet full of skeletons, that he didn't want any more scrutiny on him.
Well, you just heard them talking about that big lie. And honestly, if I'm being honest about listening to the last 28 days of testimony, it is going to come down to that lie. And if juries believe that Alec told that lie because he had a guilty conscience. Now remember, despite what Jim Griffin said in court today, that Alec lied because he was an addict, and perhaps they're saying that he was paranoid, had paranoid thoughts about SLED. If you listen to the 911 call, and Creighton Waters played it again yesterday in the courtroom, Alec lied immediately on the 911 call, and jurors got to hear that again yesterday. If you remember, on that 911 call that we have now all heard many times, they said, when was the last time you saw your family? And Alex said, well, I took a nap for about a half hour, and then I went to my mom's house for about an hour and a half. So he immediately, without SLED present, was already lying to the 911 operator. Like I said, they played that back in court. They wanted to make it very clear that that excuse that he was paranoid about SLED or paranoid because he had pills in his pocket, well, was he paranoid when he was making the 911 call? Was he thinking about the pills in his pocket when he was making that 911 call? I don't know. But again, they played that in court. I guess you're looking at a live picture in court. We're seeing people starting to stream out. You know, the jury is charged. It is only a matter of time. You know, some people I talk to in the community, JR, say they already have a decision made. I've listened to every single day of the testimony. I feel strongly with the evidence. But it is only time to tell whether this jury will come back and bring a very quick verdict or whether it will take some time to go over the pages and pages and pages of documents. What is your prediction?
I am not in the business of making predictions when it comes to juries, Andrea. I will only say that I've seen them come back quickly before. I've seen it take days on end before. We'll just have to wait and see. As we were looking live at the defendant there, Alec Murdaugh, being let out of the courtroom, the jury is now deliberating the case. We don't know exactly how long the deliberations will take. Court is in recess until the jury either comes back with a verdict or perhaps the jury has a question that they need answered. And in the day and age that we are living in, you perhaps heard the judge inform the jury, limit their use of electronic devices. Try to stay off the iPhones, don't go on the internets, because without prompting, news of this trial could come up. As you know, we have team coverage throughout the day and the evening in Walterboro. We'll be back with more on Friends at 5. In the meantime, if you'd like more information about this trial, as always, you can go to WLTX Plus, go to our YouTube page, or WLTX.com.
Did it in a very callous way, a very deceitful way.
It's all led to this. Each side has made their case.
To find Alec Murdaugh guilty, not believable.
Now the jury must make their decision. Andrea Mock is live in Walterboro, and legal experts are standing by. News 19 starts right now. The clock here on your Thursday evening. Some incredible news coming out of Colleton County right now. As we understand, there is a verdict in the double murder trial of Alec Murdaugh.
We begin with that breaking news this evening. Jurors got the case around 3:40 this afternoon following instructions from Judge Clifton Newman.
We're going to go to Andrea Mock. She's live outside the courtroom. We're expecting that verdict to be read any second now, Andrea.
Yeah, you guys, this is pretty incredible news. I spoke with an attorney in the case who said at about 6:40, I spoke with him on the phone, and he said, get ready. We think we have movement coming. Now we are hearing that the jury, in fact, did reach a verdict at 6:41 tonight. That would be an incredible 3 hours of deliberation after 6 weeks of testimony. But I'll tell you what that tells me. That tells me that these jurors were listening. That tells me that these jurors were taking in the information that Creighton Waters, that all of the prosecution team, that John Metters, that Alan Wilson, what everybody was telling them, and they were processing it. And by the time they got to that room, it is clear they had their minds made up. I felt in watching this case every day for the last 28 days that the prosecution presented a strong case, be it circumstantial or direct evidence. Judge Clifton Newman today, before he sent the jury to deliberate, he said, I want you to know, we've got action in court. Let's go ahead and look in now. Judge Clifton Newman walking back into the courtroom.
I understand that there is a verdict. You may bring the jury. Thank you. Madam Forlady, if you'll stand for me. Have you reached a verdict?
Yes, sir, we have.
Is it unanimous?
Yes, sir, it is.
All right, if you will pass it up to the clerk, who will pass it to me. And you may be seated. The defendant will rise. Madam Clerk, you may publish the verdict starting with the back, not with the, let's see, I'll tell you again. Starting with the back, flipping them over one by one. State of South Carolina versus.
Docket number 2022 GS 15-00592, the State of South Carolina, County of Colleton, in the Court of General Sessions in the term of 2022, July, the State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116. Okay. Guilty verdict. Signed by the forelady, 3/2/23. Docket number 2022-GS-15-00593, the State of South Carolina, County of Colleton, in the Court of General Sessions, the July term of 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116, verdict guilty, signed by the forelady, date 3/2/23. Docket number 2022-GS-15-00595, the State of South Carolina, County of Colleton, Court of General Sessions, July term 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for possession of a weapon during the commission of a violent crime, SC Code -16-23-0490, CDR Code 0549, verdict guilty, signed by the foreperson of the jury, date 3/2/23. Docket number 2022 GS-15-00594, the State of South Carolina, County of Colleton, Court of General Sessions, July term 2022. The State versus Richard Alexander Murdaugh, defendant, indictment for possession of a weapon during the commission of a violent crime, SC Code 16-23-0490, CDR Code 0549, verdict guilty, signed by the foreperson of the jury, 3/2/23.
Thank you. Madam Forelady and members of the jury, if that is the verdict of each and every juror, please let it be known by raising your right hands. All right, thank you. Any individual polling requested?
We do, Your Honor.
Madam Clerk, you'll need to individually poll the jury according to their juror numbers.
Number 193. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 254.
Yes.
Is this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 326. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 530. Was this your verdict?
Yes.
Is this your verdict?
Yes.
Juror 544.
Yes.
Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 572. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 578. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 589. Was this your verdict? Is it still your verdict?
Yes.
Juror 630. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 729. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 826. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Juror 864. Was this your verdict?
Yes.
Is it still your verdict?
Yes.
Your Honor, the jury has been polled.
Thank you. The jury has been polled and the verdict is a unanimous verdict. If you will bring the alternate juror out and have her have a seat in the audience, please. You can stand there or you can sit back there, whatever you prefer. Okay. Are there any post-trial motions?
None from the state, Your Honor.
We would just renew our previously argued motions for a directed verdict, and at this, on the grounds, on those grounds, we would make a motion for a mistrial and to set aside the verdict.
By the state, response.
Your Honor, based on our previous arguments, we would submit that the case properly went to the jury and the verdict is proper, and would rely on those arguments.
We've been here now 28 days, first few days of jury selection, and the remainder receiving testimony, an overwhelming amount of testimony and evidence that was presented to the jury for the jury's consideration. As I indicated to the jury during the jury charge, or the charge on the law, that this was a matter solely for the jury to determine. The court found at the end of the state's case that there's sufficient evidence to find the defendant guilty if the evidence was believed by the jury. Likewise, at the end of the defense's case, when the motion was renewed, the court found that the evidence was sufficient for the jury to find the defendant guilty. The jury has now considered the evidence for a significant period of time, and the evidence of guilt is overwhelming, and I deny the motion. Mr. Murdaugh, you now having been found guilty of 2 counts of murder involving your wife and your son, 2 counts of possession of a weapon during the commission of a violent crime, the burden now comes upon the court to impose a sentence. Given the lateness of the hour and the victim's rights that must be taken into consideration and complied with under the Victim's Bill of Rights, and consider what I would anticipate to be a number of people who might have something to say regarding sentencing, we will defer sentencing to a later date. Of course, the minimum sentence for murder is 30 years. The maximum sentence is life imprisonment. As to each count, and on the weapons charge, the sentence is up to 5 years, or 5 years, which has to be concurrent if a life sentence is imposed. When would you all like to reconvene for sentencing? I would like to give everyone an adequate opportunity to prepare for it.
State will be ready at 9:30 in the morning, Your Honor.
We could do it at 9:30 tomorrow morning also.
All right. The defendant is remanded to the custody of the Colleton County Sheriff's Department. And he may be taken away. Madam Forelady and members of the jury, I want to thank you on behalf of the citizens of the state of South Carolina and your fellow citizens of Colleton County. You did not volunteer for this service. You were called upon by being summoned to appear, and Providence have brought you to this moment in time and these weeks in time. I know that all of you have been here at great sacrifice, particularly the juror whose job was on the line until a miracle happened, I guess, that allowed him to be able to leave rather than leave after 2 or 3 weeks. But I want to thank each one of you all individually and collectively. It's not often that you're called upon to sit in judgment of the actions of your fellow man, but you all responded and gave due consideration to the evidence. I will make no comment now as to the extent or the overwhelming nature of the evidence, but certainly the verdict that you've reached is supported by the evidence, circumstantial evidence, direct evidence, all of the evidence pointed to only one conclusion. That's the conclusion that you all reached. So I applaud you all for, as a group and as a unit and individually, evaluating the evidence and coming to a proper conclusion as you saw the law, as you saw the facts. Now that you've served for the next year, you're not eligible to serve again. Now, of course, many people never get called upon, but you're not eligible for the next year, and for 2 additional years, you can be exempted from service because no person is required to serve on jury duty in this court more often than once every 3 years. Tomorrow morning at 9:30, we will reconvene for sentencing. You all have no role in that because that's solely up to the judge, to me. You're welcome to come back if you want to and be a part of the audience if you like. I also want to thank the alternate juror who was locked away in a room by herself for these hours, who's hung in there during that period of time. I want to thank you as well. Madam Clerk, what do you have to tell your jurors?
Thank you for your service and what the judge said as well. And I think we can release them tonight and bring them back in the morning.
No, they're off jury duty. They can come back if they like. And you don't have to if you don't want to. Typically, I've seen jurors wanting to see the end result of a case once they've invested a lot into it. It's really an amazing thing with juries. Quite often, at the start of the case, jurors are really like, whoa, why am I here? I wish I wasn't selected. But as time passes and the jurors become invested and really committed to the case and committed to seeing it through, and are very disappointed when they are not able to see it to a conclusion. And then along the way of serving, you end up finding out quite a bit about our judicial system and learning quite a bit, about human nature for sure, but also about the presentation of evidence and hearing from expert witnesses and really learning a lot of things that you'll be able to take with you when you leave jury duty. And to Madam Forelady, I don't know if you were hesitant initially or not, but you have stepped up to the plate and done great job of leading the jury as well. And thank all of you. So the jury is dismissed. Now, one thing before you go, of course, we have invested a lot in maintaining the privacy of the jury, of each one of you. And you are free at this point to discuss the case with anyone. Given the high-profile nature of the case, I'm certain that the many people in the media will probably want to communicate with you, but they have no means of contacting you because under order that I issued, the identity of the jurors must be kept private. And if you decide that you want to speak with anyone, local, state, nationally, or internationally, that's your prerogative. However, should anyone harass you, please let me know and I will address those issues. If anyone through the somehow or another discover your identity and harass you, and rest assured I will intercede on your behalf. That having been said, you are free to communicate with whomever you might want to concerning the case from now on. And so with that, thank you, and you all are free to go.
Judge, if I could
Yes.
If I could have you go to the jury room, and I'm going to meet you back there for just a few minutes.
All right.
Gather your belongings.
And as is my practice, I'll speak with the foreperson before you leave the building after talking to them back there. Anything else?
It took a little more than 3 hours for the jury to come back with the verdict of guilty on both charges of murder for disgraced former South Carolina attorney Alec Murdaugh. This case has lasted 28 days. They've had more than 70 witnesses, more than 800 pieces of evidence. But again, in a little more than 3 hours, jurors believed that they had heard what they needed to hear in order to convict Alec Murdaugh of murder in the death of his wife Maggie and his son Paul. We have team coverage in Colleton County right outside of the courthouse. We're going to begin now with Andrea Mock.
That's right, Darcy. And I have to be honest with you, just as a journalist and speaking about this case to people, when they said they thought that the jury would deliberate for days and into the weekend, every time I said, no, I don't think so. As somebody who has listened to the testimony from the day one, this has been a very strong case for the prosecution, and I feel like Creighton Waters, Alan Wilson, John Metters, they did an amazing job in the last couple of days during the closing arguments and then during the rebuttal of really piecing together all of those points. I mean, like you just said, Darcy, more than 70 witnesses. Jurors, no doubt, got testimony fatigue. Sometimes there was incredibly specific testimony, things about cell phones, things about the crime scene that I know the jurors were saying to themselves, why am I hearing this? Why am I hearing this right now? What relevance does this have? And then basically what Creighton Waters did and what John Metters did was connect every one of those dots together in their closing argument, and I really believe made such a strong case. Guilty, guilty, guilty. That is what the verdict came back today. Now, I want to go over some of the strongest moments I felt in court for the prosecution. Dr. Ellen Reamer. Number one, she was a likable witness. This is a brilliant woman. She is a doctor. She is a forensic pathologist. She has performed more than 5,500 autopsies, and she said she was positive she didn't want to hear any of the defense theory that the second shot that killed Paul Murdaugh was fired at point blank range from the back of the head. Now, why did the Alec Murdaugh's lawyers want you to think that that was possible. Well, that was when they floated that idea of 2 shooters. So she said, absolutely not, it's not possible. And then if you remember, in the last couple of days, they had the witness, Dr. Kenneth Kinsey, back on the stand, and that was when Alan Wilson came up and did the questioning again of Kenneth Kinsey when he was recalled after the defense rested. They did that reenactment in the door. I thought that was a very powerful moment where he showed that if it was, how it was possible, how on earth was it possible for someone to shoot the shot, shimmy past Paul in the doorway, and then move the long barrel rifle to execution style to execute him. So that was a very powerful moment. And then today, again, talking about this growing storm, talking about all the things in Alec Murdaugh's life that led to this. John Meadors today gave some great sound about what it was like on June 7th for Alec Murdaugh. Listen to this.
Whatever was going on in his mind, his world's collapsing. It's coming down. All these world is coming down financially. He's confronted that day by somebody's law firm. Where's this check? He's got another hearing coming up. It's motive. Don't have to have it. But yeah, it's there. And is this rational? When he said that, is that rational? Was it rational to be on the side of the road and claim you're shot? And when you're in the ambulance, and go watch this if you need to, and you're talking to the officer in the ambulance, and you say, what happened? Oh, by the way, he wanted to kill himself. He called 911. He called 911. When he told the officer in the ambulance, well, what happened? Well, some guy shot me. He even did a sketch. He faked the sketch. But what did he tell the guy in the ambulance? It sounded like a shot.
Yeah, that was very powerful testimony, and they even put up a full screen for the jury saying growing storm, talking about all the things leading up to June 7th that were going on with Alec Murdaugh. He was facing Paul was facing a criminal charge in the boat case. He was facing a civil lawsuit. Jeannie Seckinger was onto the fact that he was stealing money from PMPD. Maggie and Paul were onto the fact that he was using opiates again. And then, of course, on June 7th, that phone call saying that his father, unfortunately, was terminal and there was nothing else that could be done. That growing storm, they said, was his motive. We want to bring in some more experts, though, so let's send things back into the studio with J.R. Berry for some talk back with attorneys. J.R.
Andrea, thank you so very much. Yeah, we're being joined tonight by Taylor Bell and Lori Murray. They've been with us on Murdaugh After Hours on our YouTube page throughout the duration of this trial. Thanks for being with us.
Thanks for having us.
Goodness gracious, when we expected you guys to come in tonight, we thought we'd be talking about the closing arguments. We never imagined that there would actually be a verdict. Who wants to go first? Are you stunned after 3 hours of deliberation?
Sounds good. I am really... Yes, I thought it would take longer. The state did a fantastic job today. They did a fantastic job today. The defense was very, very lackluster. I'm sorry, I'm a little distracted because it's like it's unbelievable to me. The defense was very lackluster. Let's start with that. They did not do what they needed to do today, and I think a law school student could have done as good of a job as the defense. So then you get John Meadors, who comes in with that passion that we have been looking for from all of them this entire time. I told a friend of mine, Sean Kent, that he had stolen his vibe because Sean Kent's really emoting like that, and this is definitely something that Sean Kent would have done, this massive big person type closing, and it really resonates with a jury when you do that.
You agree that Griffin didn't have the strongest argument in front of the jury today?
I coined the term rambling man earlier today as about 10-15 minutes into testimony or into his closing argument. It wasn't very organized. Now, it's easy for me to sit here and say that. I'm not in his position giving, the closing statement there. But the organization needed to be better so the jury could follow him. He needed to hit points, in my opinion, and say, that's reasonable doubt, that's reasonable doubt, that's reasonable doubt, so that they could follow him. And the problem is that John Meadors got in there afterwards and did a heck of a job.
Yeah.
He got in there and showed what it is to be a trial lawyer. He had, as Lori said, passion. He showed them emotion. He got in there and it was powerful. He was like a Southern preacher in there, and the jury really heard from him. And after that, we're going to get a verdict today.
It seemed like Matters was emotionally involved with this case. He revealed in front of the jury that, in fact, he had a connection with the Murdaugh family in the past, I believe with the grandfather or father of Alec Murdaugh, as far as his legal career is concerned. He seemed to get choked up a couple of times, especially toward the end when he was talking to the jury about why they should convict in this case.
I think, again, this is a showmanship business at some point. That was emotion that needed to be shown. We have not seen emotion out of any of these defense attorneys, and we needed to see it. I really expected the defense to stand up at the very beginning and say, he's a liar, he steals, he's a cheat, but he is not a murderer. And Alec Murdaugh did not kill his wife and child, and then to move in from there. That would have been the proper emotion to be shown for the defense. And whether John Meadows has connections with this family, I know that he said he worked for his grandfather,
right.
But I don't know that that would have made him choke up as much as it really appeared to do. I think he saw Jim Griffin cry at the end of his closing argument, and knew that he wanted to show every range of emotion that he could.
But Matters also seemed angry at times. I could see him shaking his finger right there. He's
Right.
he seems visibly upset when he's presenting these facts to the jury, because I think perhaps that's his job, obviously, to convince the jury here. But he seemed very genuinely upset that the defense would come back and basically say law enforcement didn't do their job, they didn't check this, they didn't check that. He said they were offended by that in court today, Taylor. He told the jury that that's offensive to say that the people in law enforcement and that we, the state, have not done our job in this case.
He had a lot to go off of. He had a lot to go off of based on the circumstances that they put up. And in response to what Jim Griffin said, he brought it out. The emotion came. It came, and he did a really, really good job with that. I think the only thing I could flaw him on was the pacing, but that was still the energy coming out of him because he was ready. The problem is the defense didn't appear to have any energy. They appeared deflated during closing arguments. You could tell, and I think the jury could tell.
And it's funny too, and I don't mean to interrupt too, but the entire time that Jim Griffin was talking, you could see John Meadows behind him, steady, right? And you could see the emotion that were coming across these assistant U.S. attorney, or not U.S. attorneys, attorney generals. They rolling their eyes constantly, like, I don't understand where you're going with that, which is kind of what we all felt. I don't know where you're going with that, but they were showing it on their face, and it was in the background of the camera. But you could see John Meadows getting ready for his redirect, or his, what do you call it, rebuttal close. He was getting ready the whole time. You can see him even right there. He's got his notes right there. He's still reading and practicing and writing and getting ready.
I'm going to be curious as to what the jury members have to say, because probably a few of them are going to speak to the news media after this is all over. I'm curious if they think that dog kennel video was the slam dunk for them when it came to this, because again, Murdaugh saying he wasn't there. He wasn't there. Then this video is recovered. Oh, he was there, and then he admits to being there. I mean, again, I said this the other night, I'll say it again, they didn't find the murder weapons, but that video, that had to be the smoking gun in this case.
Yeah, that was the big lie. And it's not so much that he lied, it's what he lied about. And it's about the timeline that he lied about. It is, you might have made up a lie for that night, but how does it happen to coincidentally be at the same time that the murders occurred? So why would he not lie about how long he was at Alameda? And how would you know to lie about that specific time? Because he didn't know the time of death. So any lie could have been excused away, but this particular one, and knowing where and when to insert the lie, was telling.
Taylor, as we were watching the verdict read, and then after the verdict was read, I didn't see any emotion. You didn't see any emotion when it came to Alec Murdaugh.
There was no emotion. No emotion whatsoever from his face when the verdict was read. He just stood there with stare, absolute stare, and thinking somebody just got convicted of murdering their youngest son and their wife, and if they truly didn't do it, maybe there might have been some kind of emotion. He had some emotion earlier in the trial. Maybe it was he saw it coming. That quick of a verdict, typically in my experience, you kind of know that your fate by how quick the verdict came back here.
Buster Murdaugh, they showed his son as the verdict was read as well. It looked like he did get a little emotional at one point there, Lori.
I think it was probably the most emotion that we've seen out of him the entire trial. And it wasn't a lot. You had to look really closely to tell if it was actually, tears. I think he got a little choked up. But they have both been very stoic this entire trial. Well, I say that. Let me completely cross that out. Alec Murdaugh has not been stoic. Alec Murdaugh has been emoting, and whether it was pretend or not, whether it were crocodile tears, who knows. But the family has really sat back and just watched, and Buster especially has shown no emotion.
On that, his life has been devastated from this. Buster has.
Yeah.
He lost his mom. He lost his brother. Now he's lost his dad. His dad's going to die in prison, whether or not he gets a 30-year sentence or he gets a life without the possibility of parole sentence. He's in his 50s. The life expectancy to make it into his 80s in the Department of Corrections. He's just lost his entire family in the course of 2 years here.
The murder weapons, as we've mentioned, never found, but he was convicted on 2 counts when it involved weapons.
Right.
How?
Well, he's convicted on 2 counts of possession of a firearm during a violent crime, and the matter of death was a shooting. So it's just a circumstantial case that if they died by gunfire, then there had to be a gun involved.
Are we surprised that sentencing is going to be at 9:30 in the morning?
No, I think Taylor and I were talking about it. Taylor thought that it would be tonight. Judge Newman likes to normally go right into sentencing, but I thought that in this big of a case that he would give some time for the victims' families and the impact statements to come in. Actually, the victim's family in this case is the defendant's family, so whoever wants to speak to get that prepared. And so I think, given the late hour, that it was reasonable for him to do.
I think the state wanted to comply with the victims' rights, and I believe that Maggie's family has sat by and waited for the legal process to work, and now they're going to get their opportunity to speak to the court about how they feel what happened to their daughter. I'm not sure the extent of her family, maybe sister, and they're going to get their opportunity to speak, and I think that's why the state wanted to hold off to make sure that they were there, because I'm pretty sure they've not been there the entire week.
Right.
They have not.
All
and
right.
It'll be interesting to hear what they have to say.
All right, Lori Murray on TikTok. You've got a
I do.
program
Lori.
there. Thank you very much for that, Taylor Bell.
you.
Thank
Thank
you.
you.
Later tonight, they'll be back with us for our Murdaugh After Hours program. That's at 9 o'clock on all of our social media platforms. We hope that you'll be tuning in on WLTX Plus, our YouTube page, or WLTX.com. So, Darcy, a case that begins in late January, ends in March, and 2323. That is the date. That is Alec Murdaugh's Judgment Day. Back to you.
JR, thank you so much. This is day 28 of the Alec Murdaugh trial. It took jurors less than 3 hours to determine that he is guilty in the double murder trial of his wife Maggie and his son Paul. We know that there were more than 70 witnesses presented, more than 800 pieces of evidence, 6 weeks of a trial. And again, I can't stress enough that it took jurors just a little bit more than 3 hours to make this determination. You have to understand that with that much material, legal experts were saying to us as early as yesterday that they thought that this could last through the weekend. But it appears that the jury was convinced when they went into that jury room that they had already made up their minds and they understood what that verdict was going to be for Alec Murdaugh. Again, coming back tomorrow morning for sentencing. We're expecting that to begin at 9:30 tomorrow morning, where Judge Clifton Newman will sentence Alec Murdaugh. He could get a minimum of 30 years in prison. And again, as we just heard from our panel of legal experts, in his 50s now, that would put him in his 80s before he is released from prison. We've talked a lot about the murder charges because that is the big headline. But we should also put a pin in the point that Murdaugh is also guilty on those weapons charges. So again, 28 days of a trial, Alec Murdaugh handcuffed and taken back to the Colleton County Jail tonight. Andrea Mock is standing by outside of the Colleton County Courthouse. She's been there for us today. We've got team coverage. We'll start with you, Andrea.
Yeah, Darcy, you know I was the anchor assigned to this since the beginning. I have listened to almost every single moment of testimony, and I had a sort of surreal, saddening experience. I sat in the courtroom today. I actually sat right behind Buster Murdaugh. I just heard the attorneys talking about him being stoic during the trial, and it really did strike me that, you know what, he's lost all of his family no matter what, whether his father went away for this or for the financial crimes that he's facing. And they had a family picture. Jim Griffin had a family picture up the entire time he was giving his closing. And the picture included Buster in it. So very sad to remember all the lives that have been affected here, all the deaths, including Mallory Beach, starting with the boating accident. But I heard the attorneys talking about John Meadors today and what an incredible job he did. And I wanted to touch on that. There were 2 points today that I really thought, wow, he hit that home. One of the points was the fact that the experts showed, that testimony from Chevrolet, from OnStar, showed exactly what time Alec arrived back at the dog kennels. And then 19 seconds later, he called 911. John Meadors today, in speaking to the jury, said, in 19 seconds, he went and did that. He checked on his wife, he checked on his son, and processed everything that was going on. And he said something to me that gave me chills. He said, I would have still been on the ground with my son. Powerful moments like that, whether you understand all of the complicated ballistics testimony, whether you understand some of the complicated testimony about cell phones and pings and radius and in the circle, that was a moment that really hit home. And if we're talking about common sense, which both the prosecution and the defense believed was on their side, that was a common sense moment of 19 seconds. Would you have enough time to process, or would you still be on the ground with your child, seeing if there was anything you can do? That was one of the shining moments today. I believe one of the other shining moments from John Meadors was talking about those weapons, talking about that .300 blackout casing. And he used the term family weapons. What is the chances? What are the chances that these vigilantes who are coming in for justice because of the boat case are going to know that there will be weapons there that I can use them? Or will they even know how to use a .300 blackout rifle? Let's not forget that particular gun is a $10,000 gun. We learned in testimony from one of the SLED agents that he said in his 26 years of law enforcement, he had never heard of a .300 blackout being used as the murder weapon. But then we also heard testimony from a cousin of the Murdaughs saying they owned not 1, not 2, but 3 .300 blackout rifles. I found that to be very damning testimony. But today he said that was a family rifle. He said, and you know what? If they could have brought in an expert that said that those shell casings, that the ballistics expert said the shell casings around Maggie's body were fired from the same weapon that fired other .300 blackout shell casings previously on the Murdaugh property, if they could get somebody in here to say that wasn't true, they would have done it. I thought that was pretty incredible. Now, going back to Creighton Waters, let's talk about the steps. Let's talk about all the things that our cell phones record that we are now aware of. We now know that Alec Murdaugh, the testimony showed that he left his phone at the house when he went down to the kennels. Coincidentally, the lie that he upheld for a year and a half. Did he leave his phone up there knowing that he was going to lie about it? And he had no steps until 9:02. We know that both Maggie and Paul's cell phone locked forever at 8:49. Alec Murdaugh's phone starts moving again at 9:02, and he takes 283 steps until 9:06. Let's listen to a little bit of the closing arguments about those steps.
phone, tried to make a big deal about this phone that you do see right afterwards when we know he was down there. There's some movement on Maggie's phone. But every expert has said, just because if one phone's down here and the other one's walking, you're not going to have steps on that phone. He took Maggie's phone, the golf cart, however he got, drove back up to get those shorts and that shirt. And yes, you can get it and manipulate it and call to see if you made a call, put it down. That's not going to record steps on that phone because it's not moving. But that doesn't mean it wasn't with his phone. Don't fall for that. That's not real. Every expert said that. Every expert said that. And doesn't that make sense? You can grab it, see, make a call, put it down. You keep walking, it's not going to record if it's there. If it's in the car, it's in the Suburban. And I'm getting to that.
All right, another common sense moment John Meadors had today in the courtroom that I believe was a very powerful one is he said, come on people, use your common sense. If your mother is elderly and she has Alzheimer's, and we know that Alzheimer's patients get very tired, get very fatigued, would you go and see her at 9:30 at night? And then he brought up Miss Libby today, Miss Libby's caregiver, that is, Shelley Smith, saying that, you know what, Shelley is a neutral witness in this. She actually is somebody that has been employed by the Murdaughs for some time. He called her a neutral witness. And he said even she was bothered by Alec Murdaugh's behavior. He went on to say that she said that there was a conversation after the murders, a few days after the murders, that made her very uncomfortable, that Alec came to her and said, now I visited that night on June 7th, about 45 minutes, right? And wanted her to agree when she knew in fact that was a lie and he had only been there 20 minutes. And then the blue raincoat, the blue tarp that we know was covered with GSR. 6:30 in the morning, Alec comes over to visit. She said that was very unusual. He had what she thought was a blue tarp. It might have ended up being a blue raincoat. SLED did finally get permission to search that Alameda property. They found that blue raincoat coated so much GSR on the inside. The forensics expert testified, I couldn't count it all. It was so much. So she was talking about that.
It looks like we're having some technical difficulties with Andrea's shot, her live shot out there at the Colleton County Courthouse. It appears, because we're seeing, it looks like they're about to start a press gaggle. So I'm not sure if we're going to hear from the attorneys who are there, maybe the family, I'm not sure. But we do know that within the next couple of minutes, we are going to have a press conference outside of that courthouse. The breaking news headline for any of you who are just joining us: Alec Murdaugh guilty in the deaths of his wife Maggie and his son Paul. Maggie was 52 years old, Paul just 22 years old when they were gunned down and killed on June 7th, 2021. Both the prosecution and the defense had a story of timelines, and their goal was to have those 12 jurors believe the sequence of events in their timeline was the one that bode true. But that did not happen in favor of Alec Murdaugh. They believed the state's case, and now he could spend, at a minimum, 30 years behind bars. He'll be back in court tomorrow morning at 9:30. Judge Clifton Newman not giving the sentence tonight, but saying that he expects everyone back in the courtroom tomorrow for sentencing. That includes jurors if they would like to be there. Listen in as we have the verdict read just about 3 hours after they were charged. The jury, I should say, was charged with the case.
Docket number 2022 GS 15-00592, the State of South Carolina, County of Colleton, in the Court of General Sessions in the term of 2022, July, the State versus Richard Alexander Murdaugh, defendant, indictment for murder, SC Code 16-3-0010, CDR Code 0116. You want me to turn it over?
As you can see for yourself, when that verdict was read, there was very little emotion from Alec Murdaugh. One may be able to glean from that after spending his entire professional career as an attorney. He probably already knew what his fate was when the jury came back just over 3 hours with a decision. There's been a lot of emotion with Murdaugh throughout the trial, lots of crying, lots of tears. We, the public, did not get an opportunity to see the more than 800 pieces of evidence that was presented. We saw a lot of it, but we didn't see all of it because a lot of the evidence was graphic. A lot of the pictures were of... I don't even have the right words to describe how experts have described how Maggie and Paul's bodies were after they had been shot. So we did not get to see that evidence, but the jurors did. And again, at 6:41, they told the clerk of court of Colleton County that they had made a decision. J.R. Berry standing by now in Studio B. He's got our panel of legal experts with him again this evening. A minimum sentence of 30 years. Alec Murdaugh, more than 50 years old. That would put him at more than 80 years old before he is released from prison. What are our experts saying about this and what we can expect with the charges, the weapons charges as well, JR?
All right, thank you so much, Darcy. Taylor and Lori have rejoined us again. I believe we have a live look outside the courthouse where we're waiting for the attorneys to show up to address the media there following this verdict, which took about 3 hours or so this afternoon to come to a conclusion. And that's what I want to talk to you guys about right now, because you've been on social media. You know, there's been people on both sides of the case. There's those who have said, oh, he's guilty as sin. Then there's others who say, hey, the state has not proven their case here. I don't think he did it. So what do you say to the Murdaugh supporters out there after a jury, after 6 weeks of testimony and all this evidence, hundreds of pieces of evidence presented to them, come back with a verdict, I should say, in 3 hours?
So good job, John Metters. I think that this was all John Metters. I was one of those people. I was one that said that he didn't meet their burden, that Creighton Waters didn't meet the burden. I didn't think that he did. And then John Metters got up there and convinced everybody that he had. They forgot all about all the evidence and they listened to that impassioned, bolden closing by John Metters, and I think it was over from that moment on.
I think it's a direct reflection on the jury and their ability to look at Alec when he took the witness stand and say, he's lying to us. I don't think they believed him whatsoever. I think the quickness of the jury coming back with this verdict tells us they didn't believe a word out of his mouth when he was on the witness stand. And I think that right there was enough for them to come back with a verdict this quick.
I disagree. I'm sorry. I disagree with that a little bit because there were reports of jurors crying and handing him tissue. So I think that they initially did, but John Metters and Creighton Waters convinced them afterwards that he was lying.
I'm not going to disagree that John Metters brought it home, scored the winning run at the end. I think that comparing the closing by Jim and the closing by John Metters, they were stark contrast of each other. Absolutely. One was very emotionless, no voice inflection, stood at the lectern the entire time.
Read part of his
read it,
argument.
didn't have any kind of chronology up there.
Right.
Whereas you had Creighton Waters up there, at least had PowerPoints and chronologies. Right. And then you had John Metters got up there with a lot of emotion. We had none of that, in my opinion, until the very end from Jim Griffin, and it was minimal. There was no voice inflection in when he wanted to talk about something that really mattered by raising his voice. He talked very, very monotone the entire time, and I think it showed that he was defeated in his closing argument.
He sounded nervous.
Right. The jury member who was booted out of the jury panel before things got underway this morning, how big of a deal was that?
The rumor, I think it's a big deal. The rumor is that she was kicked out for talking to, maybe on social media or for talking to other people, at least 2 other people. My understanding from the rumor mill is that what she said was that she did not think the state had met their burden. And so she was the ringer on the jury, which is why you heard the defense a little bit testy this morning. And at the same time, it doesn't make any sense that they didn't object to that. I mean, I guess they felt like there was no objection to be made. The judge made a decision, but there should have been an objection to that, motion for mistrial, something to preserve the record for appeal.
And to be clear, that is just something you've heard. Nothing has been said
it's a
about
total
that
rumor,
at all.
yes,
All right.
total rumor.
You, Taylor, how big of a deal was it that you get, on the day we get the verdict, a jury member kicked off and the alternate comes in?
I think that's the only juror that got caught at the end of the day. I think that's the only juror that got caught talking about this. There's no way that these jurors have not had some kind of conversation about the trial, their feelings, especially at least at home. There's no way they're sitting on their social media and scrolling through and just skipping whatever, mentions Alec Murdaugh trial everywhere. It's everywhere here. You can't tell me that they're not scrolling and seeing it and not reading it. So I think a bit of it is others actually probably had some type of outside influence. That's the only one that got caught. I do find it funny that there was a dozen eggs that had to be gotten at the end. And I said, maybe they're going to hold out for another day so they can get another dozen eggs. I mean, they're expensive.
I'm not sure where
They
that came
didn't
from.
understand that on social media. And because these people that are not from South Carolina said, you don't understand, those are country eggs. Those are fresh country eggs. I would wait for them too.
Real yellow oaks.
That's right. I would absolutely wait for those eggs.
No one has followed this trial closer than our Andrea Mock. She and I were kind of surprised at something we had not heard until today. Maybe you had heard it already. In fact, let's look at this video right now. This is Alec Murdaugh
Being escorted out.
being led to the van to take him to the detention center. This video coming into us just a short time ago. We saw Alec Murdaugh being let out in handcuffs. And when he was let out in handcuffs, when he was led through the door, we inadvertently showed some jury members. Our apologies for that as well. That is a pool camera that we're getting the feed from, but we inadvertently showed some of the jury members on TV. But again, here he is walking out in those handcuffs to the van as he heads off to the detention center for the evening.
Look what a big man he is.
He's
so
6
tall.
feet 4. Yeah.
When I was in the courtroom, it was very noticeable. I think he was the tallest person in the room.
Yeah. I want to mention something that we were going to get to just a moment ago. Andrea has watched, I think, every moment of this trial. I've watched as much as I could. Something that was said today in Jim Griffin's closing arguments caught us both by surprise. Hair found in Maggie's hand.
Absolutely.
I had not heard of that. I had seen something, actually, let me say, I had seen something on social media about that, but since I had not heard about it in court, I'm like, that's just somebody stirring up rumor on social media. But Griffin today, in his closing, he says, why didn't SLED test the hair in Maggie's hand? And I'm like, whoa, wait a minute. Really? There was hair in Maggie's hand? What do you know about that?
It was in one of the reports. It was in one of the forensic reports that they had found brown hair. One of the SLED agents testified to it, that there was brown hair in her, what appeared to be dark brown hair in her hand, which begs the question, why didn't the defense make more of a big deal about that? Why didn't they raise that issue more emphatically, that SLED did not test that hair? Because it could have been a really good point for them.
You agree with that, Taylor?
Also, question, why didn't maybe the defense independently potentially try to force the issue and have it tested? They maybe could have filed a motion and said we would like them to run this through the database held by the state, whether or not it came back with anything, whether or not they actually wanted that to be done. That's a double-edged sword. It could have come back for nothing. It could have come back with a hit, or it could, we don't know. But it is a question that, why didn't they test it?
Yeah, Jim Griffin said, it could have been her hair, could have been someone else's hair, but we don't know because it wasn't tested. So why wait until the closing arguments before we hear something like this? To me, it seems like a pretty big deal.
It is a big deal. It's just another mistake by the defense. And there were a lot of them. And this was a big one, a big mistake.
All right, we mentioned Jim Griffin. Earlier today, he was basically saying that SLED, law enforcement officers, did not do a good job with this investigation. Here now is some of what he had to say earlier today.
We know from June 7th, June 8th, Alec is a suspect, and he's in the circle. And from that day forward, he is at the mercy. He is at the mercy of the ability of SLED to exclude him from that circle. They have the ability to do the forensic work, they have the ability to interview witnesses, and they have the ability to gather electronic data. And we believe that we've shown conclusively that SLED failed miserably in investigating this case. And had they done a competent job, that Alec would have been excluded from that circle a year ago, 2 years ago.
All right, we are going to go live now. The presser we've been waiting for, State Attorney General Alan Wilson, Creighton Waters, they are expected to meet with the media here and to take some questions and make some statements following this verdict that came down about, well, a little less than an hour ago.
There's a lot of us coming out.
Let's take a listen.
How are we on the mic check? Thumbs up, thank you. We got our team out here. Wow, what a great day for the people of South Carolina. I want to thank every one of you for being here tonight. There's a lot of emotion here tonight at this courthouse. A lot of, a year and a half, nearly 2 years of blood, sweat, and tears, it feels like. A lot of hard work from so many people. So if you will just bear with me, there's there's a lot of people I have to thank. But first, those of you who don't know, I'm Alan Wilson. I'm South Carolina's Attorney General, and I got the best staff of any Attorney General in the United States of America. I want to start by thanking our prosecution team. I want to tell you, I've been here for nearly 6 weeks with this team, living in a hotel, and it felt almost like being in a dorm environment in college. Late nights, cramming, studying, little sleep, away from our families, getting up early, getting here to the courthouse, working long hours, getting on each other's nerves at times, but it was all worth it. It was all worth it because we got to bring justice and be a voice for Maggie and Paul Murdaugh and bring justice for the people of South Carolina. I'd like to start real briefly by thanking our team. First, excuse me, I need to put my glasses on. Our chief prosecutor, I tell you, I appointed Creighton Waters to be the chief prosecutor of this case nearly a year and a half ago. And I want to say I'm pretty brilliant because I picked the right guy. And I want to say thank you to Creighton Waters. Creighton, you did a fantastic job. I don't think there's another attorney in the state of South Carolina that could have led this Herculean effort. But Creighton will be the first to tell you he didn't do it alone because he had a team of people. I want to first thank Don Zelinka, who is actually Creighton's boss. He is the Deputy Attorney General, been in the Attorney General's office for over 40 years. Sitting here to my immediate left, Don Zelinka, thank you so much. John Metters, many of you got to see him do the closing argument today. John, thank you. You've been a phenomenal add to our team. I'm going to go quickly through the names, but as I read the names, please raise your hand. You know Creighton, you saw Don, and you see John. David Fernandez, John Conrad, Johnny James, Savannah Gowd, Ozzie Toledo, Shane Acito, Carly Jewell, Carson Burney, Danielle Colon, and our victims advocate, Tricia Allen. I also want to say thank you to the South Carolina Law Enforcement Division. Mark Keel assigned some amazing men and women. And when I said it was an agency-wide effort on behalf of SLED, I can't underscore that part enough. Every time I called Chief Keel, every time I reached out to the lead agents, every time Creighton was asking me, hey, General, we need something from SLED, we would reach out to SLED, and they were there. They busted their butts. I can't begin to list every agent, and some can't be listed for obvious reasons. Some are standing up here tonight. I told them I wasn't going to mention their names, but we would not be here if it wasn't for SLED. And I want to thank Mark Keel and his team and all of the men and women across the entire state law enforcement division for what they did to make tonight a possibility. I also want to thank the FBI and the Secret Service, our federal partners. We had to utilize many of their assets and resources. We couldn't do all the things that we did without our federal partners. We had a lot of local partners. We had the Colleton County Sheriff's Department, Buddy Hill, Sheriff Hill and his team, providing the security. They did a phenomenal job, and they were there. They were the first responders the night on June 7, 2021, when Maggie and Paul were butchered brutally. They were the first responders, and they were the first ones to be there. The Charleston County Sheriff's Office, the Orangeburg County Sheriff's Office were instrumental in supporting our investigative efforts. You all know Kenny Kinsey, our chief crime scene expert, was with the Orangeburg Sheriff's Office. I also want to thank the city of Walterboro. I think the mayor is here somewhere, and the police department. They provided security. Thank you. This whole community has embraced our entire team, and I cannot thank you enough. We've all been away from our families, 2 hours away from our families for the past 2 months, and it's this community that made us. We would walk into restaurants and people would come up and thank us. You know, you don't have any idea how good that makes people feel when they're under an incredible amount of stress, an incredible amount of scrutiny, and this community really embraced us. I want to thank the Colleton County Clerk of Court, Becky Hill, and her entire team and their staff. I don't know. I call her Becky Booth, that's her nickname, but Madam Clerk, wherever you are tonight. I'm sorry, that's my pet name for her. But I want to thank you, Madam Clerk, for you, the entire team, the bailiffs, the court security, the staff here. There was no role that was too small that they weren't willing to do for us. The security team here, it was a Herculean effort by everybody, and I can't thank enough people. I don't know if I mentioned the bailiffs, but I want to thank them. And there's another group of people who you don't know who they are, but that's the jurors. And not just the jurors, but the alternates, the ones who didn't even get to serve to the very end, but people who were taken away from their families. And I want to thank the families of our jurors who sat here every single day for what seemed like long amounts of tedious, monotonous information and evidence. Sometimes people didn't know what it meant. They didn't understand it. And they had to sit there and process it and hear it over and over and over again. And I want to thank these nameless jurors whose identities have been protected. They may make their identities available to all of you at some point, but they sat there and they delivered justice tonight, and I want to thank them for their role in this process. You know, Winston Churchill said, democracy is the worst form of government except for every other kind. I kind of want to adopt that and say we may have the worst criminal justice system in the world, but it's better than every other kind that there is. And our criminal justice system worked tonight. It gave a voice to Maggie and Paul Murdaugh, who were brutally mowed down and murdered on the night of June 7, 2021 by someone that they loved and someone that they trusted. And they couldn't be here to testify for themselves tonight. Their testimony came through the evidence and the information that was gathered by the men and women of the agencies I've just mentioned. It came from the testimony of the agents and the investigators and the attorneys and the folks in our staff who were able to get it to the court record. And so I want to say tonight, their voice was heard tonight and justice was brought for them. We can't bring them back, but we can bring them justice. I started off my remarks by saying that it is a good day in South Carolina. Today's verdict proves that no one, no matter who you are in society, is above the law. A lot of people doubted that this process would work, and hopefully, for those who did doubt the process, hopefully we have instilled and put a little bit of faith back into you and your lives as you view this process as it unfolds. I'm proud of this team. I'm proud of the men and women standing behind me tonight, and there's been a lot of emotion. And I just want to say from the bottom of my heart, I saw firsthand for the last 5 or 6 weeks the countless nights where you were up beyond midnight and you were getting up before dawn, not eating. I was watching Nancy Grace the other night and I heard her call Creighton pale and gaunt because Creighton wasn't eating and sleeping. He really wasn't, folks. I'm serious. You know, we would have to bring him Kind bars and things to eat during breaks, but Creighton, Herculean effort, my friend. And I am truly honored to have you on our team. Thank you for being a great leader and a great chief prosecutor. And I would like to invite you to come up here and make some remarks for the folks here tonight.
Thanks, everybody. And I want to start by thanking this guy who's given me and all these folks behind us opportunities to do justice, which is what we want to do with our careers. It is very tough and demanding, but it's rewarding for moments like these. The general stole a lot of my lines, but I also want to thank the jurors for their long and arduous service. And we had no doubt that if we had a chance to present our case in a court of law, that they would see through the one last con that Alec Murdaugh was trying to pull. And they did, and we're so grateful for that. I get to lead the state grand jury section in the Attorney General's office. This particular case is not a state grand jury case. There are other indictments that are state grand jury. But the one thing about that is that I have an amazing team. And I want to be clear, this was a team effort. Y'all saw all of these folks behind me doing amazing work. And I can't be prouder of a team in my life. We called this our Super Bowl, and not because of the media attention, but just because of the effort that we knew that we would have to put into this. And we didn't really get to watch much of the Super Bowl that went on, because when we arrived, I think it was winter, and it feels like spring now. But every single member of this team, every single member of the state grand jury staff, what we do well is work together as a team in complex investigations, and who we work with is my partners at SLED. And I can't thank them enough as well, because we're used to working on these complex cases and working together. And I'm not leaving out Sheriff Hill and the Colleton County Sheriff's Office and our federal partners in Orangeburg and Charleston Sheriff's Office and all the other agencies that have worked on this case. I also want to thank Ms. Becky, if she's still up there, because she's been amazing. The clerk staff has been amazing. The court staff has been amazing. The bailiffs have been amazing. And again, I also want to thank this community who really has embraced us and has been so great to us and made us able to survive this process that has been long and arduous. And I have been sleeping. I hadn't been. And I have been eating more than Con bars every now and then. But, and I'm sure that's a nice plug for Con. But anyway, it really has been a great process. We will have sentencing tomorrow. Obviously, we're not going to comment on sentencing because that's still pending. But justice was done today. It doesn't matter who your family is. It doesn't matter how much money you have or people think you have. It doesn't matter what you think, how prominent you are. If you do wrong, if you break the law, if you murder, then justice will be done in South Carolina. And I think South Carolina has shown the nation and the world how a process can work and work well. Thank y'all.
And also, I want to thank Creighton. I told Creighton, I said, Creighton, I'm going to come down and I'm going to be just a staff attorney. I know I'm your boss. I'm your boss's boss's boss. But I said I'm going to come down and I'm going to help. And I said I'm going to follow instruction. And I hope I was true to my word. This past weekend, I was saying, what can I do to help? I said I'm willing to take a witness if it'll help. He said, actually, it would. So he let an old prosecutor dust off his cleats and get back in the game and to help the team out. And
I got to beat the boss of the boss for a while.
Yeah,
So
don't get used to it.
I'm not used to it.
No, but in all seriousness, I'm proud of the decisions that I made in putting the people behind me and to the left and right of me in charge of this case, and I was honored to be part of this team. Just another member, just another worker bee in the trenches trying to bring justice to the people of this state, and to bring justice to the people who couldn't be here tonight because they were brutally murdered by someone they trusted. Now, with that being said, I know a lot of people want to talk to us. A lot of people want to talk to some of the attorneys and the support staff and the agents, investigators here tonight. Some of you want to talk to me and others. We're going to make ourselves available to you. But like Mr. Waters just said, tomorrow there's a sentencing hearing, and we don't want to get out in front of our skis. And plus, I'm starting to feel the rain come down. But I promise you, we're going to make ourselves available to talk to members of the media, to talk to all of you out there that have questions. We'll answer any questions that we ethically can. We hope you'll continue to be patient with us. as we finish this process tomorrow. Again, we're going to go back and get a good night sleep tonight. But again, thank you. I'm going to also, one last group that we didn't thank, the media. You all, I know a lot of people in this polarizing world we live in, a lot of people take shots at the media, but the media was incredibly respectful. You were so good, not just to us, but listen, to the families of the victims, okay? I know this is an awkward situation, but you protected the identities of people, and you protected the process, and I want to thank you for your part in this and telling the stories, educating the public on what's going on out there. So now I'm going to stop speaking as an attorney general, and I'm going to close as a father and as a husband to say that when you go home tonight, hug your loved ones, Amen. Hug your spouse, Amen. Yes. Hug your children, because this case reminds us of anything that you can't take for granted that people in your family are always going to be there. And right now, when I get home tomorrow, I'm going to hug mine, and I hope you hug yours. But thank you again. Thank you for your prayers.
Yes, sir.
Thank you for your prayers. You came and prayed for me. I see a lot of people come and say we're praying for you. We appreciate your prayers. Thank you all so much. And this is going to conclude this press conference. We look forward to talking to all of you tomorrow. Thank you.
That's South Carolina Attorney General Alan Wilson wrapping up that press conference where the state came to talk about that guilty verdict for Alec Murdaugh. This is the 28th day of the trial, and around 6:41 this evening, jurors told the Colleton County Clerk of Court that they had reached a decision a little more than 3 hours after receiving the charge to come back with a guilty or not guilty verdict. They came back with that guilty verdict saying Alec Murdaugh guilty in the deaths of his wife Maggie and his son Paul. June 7th, 2021 was when they were both brutally murdered. And again, that jury saying today that Alec Murdaugh was the one who killed his family. We're going to continue to follow this case for you. If you would like to share your thoughts about the guilty verdict in this trial, you can text us at 803-776-9508. Again, share your thoughts about the Alec Murdaugh guilty verdict by texting us at the number on your screen, 803-776-9508. And we may share some of your comments on air later tonight and into tomorrow, because we know that Judge Clifton Newman tomorrow morning at 9:30 will come back into that Colleton County Courthouse and sentence Alec Murdaugh. We are going to head back to network coverage on air, but we're not done with our coverage of this trial. We're going to be online at WLTX.com and on our YouTube channel for those of you who want to continue to follow along with this guilty verdict. Again, sending things back to network coverage now, but we'll see you online.
See a story you loved? Watch it again right now on WLTX Plus, available on Roku and Fire TV.
Well, today, 5 women, 7 men, after 28 days of testimony and evidence, have now found Alec Murdaugh guilty in the deaths of his wife Maggie and his son Paul. Thank you so much for joining us for this breaking news. I'm Darcy Strickland. We have team coverage down in Colleton County. We have a panel of legal experts here in the studio. We're going to get to them in just a moment, but we're going to begin. For those of you who are just following along and just joining us, let's listen to that verdict.
The court found at the end of the state's case that there's sufficient evidence to find the defendant guilty if the evidence was believed by the jury. When the motion was renewed, the court found that the evidence was sufficient for the jury to find the defendant guilty.
Again, Judge Clifton Newman reading that deliberation from or reading the after the jury had deliberated for 3 hours, I should say, excuse me, telling Alec Murdaugh again guilty on the charge of killing his wife, Maggie, his son, Paul, and then also guilty on those weapons charges. The murder charge, a minimum sentence of 30 years behind bars. We're going to start our team coverage again in Colleton County at the courthouse. That's where we find News 19's Andrea Mock. She has been following this case for us today. And Andrea, I can still see that there are a number of folks behind you, some of them from the press, some of them who were court observers today. What is the feel right now that we know that Alec Murdaugh is guilty?
I gotta be honest with you. Yes, you're right. There are a ton of people here at the Colleton County Courthouse. As a matter of fact, when we started announcing that there was a verdict, cars with families, with young children were pulling up and letting them off right here. The stairs behind me go up to the courthouse door. You know, but it's bittersweet, Darcy. Yes, justice has been served, but 2 people are dead. A brother has lost his mom, his brother, and now his father is going to jail. There's certainly nothing gleeful, but they just arrived and they were cheering for the lawyers when they came outside. It was nice to hear from Creighton Waters after the fact. He certainly has done the heaviest lifting in this trial, and he said Alec Murdaugh had one last con, and it was shut down. He said it just shows that if you do the wrong thing in the state of South Carolina, justice will find you. And Creighton Waters, I believe, is largely responsible for this guilty verdict. He had many powerful, passionate days, but I believe his most powerful was his closing argument yesterday. He came out and said point blank at the very beginning and the very end of his closing arguments, there is only one man in this courtroom who had the motive, the means, the opportunity, and the guilty conduct after the crimes. And he said that is Alec Murdaugh. Something else that's interesting, he has said when accountability is at his door, Alec Murdaugh becomes a victim again. And why he said that, he was talking about the fact of June 7th. We know now a lot of things were coming down on Alec Murdaugh that day. He called it a growing storm. Alec was facing lawsuits, civil lawsuits, perhaps $10 million. Mark Kinsey was the attorney for, or Tinsley was the attorney for Mallory Beach. They were asking for $10 million. Well, the bank testimony was that Alex on June 7th had negative $300,000 in his bank account. On top of that, Jeannie Seckinger at PMPD Law Firm came and testified before the jury about missing fee after fee after fee. But on that day, June 7th, she confronted Alex Murdaugh about the missing Ferris fee. And it was no chump change. That was a more than $700,000 settlement that Alec had allegedly stolen and spent in 2 months. So there was that. They also took us back in their testimony, talking about what happened with Alec and his family in May. In May of 2021, which, as you know, is just a couple of weeks before the killings, there was testimony, and we saw the text message from Paul that said, "Mom found pills, we have to talk." We also know just a day before the murders, the family was with us in the Midlands in Columbia, South Carolina for a baseball game. There was text messages going back and forth that Alec didn't feel well, wanted to stay at the hotel, and didn't even go to that baseball game. So Creighton Waters say all those things adding up for this slow burn where things were crashing down on Alec Murdaugh. Now, what was so powerful is when Creighton Waters passed the baton to John Metters, they were able to revisit that. So they were talking about all these things that were happening on June 7th. And then he said, again, when accountability comes for Alec, he becomes a victim. And what does that mean? That means after June 7th, they stopped asking him about the Ferris fee. They stopped asking him to have a hearing about the boat crash. That solved his problems temporarily. So he said that was the motive in the case. That is why the judge allowed that financial testimony to show motive in this case. And just a very powerful rebuttal today from John Metters. He did an excellent job. And like I said, the part that stuck with me was the 19 seconds, was talking about pulling in to the kennels in Moselle, seeing that your own son and your own wife